Commissioner, the next witness is Ms. Smith.
Yes, Ms. Smith, would you come into the witness box? Can I ask you first, Ms. Smith, whether you'd prefer to make an oath or take an affirmation?
Thank you.
Right, if you wouldn't mind remaining standing.
I solemnly and sincerely declare and affirm
I solemnly and sincerely declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much, Ms. Smith. Do sit down. Yes, Mr. Young.
Ms. Smith, is your full name Nicole Susan Smith?
It is.
Is your business address 105 to 153 Miller Street, North Sydney in New South Wales? And is your current occupation that of a non-executive director?
Yes.
And were you a director of NULIS from 1 October 2009 to 30 June 2018? And were you in fact chairman of the board of directors of NULIS from 1 January 2013 to 30 June 2018? Have you received a summons to appear at this round of hearings of the Commission? And is that summons dated 30 July 2018? And do you have the original with you in the witness box? I tender the summons, Commissioner.
Exhibit 5.42, the summons to Ms. Smith.
Ms. Smith, have you prepared 2 witness statements for this round of the hearings of the Commission?
I have.
Is the first of those statements dated the 1st of August, and it relates to rubric 5-40?
Correct.
Do you have the original of that statement with you?
I do.
I understand there's one correction you wish to make to a date that appears in paragraph 41 of that statement.
Yes.
In paragraph 41, it commences by referring to on 8 August 2016. Is the correction that the date should be 1st September 2016?
Yes.
And have you corrected that date in your own handwriting?
I have.
Can you please initial the change in the margin? And with that change, are the contents of that statement true and correct?
Yes.
Commissioner, I tender that first statement.
Exhibit 5.43, the statement of Ms. Smith of 1 August 18 relating to rubric 5-40.
And Ms. Smith, does your second statement relate to rubric 5-77, and is it dated 3 August 2018?
Yes.
Do you have the original of that statement with you?
I do.
Are the contents of that statement true and correct?
Yes.
Commissioner, I tender that statement and its exhibit.
The statement of Ms. Smith of 3 August 18 in relation to rubric 5-77 and its exhibit 5.44.
Thank you.
Mr. Young. Yes, Mr. Hodge.
Thank you, Commissioner. Ms. Smith, as you've already indicated, you've been a director of NULIS, I think, since October of 2009, is that right?
Yes.
And you've been the chair of NULIS since, is it 2013? The chair
Yes, that's
since
correct.
2013. And in addition, you've been a director of some of the other trustees within the NAB group, is that right?
Yes, commencing in 2006.
All right. So from 2006, you were a director of, is it MLC nominees, is that right?
Yes.
And also of PFS.
Yes.
So I assume it was just a single set of directors that were the directors of each of the RSE licensees, is that right?
Yes.
Each RSE licensee had the same board of directors?
No, not initially.
Oh, I see.
I can't recall the exact date that we merged the trustee to have all of the same directors, but when I first started on the board, MLC nominees and PFS nominees had different sets of directors.
Right.
I'm sorry, Ms. Smith, you're going to have to keep your voice up a bit
Sorry.
more.
I'm generally quiet by nature, so...
I won't respond, Ms Smith.
Now, as you've already indicated, you've given two statements. The first statement in response to rubric 5-40 deals with two separate issues. One issue is the PSFs or plan service fees,
Yes?
and the other issue is the ASFs or advisor service fees.
Yes.
And in relation to the plan service fees, you've exhibited a document or an email, I think, from Mr. Cook from August of 2015.
Yes?
And that's an email which I think you've identified as the starting point from when it was identified that there was this PSF issue.
Yes.
And you wouldn't have been, you obviously weren't copied onto that chain of emails.
No.
And in your role as the director of the trustee, you're ultimately dependent on what information management comes and provides to you about these types of issues.
Yes.
And the process that NAB had was that breach reporting was considered by another committee outside of the trustee.
No, so the trustee has a series of policies and processes in place to govern the event management process and the breach review committee, and also has representatives from the trustee in the form of the office of the trustee involved in that process.
The breach review committee is not within the trustee.
Correct.
It's a breach review committee for, is it all of the National
All of the
Australia
wealth.
Bank?
No, just
All of
for the
wealth.
wealth entities.
All right. And so the breach review committee for wealth will consider whether or not there's a reportable breach.
Yes.
And then if it determines that there is a reportable breach, it will presumably give notice to ASIC.
Yes.
As you know, quite often not on time in the case of the National Australia Bank.
I think from the trustee's perspective, we had probably poor performance on time delivery to ASIC up until around 2015, where we had an independent review from PricewaterhouseCoopers on the breach review committee process. And I think from that date, we've shown improvement in timing, and I think there's only been very few amount of breach review committee notices that have gone past the 10-day requirement by about, I believe, up to 1 to 2 days.
All right. The requirement is as soon as possible, but in any event within 10 days. Is that right?
Yes.
All right. And the number of breach reports that have been submitted on behalf of the trustee in excess of that 10-day period has decreased.
Yes.
All right. And now, in the last 2 or 3 years, there's not been as many that are more than 2 days late.
Yes.
All right. And to come back to the Mike Cook email, I just was interested in knowing whether you've seen before another email of Mr. Cook's. Can we bring up NAB.076.077.9069? This is an email of Mr. Cook's sent on the 21st of December 2015, but it contains an earlier set of emails sent by him on the 18th of December 2015. You presumably would not have seen this email at the time it was sent.
No.
Have you seen this email in the course of preparing to give evidence before the Commission?
I may have seen this email through the course of documents I've reviewed.
Right. If we go to page .9071,
Yes.
Now, you'll see there's a numbered item number 1, which is outline of TERP.
Yes.
And Mr. Cook is explaining the TERP issue, which is at May 2013 trade up, TERP was a 21-year-old book of standard employer-sponsored business where only 15% of employers were regularly contributing for the 250,000 members whose median account size was $2,000.
Yes.
And the trade up that he's referring to, I assume, is a trade up of members of TERP being moved on to the MKPS or MKBS product, presumably MKPS, you would think.
If they are actively contributing and employed, they'd be in MKBS.
Right.
If they have left their employer, they would be transferred to they'd be going to MKPS.
Right. And then you see the next paragraph is over 35% of TERP members had under $1,000 in their account. No members had personal financial planners attached to their accounts, but plan advisors who did exist and received trail commission were required by MLC Limited's commission schedule to provide annual written advice to each person in order to qualify to continue receiving this asset-based commission. That matter there, that fact that's set out in that sentence, is that something that you were aware of back in 2015?
No.
All right. It wasn't something that was reported up to the directors?
The requirement to provide annual written
Yes.
advice? No.
All right. Were you aware that none of the TERP members had personal financial planners attached to their accounts?
No.
Were you aware that over 35% of TERP members had under $1,000 in their account?
No, I was not aware of that.
And then you see the next paragraph says, MLC Limited elected not to police the requirements of its commission schedule, largely because no sane person would expect plan advisors to service such small account holders in such a basic product. Was that a matter that you were aware of in 2015?
No.
All right. You in fact weren't even aware that the commission schedule required the advisor to provide annual written
No, I
advice?
was not.
All right. Were you aware of deficiencies in the processes that MLC had in place for policing whether plan advisors, forget about TERP, just plan advisors generally were providing services to members?
No.
All right. Were you aware of any processes that were in place to police whether services were provided? That is, in 2015, were you aware?
Not specifically as it relates to the trustee, no.
All right. And were you aware of, again in 2015, deficiencies in MLC policing whether advisors who were receiving advisor service fees were providing advice?
No.
Right. At some point in time, presumably you became aware that there was an issue about advisors providing advice in exchange for advisor service fees because there was a breach notice given about that.
From the trustee?
Yes, there was a breach notice given about advisors not providing advice where the payments for the advice were coming out of the trust funds.
Yes.
All right. And so at some point in time, you presumably then became aware of an issue about whether advisors were providing advice.
Yeah, I think probably also as it became aware across the industry as a matter of concern.
Right. Attend to that document, Commissioner.
Email Cook to Herald December 15, or email Cook to Herald and others December 15, planned service fee event and wider discovery NAB 076 0779069 Exhibit 5.45.
I just want to make sure the Commissioner has an accurate understanding of how the trustee has operated during the period that you've been the chair of the board. There's an office of the trustee that provides support to the board, is that right?
Yes.
And many of the services or indeed all of the services of operating the trustee are effectively subcontracted out to other NAB-related entities?
Yes.
And the trustee then is dependent upon reporting back to it as to how those related entities are providing services?
Yes.
And the office of the trustee, to what extent is it able to monitor whether the related party service providers are properly providing those services?
Well, I think the trustee has monitoring in place at a hands-on level through the office of the trustee, and then also through reports and requirements specifically into the board and the board subcommittees to determine that services are being provided appropriately and in accordance with contracts.
All right. And in your time as the chair of the board, were you satisfied with the adequacy of those processes?
Yes.
Were there any concerns you had about adequate resourcing being provided to the office of the trustee?
To the office of the trustee.
Yes.
I think resourcing is always goes up and down depending on the workload, both from a legislative perspective, what the organisation's trying to do at points in time. The office of the trustee reports directly to the board and specifically to me. So when the office of the trustee doesn't have appropriate resources, we would look to put in place through either external recruitment or through seconding staff into the office of the trustee to ensure that they have appropriate resources to undertake the workload that's expected of them.
If we just go back to my question, during the time that you were the chair of the board from 2012, is that right?
13.
2013, I'm sorry. Were there any times when you had a concern about whether the office of the trustee was being adequately resourced?
Not that I can recall, but I'm sure that there are times where we've discussed resources during the last 5 years.
Okay. Now, you were on the board of MLC nominees when it approved the change to the fees in relation to MKBS and MKPS?
Known as Project Swift, yes.
All right, and that was in 2012?
Yes.
Can we have a look at the management paper that was provided to the board? The document ID is NAB.005.788.0496. So this front sheet is effectively the noting out of what occurred at the board meeting, is that right?
It appears to be. It's a little bit far away from me on the screen.
Perhaps there
You've got
is
a
actually a
screen
screen
next to
just
you.
next to you,
Thank you.
Ms. Smith.
Thanks. Yes.
And so we can see there was an agenda item which was number 10 on the 19th of April 2012.
Thank you. Yes.
It was a combined board meeting of the directors of all three of the RSE licensees.
Yes.
And we see that there was a discussion of a paper which is referred to as the SWIFT proposal,
Yes.
and that's what you referred to before, the SWIFT proposal.
Yes.
And the SWIFT proposal is noted, and then we see that the board resolved to approve the integrated package of SWIFT changes as described in this paper, including specific items that are noted there.
Yes.
If we go over the page to .0498, we see one of the specific changes was the proposed changes to advisor payments under the trust deed, as
Yes.
detailed in section 7 of this paper.
Yes.
And I assume in the course of preparing to give evidence, you've gone back and reviewed this document?
I have.
And I assume at various times over the course of the last few years, as issues have arisen with respect to the fees charged as a consequence of the SWIFT proposal, you've gone back to look at this paper?
I have more in the last 12 months, yes.
Right. Do you recall that the reason, the motivation for SWIFT was connected with the introduction of FOFA and MySuper?
The trustees' motivation for Project SWIFT, SWIFT stood for I'll forget the acronym, but essentially it was fees with transparency. So the trustees' motivation for Project SWIFT was essentially motivated around making fees open and transparent to our members so they could see what they were paying advisors, and so that they had control over those fees and were able to negotiate those fees with their advisor for services that they were receiving.
When you speak about the trustees' motivation for SWIFT, do you recall it having been initiated at a trustee level rather than at an administrator level?
No, I believe it was initially initiated at a administrator level.
All right. And when you speak about the trustees' intention, does that mean you're in understanding of what you and your fellow directors intended?
My recollection of the trustees' intention with Project SWIFT at the time.
I just want to be clear, when we talk about the trustees' intention,
Yes.
we're speaking about the directors as the mind of the
Yes,
trustee.
that's right.
Is that right? All right. And as I understood what you said, the intention of the trustee was first to make fees transparent,
Yes.
and second, did I understand this correctly, to allow the member to have control over their fees?
Yes.
Right. And do you recall that another issue that was looming was FOFA?
Yes.
And was part of, I'm not saying the only motivation, but was part of the purpose of this proposal to come up with a FOFA compliant product?
I don't recall that being a primary consideration for the trustee at the time. I think we were more considered, or our considerations really related to our corporate superannuation products, of which we had 3, and MySuper that was coming in the not too distant future as well, and trying to put in place a product set that would enable us to comply with MySuper.
Well, do you recall that at the time that you were considering the SWIFT proposal, you knew that FOFA was imminent?
I only know that it was imminent because I've gone back and looked at dates. I don't recall FOFA being a part of the discussion around the trustee boardroom table for kind of our motivation and the trustees' motivation to implement Project SWIFT.
All right. If we go to page 3 of the presentation that forms part of the board papers, that's at NAB.055.788.0502.
Yes?
You see, this is what's described as the MLC Business Super Roadmap.
Yes.
And you see it said SWIFT is a key component of the MLC Business Super Roadmap.
Yes?
And you can see in the middle of the page, SWIFT move MKBS/PS to simplified explicit fee structure.
Yes?
It's NAB.005.788.0502.
Oh, not me.
I'm sorry, that wasn't directed at you, Ms. Smith. There we go. You've got a hard copy, I think, Ms. Smith.
I do.
You're lucky. You'll see that SWIFT on the diagram then leads over into make FOFA and my super compliant.
Yes.
Do you recall whether there was something else that needed to be done in order to make the SWIFT changes FOFA compliant?
Sorry, I'm not quite sure I understand.
Well, perhaps if we look at it in a different way. You understood that under FOFA, it was no longer possible to pay commissions.
Yes.
Do you recall whether part, not all, but part of the purpose of SWIFT was to remove commissions and replace them with explicit fees?
Yes.
All right. And then if we go over the page to page 4, which is .0503,
Yes.
you'll see this is the SWIFT recap, and this is consistent with the points you're making, a simple and transparent fee structure. The administration fee will be unbundled from the unit price and made explicit to members. The second point, commission will be removed from the administration fee.
Yes.
And then if we go over the page to page 5, we see the approval sought, and one of the approvals, the last one, the proposed changes to advisor payments, which is slide
Yes.
35. All right. And then if we go over to page 16, which is .0515, you see simplifying the fee structure, and there's various changes that are going to be made to the fees.
Yes.
And I'll just direct your attention to two. One is advisor contribution fee, new name for contribution fee.
Yes.
The next is plan service fee will replace the current employer service fee and servicing rebate and the current implicit advisor trail commission currently built into the unit price includes cost of GST.
Yes.
And then if we go through to page 19, which is NAB.005.788.0518. See, it's titled MKBS, Existing Employer Plans, Current versus Proposed Administration Fees.
Yes.
And then you'll see at the bottom of the page the words, all existing advisor remuneration for existing members will continue. It will be funded by additional explicit fees for advice, including GST.
Yes.
And just to pause on that, was it your understanding that amounts that had been paid to advisors as commission would now be wrapped up in a single fee for service?
Yes.
And the difference then, an important difference, would be that whereas with commission it wasn't necessary to provide a service in order to receive the revenue, for a fee for service you would have to provide a service.
Yes.
And that was your intention, first just yourself as a director, that if advisors were to receive these fees they would provide a service?
Yes.
And you understood that was the intention of the trustee.
Yes.
And the fee that they would be paid, I'm sorry, I'll withdraw that. You understood that they would agree on what service was to be provided before they were paid the fee,
Yes.
and they would be paid a fee if they provided the service they had agreed to provide.
Yes.
You didn't think if somebody else provides some other service, then the fee will still be charged.
Who else? It's an advisor service fee.
Well, that's for an advisor service fee. This isn't
It's
just...
a fee paid to an advisor in respect of general advice services.
Yes, that's the plan service fee.
Yes.
Is that also your understanding of the advisor contribution fee?
No.
What did you think the advisor contribution fee was?
A commission. That would stop with FOFA. I don't recall thinking about the contribution fee at the time.
Right. We might come back to that. Let's just focus for a moment on the
Okay.
plan service
Yep.
fees. What you were saying is you understood a service would to be provided by the advisor
Yes.
and a fee would be agreed for that service.
Yes.
And if that service was provided, the fee would be charged by the trustee and paid to the advisor.
Yes.
And if that service that had been agreed wasn't provided, the fee wouldn't be charged and wouldn't be paid to the advisor.
Yes.
And you weren't anticipating that, for example, MLC would provide some different service and then claim the fee for itself.
No.
And then can we go to page 35 of that document?
Yes.
This is a more detailed breakdown of the proposed changes to advisor payments.
Yes.
I'm sorry, it's .0534.
Yes.
It's not you we're waiting for,
Oh.
Ms Smith, don't worry.
We're not waiting on the operator either, we're waiting on the system. I have the benefit of looking at the screen grow grey.
I feel like the system is less afraid of you, Commissioner, than the rest of us are.
Judicial
All right.
deafness is a very useful tool, Mr. Hodge. Go on.
You'll see there's now a slide up there which is proposed changes to advisor payments.
Yes.
And the point being made there is the trust deed allows the trustee to debit agreed advisor payments from a member's account as fund expenses, and as such these should be approved by the trustee rather than fees or charges to be imposed unilaterally by MLC under the life policy.
Yes.
And it's then explained that there'll need to be an amendment made to the MLC licensee remuneration agreement and schedule of commission if the trustee is now going to make the payments.
Yes.
So that's the effect of what's there. And then it sets out certain payments, the first of which is the contribution fee.
Yes.
And it explains that's been renamed as the advisor contribution fee
Yes.
and will be made explicit rather than paid by MLC Limited from group revenue.
Yes.
And the amount paid as advisor remuneration, open brackets, including GST, where applicable, close brackets, will exactly equal the advisor contribution fee charged.
Yes.
I'm just trying to understand why, having regard to what's written here, the contribution fee is different in some way from the plan service fee. You obviously think they are different or thought they were different. I'm just trying to understand it.
To be honest, I haven't actually considered the legal construct of the contribution fee as to whether it's a fee for service or whether it's a commission that's been grandfathered. I don't recall from 2012 what my consideration was in respect of the contribution fee.
Do you recall it ever being raised at a director level whether the the advisor contribution fees would need to be repaid if there was no advisor linked to the account?
The advisor contribution fee,
Yes.
I don't, not in 2012, no.
All right. Well, I'm sorry, not in 2012, but obviously this issue arises in late 2015 and into 2016. When the issue arises in relation to plan service fees, do you recall an issue also being raised about advisor contribution fees?
No,
All right. It's not something that you can recall having yourself turned your attention to?
no, I don't believe I have.
But that's, can I suggest, as the director, not necessarily the type of thing you would be expected to think about of your own volition. You would expect that to be brought to you by management if there was an issue.
Yes,
All right. And management didn't come to you, as far as you can recall, and say there may also be an issue about the advisor contribution fee.
no, not that I can recall.
And you know that in terms of the amounts that have been agreed to be remediated by NAB to members of the various funds of which you've been a trustee, that there has not been an agreement or commitment to remediate for advisor contribution fees?
No, there hasn't.
Right. And as far as you can tell, it hasn't been raised with you?
No, it hasn't.
All right. And then the asset-based commission and commission on the employer service fee is to become the plan service fee.
Yes,
And again, that's an amount that you understood would be paid in exchange for a service,
yes,
but it's also an amount that the member could choose to simply reduce to zero,
yes,
and could do that whether they were an MKBS member or an MKPS member.
yes,
Right. And one of the issues that has since arisen is that the PDSs that were produced for members and the significant event notices that were produced to members did not reveal that they could simply turn off the plan service fee if they wished.
not explicitly.
No, well, in fact,
No,
what they said was, this is something that you can negotiate with your advisor.
yes,
It was, can I suggest, something that is positively misleading if in fact they can just call up and turn it off.
I've thought long and hard about whether or not it's misleading. I essentially believe that's what has led us to the second round of, or triggering the second round of remediation for the planned service fee.
Right.
That in hindsight, it should have said you can turn it off.
In hindsight, in your role as director of the trustee, you concluded that it was misleading.
I concluded that we should have said to members that they could turn it off, yes.
And should you have said that to both MKPS and MKBS members?
It wasn't the same. They couldn't turn it off in MKBS. They could go to their employer, and they could, through their employer, change the fee if they felt they weren't getting services. For MKPS, I believe we should have told members they could turn it off.
Is that what you've been told by the National Australia Bank? That if you're an MKBS member, you
I believe it
couldn't
says it in
call
the
up
PDS.
and turn it off?
I believe it says it in the PDS,
It says what in the PDS?
that you go to your employer to negotiate.
You think in the PDS it says you have to go to your employer to negotiate?
Yeah, I believe so.
I just, for the moment, assume this. Assume that if a member of the MKBS called up the relevant MLC call line and said they wanted to switch off all of their fees and commissions,
Yes,
that the PSF would be switched off. Assume that that's the case. If that's the case, does that mean that the PDS for MKBS was also misleading?
I haven't turned my mind to that or not.
Well, turn your mind to it now.
Well-
Is there a distinction, if that's the case, between the MKPS and MKBS?
So I would have to go and reread the MKBS PDS to see exactly what it says.
I mean, I can help. We can look at that now. Why don't we bring up, Commissioner? I'll tend to that document and come back to it.
Extract of minutes MLC nominees, NULIS and PFS nominees, 19 April 2012, and accompanying document. NAB 005 788 0496, Exhibit 5.46.
Thank you, Commissioner. Can we bring up first ASIC.003.0001.2760? So it's described as the reference guide for the MKBS plan, and you'll see its preparation date is the 1st of June 2012. You
Yes.
probably need to look on that version, I think. Now, we understand this is effectively the significant event notice. Does that seem right to you, or do you think there'd be another document?
Well, there would have been multiple documents that related to the significant event notice, a letter, a guide, as well as the PDS.
All right. And I just want to see if I've understood this. If you go to page 10 of that document, which is .2769, you see on the right-hand side there's plan service fee. And it refers to what the fee is. It says it's deducted monthly from your account and paid to your plan advisor. And it
Yes.
says it's the asset-based commission plus the employer service fee.
Yes.
And it doesn't seem to deal there with negotiation of the fee.
It's only one page of a multiple page document,
Understand.
so the document, it would be referenced in other parts of either the PDS, this document, or this
Right.
document.
What is it that you are expecting to see in this document? Something that says that only the employer can agree on what the plan service fee is?
The employer does agree the plan service fee with the advisor and
Yes.
puts that process in place. Whether it's this document or the PDS itself does describe that process. It also describes when the member can negotiate it.
It describes when they can negotiate it.
Yes.
And again, I think we're just trying to find the document that you're talking about. It's a document that says that only the employer can change the plan service fee, or you're
I
not
would
sure?
have to go to the PDS and re-review it.
Okay. I'm just trying to understand your recollection as to the distinction between the MKBS and the MKPS.
Essentially, I'm not. I need you to be more specific about what you want me to actually go into in respect of the difference.
Well, you know, don't you, that what the bank has agreed to refund is plan service fees charged to MKPS members,
Yes.
and it's agreed to turn off plan service fees for both MKBS and MKPS members from September of this year?
Yes.
And is it also your understanding that the bank hasn't agreed to refund plan service fees for MKBS members?
Correct.
And what I want to understand then is what the difference is between the MKPS members who are to have their plan service fee refunded and the MKBS members who won't have it refunded.
I see two distinctions. The first, that when the plan service fee is set up in MKBS, it's determined between the employer and the advisor, and the employer is also determining the services that will be provided by the advisor for the plan and monitoring the provision of those services. The second part, I think, I'm sure we'll get into some more conversation on MKPS, but it would be too simple to say it's about disclosure. Essentially, the MKPS member has the fee applied to their account in a default manner, and there's a series of things that are different about the MKPS member at the point that the fee is being charged to them than when someone is in MKBS and part of an employer plan.
Is one of those things that it's not possible for the trustee to be genuinely satisfied that services were provided to an MKPS member in exchange for the plan service fee?
Yes.
And is it your understanding that that is one of the reasons why the bank has now agreed to refund the PSFs to all MKPS members?
Yes.
And so you know that the way in which this has been presented is that this was just a problem with disclosure.
No.
You don't think so?
No.
Okay. You think that it's been presented as also a problem with whether or not the services were actually provided?
So depending on who you think it's being presented to,
The public, in the public statements that have been made, which you've given a statement about.
I think we've made. Yes, I have. I think the point of the public statement is not to go into the entirety of the rationale for why we've determined we have an error. It's to the point of that public disclosure was to ensure that our members were aware of information that was going into the hands of advisors so that they knew at the same time that an error had occurred and that we would be refunding a particular category of members. There was I wasn't involved in the drafting of that. I don't know how the words were chosen or why the words were chosen, but primarily the starting point for the PSF event actually was concern from ASIC with the disclosures that we had made.
Right. Let me just show you another document, which is Exhibit 5.12. It's NAB.005.871.0022. You just need to look over on the screen. Have you seen that document before, Ms. Smith?
I don't recall. I may have seen it as part of my witness statement preparation, but that would be the only time. I have reviewed a lot of documents in the last few days, so.
I understand. And you see it's a document titled Removing an Advisor Turning Off Commissions, MKBS, MKPS.
Yes.
And you see in item 3, what action will we take if a member requests us to turn off commissions or stop paying their plan advisor?
Yes.
and you see when a member directly requests us to turn off commissions, we will perform the following. And the first thing is remove plan service fee.
Yes.
The second thing is remove advisor contribution fee.
Yes.
And it doesn't distinguish between whether that member is a MKPS or MKBS member.
No.
So if you assume that that is the process that was adopted by MLC, does that change your view as to whether there is a difference between the MKPS and MKBS in terms of having to refund the plan service fees?
I think I'd still go back to the response I provided earlier in the difference to services being provided and the ability of the trustee to determine that service had actually been provided.
I understand that there's still a difference, which is that in relation to MKPS, the trustee can't be satisfied that services have been provided in exchange for the plan service fee.
Correct.
And how does the trustee satisfy itself that services have been provided for MKBS members in exchange for the plan service fee?
There's a series of controls, but really the primary control would be between the relationship between the employer and the plan advisor, and the establishment who established the fee, and then the monitoring of that service that's provided to the employer plan.
Sorry, who monitors the
The
service?
employer.
Oh,
The employer of the members of the fund.
so the assumption, if I understand it, is that the employer will monitor whether or not the advisor has provided the services to the employee.
Yes.
All right. And if the employer determined that those services weren't being provided, what would you, in your role as trustee, expect to happen then?
I would expect that the employer would determine to take the advisor off the account and that the services would, the fees would be stopped.
All right. And if the member didn't think that they were having services provided, what would you as the trustee expect the member to do?
If the member determined they weren't receiving appropriate service, that they would call us and ask us to turn the fee off.
Yes, if they were the MKBS member as well,
Yes.
and you'd do it.
I don't know the administrative process that's in place and whether or not we do it immediately or they go back to the employer or how that's actually processed. So I think the answer is I'm not unsure of the administrative process in place.
Does the employee who is signed up under to the MKBS have to agree to have amounts deducted for the PSF from their account?
Essentially, they agree by remaining in the plan and they're advised of what the fees are when they join the plan.
So it's via the PDS.
Yes.
All right. And so again, then this gives rise to this same issue of potentially misleading the MKBS members because they may or may not understand that they can simply turn off the PSFs.
I wouldn't. I think I haven't turned my mind to MKBS members, the actual disclosure, and whether or not between the process and the disclosure is misleading. So I can't answer that question.
Can we go back to NAB.005.788.0496?
Yes.
And we were looking at page 35, which is .0534. And can you then look for me at the fourth box down, which is RITC change?
Yes.
And does RITC, is that recipient input tax credit? The reduced input tax credit, I'm sorry, Commissioner, the solicitor from the tax office is just correcting me on that.
Yes.
And you see it says there, given that the plan service fee and advisor contribution fee will represent services provided by an advisor to a member for GST purposes, MLC Limited will lose its entitlement to recover a reduced input tax credit from the Australian Taxation Office on the payments.
Yes.
This has been factored into the proposed new arrangements. Reflecting on the answer you gave earlier, does this change your view as to whether at the time you understood that the advisor contribution fee would or would not be provided for a service?
No.
You still think, notwithstanding this, that it wasn't being provided for a service?
No. I said I couldn't recall.
Oh, I see.
I couldn't recall whether or not I considered the contribution fee at the time, and I'm not a lawyer by training.
Understand.
I'm an accountant, and so I haven't, in the context of the contribution fee, considered the legal construct of that, and I would be, I think it would, I would be giving you an accountant's answer, and without going back to read the legal advice or to actually understand. It could be nothing to do, it could be the way the fee is proposed to be charged through the trust. I don't know. There are questions I would ask. So I don't recall the conversation at the time. I don't recall my thinking of it at the time around the contribution fee.
Right. Now, again, though, thinking about the issues that have occurred, if the advisor contribution fee is a fee for service provided by an advisor and the member doesn't have an advisor linked to the member's account, can you think of a reason why the advisor contribution fee ought not be refunded to the member?
If it is a fee for service and there is no advisor linked to the account,
Yes.
no, I cannot.
All right. But that's not something that you've had to consider before now,
No,
is that right? It hasn't been something that management has raised with you?
no.
All right. And you see then in the last box on that page, the cap on the combined advisor service fee and employer service fee of 2% of the member's account balance, or $2,200, whichever is the greater, will be removed.
Yes.
And do you have any recollection of the making of that decision to remove the cap?
So I think it was based on aligning to other products where we did not have an advisor service fee cap at the time.
You see it says in the box, it is considered that the removal of the cap will facilitate member engagement in the negotiation of advisor fees. Are you able to explain to the Commissioner what that means?
Well, the way I look at that is sometimes the cost of, particularly for members with potentially smaller balances, the cost of advice in terms of personal advice specifically might be larger than the cap would allow, and so it's actually it's to enable the member to negotiate the fee with the with the advisor.
By removing the cap?
Yes.
I just want to make sure I've understood the logic. Presumably with a cap, the member could still negotiate the fee
Up to the
with
cap.
the advisor up to the cap. So in this way then the member could negotiate for an even higher fee.
Well,
Is that the point?
yes.
And then if we go to page 38, which is .0537, you see this is the set of key messages from as part of the SWIFT process.
Yes.
And you see the audience-specific messaging, and for advisors, there's a heading which is awareness, and the first dot point is moving MKBS to a commission-free product with changes to the fee structure to ensure FOFA readiness.
Yes.
And when you read that, does that have any effect on your view as to whether or not the advisor contribution fee was a commission?
No, I just read it as a message to go to advisors. I mean, the trustee's responsibility was not engagement of advisors, it was engagement of members. So
I'm not sure it's quite as easy to slip away from that, because what's happening in this process is that the trustee is going to enter into an agreement to pay the advisors.
yes,
And the trustee is going to exercise its right under the trust deed to deduct from the member's account the fund expenses. That's right.
yes,
And so the trustee is in the relationship with the advisor. Do you agree?
yes,
And the message that is to be conveyed to the advisor is that the MKBS product is being moved to a commission-free product.
yes.
And what I'm trying to understand is there some reason to doubt that this is true?
No, only you're asking me to make a legal analysis in respect of a fee.
No, I'm sorry, go on.
And I would have to sit down with more thought and more understanding to be able to answer definitively yes or no. I would be speculating based on simple words in a PowerPoint slide.
Right. And then if we go then to NAB.005.788.0561, that's a page further on in that document. And you see section 6, so this is the management paper that's put forward in support. I think you should be able to see that in your version if you go to page 4 of the paper, which is NAB.005.788.0555.
Oh, 0555, sorry. Oh no, I'm on the right page. 0561 at the top.
I'm sorry, if you just go back for, I just want to show you that this is the management paper. If you
yes.
go back to .0555,
Yes,
see this is the paper for the directors of MLC nominees prepared by Mr Daly and Mr Mulholland.
yes,
All right. And then when we go over to .0561, this is page 10 of that paper.
yes,
And this is where it's setting out the changes to fee structure.
yes,
And it explains that what was the contribution fee will be renamed the advisor contribution fee.
yes,
2 dot points down, asset-based commission will be discontinued. Existing asset-based commission arrangements will be aggregated with existing employer service fee arrangements and made explicit. The new fee type will be called the planned service fee.
yes,
And then another 2 dot points down, the plan service fee in MKBS will be capped at 1.5% and will be inclusive of GST.
Yes.
Now, another thing I'd just like to understand is there was an employer service fee which was up to 1.1%,
Yes.
and there was now going to be a plan service fee which was up to 1.5%.
Yes.
And the reason it was going up to 1.5% was because asset-based commission would now be discontinued and they would be aggregated together into this up to 1.5%.
Yes.
Was it expected by the trustee that there would be some change in the services being provided, depending upon whether it was an employer service fee of up to 1.1% or a plan service fee of up to 1.5%?
I don't recall specifically thinking about it like that.
Do you recall that the purpose was to just maintain the same amount of remuneration going to advisors?
I think that there were 2 points, or the consideration that I can recall was that advisors received an array of remuneration in the form of commission and the employer service fee, and it was this package of remuneration that they were receiving in respect of the services they were providing members when they were part of the employer-sponsored plan, as well as when they moved into the MKPS part of the plan. And so it was really the package of remuneration for delivery of the service.
For delivery of whatever was the employer service fee, is that right?
Yes, and then the member general advice services.
Right. And then if we go...
So if it wasn't clear, what I was trying to say is we didn't individually pick out bits of the fee and think about this bit was for this service. It was a package of remuneration for the delivery of service.
And then if we go over to .0565, which is section 7, changes to advisor payments.
Yes.
So this, again, seems to be consistent with what we've already seen in the PowerPoint presentation. First, the trustee allows the trustee to debit agreed advisor payments from a member's account as fund expenses.
Yes.
So now the trustee is in a relationship with both the advisor and the member,
Yes.
and the trustee is debiting from the member's account in order to pay the advisor for the services that the advisor will pay to will provide to the member.
Yes.
And this explains in the first dot point, the contribution fee will be renamed the advisor contribution fee, and it won't be paid by MLC Limited from group revenue.
Yes.
And that's consistent with the idea that it's now the trustee, which is MLC nominees, that will be paying the advisor.
Yes.
All right. And then another 2 dot points down, asset-based commission and commission on the ESF will be discontinued and replaced with this single PSF.
Yes.
All right. And I tender that document, Commissioner, if I haven't done so already. I think I've done it.
Thought we had it in already.
I thought we have. My DS is questioning us, Commissioner, but on this one occasion, I think we're right.
Take it while you may, Mr Hodge.
I beg your pardon, Commissioner?
Said, take it while you may.
Yes. Now, the trustee is then informed at the end of 2015 that, and for the moment I use the term the business, that is the wealth business and the trustee together. We'll come back to the specifics of that at the moment. But the business has been deducting PSFs from members' accounts, even where there's no linked advisor.
Yes.
And it would seem obvious that in those circumstances, those members would need to be refunded. Do you agree?
I'd agree that where there's no advisor, no service can be provided and a fee shouldn't be charged.
And was that obvious to you when you were first informed that these fees had been deducted where there was no linked advisor?
Don't recall if my reaction was obvious or not, or whether I thought it was obvious or not.
As you know, although the trustee was told about this in 2015, it wasn't until the end of October 2016 that a final decision was made about remediation.
Yes.
And I'm curious to understand your view as to the elapsing of that period of time.
At the point that the TERP event was found and reported to the regulator as a significant breach, there was also a commitment given to the regulator that we would undertake a review into potential other errors of similar nature, and that's when the second stage of the PSF review commenced for the SWIFT trade-up, SWIFT changes and the Encompass trade-up, and we were awaiting the outcome of that review. Essentially, if we have an error that goes across multiple different categories of members, we really look to remediate once so that we make sure that we get it right.
Is it your understanding that the reason for delay was because it was trying to be determined by somebody within the business whether there were other affected members other than the TERP members?
Yes.
And is it your understanding that that was the only reason for the delay?
Yes.
Were you aware of questions being raised within the wealth business as to whether or not there was actually an obligation to refund the money
In respect of TERP members?
in respect of all of the affected members?
I was aware that there was a review going on at a very high level, but not whether or not we were deciding whether... I didn't know the specifics of what the proposed remediation program was going to be until it came to the boardroom.
Were you aware of questions being raised as to whether it could be said that general advice services provided by MLC nominees, such as answering telephone calls and giving telephone assistance, could justify retaining the plan service fees?
At a very high level, yes.
And do you recall when you became aware of those questions?
No.
Do you recall whether you were concerned that those sorts of questions were being asked?
So my engagement was really at any level through the Office of the Trustee and some very ad hoc conversations between the management team at a very high level. And my response to that is, specific answer to your question, at the time I was not concerned.
And can I suggest to you, for you to consider, one reason why, as the trustee, you might be concerned about this is because as the trustee, you have deducted money from members' accounts in order to pay for a service that has not been provided to the members. And now this related wealth entity is trying to find a reason to keep the money.
So I wasn't concerned for two primary reasons. First of all, at this point in time, the Office of the Trustee was highly engaged in the review process and the discussion around what, the events. And the Office of the Trustee is there listening to and speaking and thinking for the trustee. Through experience over my starting as a director on the board in 2006, as well as through my chair, my relationship with the COO of the OTT, I would expect and know that he will raise anything with me that he would be worried about and needed either the trustee or me to have be involved in. So really, Office of the Trustee involved in the process as an independent voice. And secondly, the trustee had, through the Office of the Trustee, sought independent legal advice in respect of the matter. And so I believe that the organisation needed to go through due process and consider the matter, and that the trustee had a voice and an independent voice as part of that process.
I'm sorry, just so I understand who we're talking about, is that Mr. Marriott?
It is.
Right, Mr. Marriott was the Chief Operating Officer for the OTT.
That's his title, yes.
All right. And your point is he was involved in this process?
He and his and members of his team.
All right. And the process that we're talking about is what I'm just trying to understand. The process seems to have been to look at whether retaining the PSFs could be justified on the basis that MLC nominees or MLC Direct had provided some sort of general advice services to the members or had made available general advice services. Is that the process that you're referring to?
Well, essentially, my recollection and my understanding of the matter at the time were there were two pieces of legal advice that had differing views, and that was being looked at as to what the error actually was.
Right. You didn't feel like at the time in 2016 that the trustee needed to say to the NAB wealth business, we just have to get on with this and pay back this money to members?
I believed that the management team needed to go through due process and bring the outcome of that to the board.
Right. Can we bring up ASIC.0036.0001.2898? Commissioner, this, I suspect, is a document that you're going to need to rule on in terms of without prejudice privilege. It's a letter of the 22nd of July 2016. I'm not sure whether every claim is still pressed or not.
Now, the claim is for a non-publication direction, I think, is it?
It is.
Can I have the
Commission-
document then, please? Because if it's an NPD, there's no reason for me not to have it.
I can provide a copy.
Yes, thank you. Yes.
We made a submission, Commissioner, to the
Yes, I've
effect.
read that, Mr. Young. Can I perhaps focus debate a little? The documents have been produced, is that right?
Yes,
The documents have been produced unredacted to the Commission.
yes, accompanied by the confidentiality
The
application.
claim is a claim for a non-publication direction. That is, it is a claim under 6D3, is it not, of the Act, I think? Yeah, 6D3. The contents of the document produced under a notice not be published. Is that right?
Yes.
Yes.
There's no objection to the Commission using the document in its deliberations, but the document records without prejudice proposals exchanged with ASIC. Without prejudice privilege is a common law right that continues. We say that there's no reason why the confidentiality and privilege that attach to this communication should be lost. The Commission can make use of the document in its deliberations without publishing the document. And in our submission, the balance lies in favour of preserving the confidentiality that attaches to it.
Can I understand the nature of the question I've got to answer? Because unless we get the question right, the answer will be wrong. The question is one of balancing between the interests of confidential negotiation with ASIC and the needs of a public inquiry. Is that right?
Yes.
Is that the balance to be struck?
More specifically, as to the second limb, Commissioner, it's not simply the interests of a public inquiry, it's whether the interests of that inquiry mandate or require the publication of this document to enable the Commission to engage in its work.
I think there's an inversion there, Mr. Young, in the sense that the inquiry is a public inquiry. That's the premise from which we begin, is it not?
Commissioner, when confidential records arise and are provided, and they were brought into existence in the context of without prejudice privilege, the mere fact that it's a commission which conducts its operations largely in public does not mean that there's no ability to weigh in the balance the genuine interests that we seek to preserve by a non-confidentiality order.
And what is the interest that you seek to have preserved by my giving a non-publication direction in respect of this document?
It's our interest in precluding public disclosure of communications that we made with ASIC in a particular negotiation and potential contravention context.
Exactly. Now, negotiation of what? Of what dispute? Can I just tease it out to know, without prejudice privilege, it attaches to compromise of a dispute, is that right?
Yes.
What is the dispute that is sought to be compromised
Well,
here?
the backdrop to this is that a significant breach notice had been given in late 2015.
That is, there was compliance with the law obliging reporting.
Yes, but the
Yes.
reporting was in respect of a potential breach of legal obligations.
Yes.
Now, that was the backdrop to this communication. The communication with ASIC concerned various proposals for the resolution of outstanding issues associated with that breach notice, including remediation.
No, just,
Yes.
you say outstanding issues. What is the dispute? You have reported in accordance with law. There are, or there are not, according to a determination of a court later, legal consequences which may or may not attach to what has been reported.
Well,
What is the dispute that is, you say, the subject of debate with ASIC?
the ASIC was conducting an ongoing investigation as to the way in which that significant potential breach could be addressed and remediated in such a way that ASIC would take no further action in respect of that notified breach. It's the same context that arises in any situation where there is an apprehended breach, there is discussion with ASIC of potential enforcement action, and a range of solutions or remedies are the subject of without prejudice discussions with ASIC, including such things as enforceable undertakings or the like.
Is it part of my inquiry to look at the response that NAB makes to the circumstances that are revealed by the 912D notice that NAB has given?
Yes.
Is it part of my inquiry to inquire into the response that ASIC makes to the 912D notice that NAB has given?
Yes.
We've agreed, I think, have we not, that I have to strike a balance between the interests that NAB would have in keeping confidential what it says to ASIC and the interests of my effecting the execution of my terms of reference, including to inquire into, among other things, the responses that NAB have made, is making, and the responses that ASIC has made, is making to the events described. Am I right so far?
Yes, that follows from my earlier answers.
What is it then that makes the balance tip in favour of saying no disclosure?
It's not in dispute that these matters are within the scope of the Commission's inquiry. The question is whether these matters ought to be addressed confidentially or in open session. Publishing this document at large, this document contains different proposals exchanged between ASIC and entities within NAB concerning proposed methods of resolution of the investigation that was underway by ASIC. Now, we know the ultimate outcome of that exercise. So in our submission, it doesn't amount to a matter that requires public disclosure to see at one snapshot in time, as per this document, what the state of affairs were in terms of what proposals and counter-proposals were being mooted at this point of time. Also, there is a wider consideration, that is to say, corporations in discussions with ASIC about potential enforcement matters engage in such discussions commonly, without prejudice, and in circumstances where the anticipation is both the government regulator and the private party will preserve the confidentiality that attaches to the without prejudice communications. So there is a wider public interest in preserving these communications, not just for this case, but for other cases. So it's our submission that by all means the Commission has this document, it can utilise it, but the potential detriment that would flow to my client if this were to be published at large, and the potential detriment to the public interest in ensuring that negotiations and discussions of this kind are conducted frankly and fairly with the ongoing benefit of without prejudice protections, are factors that need to be brought into the balance, And in our submission, there's been no reason identified as to why this document has to be published to enable this commission to fully perform its functions.
You've spoken of two kinds of detriment to your client and detriment to the wider public interest. I want to be entirely sure that I have fully understood what you say is encompassed by each. Please list in summary form the detriments to your client, and then please list in summary form the detriments to the wider public interest.
The detriment to our client is that there would be unnecessary public revelation of the various concessions and compromises that my client was prepared to put forward in July 2016 in the context of this issue that had arisen with ASIC. Conversely, ASIC's position at that stage of discussions is also described in this document. The damage to the wider public interest is that the ability of organisations, ASIC and corporations, to engage in discussions with a view to agreeing upon appropriate enforcement steps may be hindered if parties can't engage in those negotiations with the benefit of without prejudice privilege that is maintainable in the face of various public bodies that might call for the production of documents. That's the wider public interest.
Yes? Anything you desire to add?
Nothing further, Commissioner.
Counsel assisting seeks to put to the witness a letter dated 22 July 2016 from NAB to ASIC that is entitled Without Prejudice. NAB has separately and previously sought a direction from me that the content of that document not be published to any person beyond the lawyers assisting the Commission and those who are representing NAB. The premise for the application is, of course, that the letter of 22 July 16 was produced to the Commission under a notice to produce issued pursuant to Section 2, subsection 3A of the Royal Commissions Act 1902 of the Commonwealth. Counsel for NAB accepts, rightly if I may say so, that the question is to be determined as one depending upon where a balance is to be struck between the maintenance of NAB's interests and the interests of others dealing with the regulator in having negotiations with the regulator in confidence with the needs of the Commission to conduct its ordinary business in hearings in public. Counsel for NAB identified the detriment to his client as centring upon the unnecessary public revelation and consequent controversy concerning the positions which his client adopted in the course of its negotiations with ASIC in July 2016. Further, he pointed to the fact that the position adopted by ASIC at that time either is expressed or can be discerned from the content of the letter. Counsel further pointed to what he identified as being the wider public interest which underpins without prejudice negotiations generally, and more particularly without prejudice negotiations between a member of the regulated community and the regulator. He identified that wider public interest as the ability for a member of the regulated community and the regulator to conduct discussions about the consequences that may attach to events that had occurred, which may raise issues about compliance with legislation administered by the regulator in confidence and to conduct those discussions with a view towards ultimate agreement about what enforcement steps can or might be taken. He pointed in effect to the fact that to publicise what was said at this time may somehow inhibit or chill negotiations that take place between members of the regulated community and the regulator in circumstances generally similar to those which yielded the letter of 22 July 16. The oral hearings of this commission are being conducted in aid of execution of the terms of reference as they are established by the letters patent of 14 December 2017. Those terms of reference require me to inquire into whether any conduct by financial service entities might have amounted to misconduct and whether any conduct, practices, behaviour or business activities by financial services entities fall below community standards and expectations. The events which gave rise to the discussions between ASIC and NAB and are the subject of the letter of 22 July 16 are events of a kind that may, I do not say do, constitute conduct of a kind that falls within either of the two paragraphs of the terms of reference to which I have alluded. But it is also important to recognise, I think, that the responses both by ASIC and by NAB to the events which were the subject of the Section 912D breach report, which lies behind the discussions which yielded the letter of 22 July 16, are matters that are themselves central to the inquiries I am charged with making. In particular, the response which NAB and ASIC make, and I think therefore the positions adopted both by ASIC and NAB in the course of whatever negotiations there were with respect to the matters that stem from the giving of the breach notice, are matters that may raise questions central to the execution of the terms of reference. In the circumstances, I think there should be no non-publication direction. Yes, Mr Hodge.
Thank you, Commissioner. Could we bring up ASIC.0036.0001.2898? That document will be in the staging area. Thanks. You've got that letter, Ms Smith?
I do.
That's a letter dated the 22nd of July 2016 to Mr Tanzer, a commissioner at ASIC.
Yes.
And whilst it's coming up, if you go to page .2904, page 7,
Yes,
you're one of the signatories to that letter along with Mr Hagger.
I am.
And do you recall the circumstances in which this letter came to be prepared?
Yes.
And what were they?
Essentially, this was to do with the TERP event, and as well as a number of other events, one relating to TERP, but then some others relating to other parts of the NAB Wealth business, where ASIC had raised concerns with NAB Wealth. And I had attended a meeting with Mr Hagger and ASIC for them to express their concerns to us and for us to put in place a response to those concerns.
Was this letter provided at that meeting?
I had 2 meetings with ASIC. I can't recall whether we provided this. This could have been provided at the actual second meeting, but I can't exactly recall.
Or in any event, you remember having attended 2 meetings in 2016 about this issue?
Yes.
And you remember, if we go to the first page, you see the first paragraph of the letter says, "Thank you for meeting on 24 June 2016
Yes,
with
so-
Andrew Hagger, David Gall and Damien Murphy."
Yes.
It doesn't seem to refer to you, so that probably suggests you weren't at the meeting in June.
I was not at the 24th of June meeting.
But you recall that somebody came and explained to you that there were concerns that had been raised by ASIC?
I'd been at a meeting prior to the 24th of June.
I see, with ASIC.
With ASIC.
And ASIC had raised concerns.
Yes.
And the question was, what was NULIS, the trustee, prepared to do in response to those concerns?
Yes.
And this letter outlined those proposals.
Yes.
And was this a letter prepared in consultation with you, or were you just brought a draft and asked to sign it on behalf of NULIS?
In the ordinary course of business, it would go through process with the management team, together with the OTT being part of that process, and I would be provided with a complete letter for me to review and approve prior to submission to ASIC.
Is it something, though, where you would be consulted about exactly what the response was that the trustee was going to make on behalf, or was going to make to ASIC?
At a high level, yes.
All right. And was one of the issues being raised by ASIC that it wanted an enforceable undertaking from NULIS?
Yes.
And NULIS didn't want to provide an enforceable undertaking?
No.
And why was that?
Essentially, and this was a view held by me, but also across the organisation, that we had, from about 2014, I would say, substantively improved our control environment across a number of, through a number of different measures and matters. And at the point that the errors occurred, which was prior to the uplift in our control environment, we felt we were a different organisation at the 22nd of July 2016 that we were in 2012 or 13 when the errors first occurred.
I see. And therefore didn't think that enforceable undertaking was warranted?
Yes, and so we were more than happy to obtain an external review and an independent review and provide that to ASIC, but we felt that an enforceable undertaking wasn't necessary for us to be able to do that and demonstrate to the regulator that our control environment at the 22nd of July was not as it was when the errors occurred.
And I'm just trying to understand some aspects of the way NULIS approached a request for an enforceable undertaking. As I understand it, an enforceable undertaking would be proposed because ASIC believes that there may have been a contravention of the law. Is that right?
I don't know when ASIC decides they
You don't
want
know why they want enforceable undertakings?
Well, they wanted one because they were concerned, they had concerns with our risk and control environment, but I don't know how they decide, when they're going to require an enforceable undertaking or not.
All right. If we go to page 2 of that document, we see paragraph 1.9, which explains the TERP trade-up.
Yes.
And you see subparagraph B says, we were not clear to members on the nature and how planned service fees would apply to members who did not have a named financial planner linked to their account.
Yes.
I'm trying to understand whether that explanation there reflects your view as to the reason why planned service fees should not have been charged to members with a non-linked advisor.
No.
It doesn't reflect your view?
No.
All right. And to be clear about that, that's because your view was that NULIS had no entitlement to charge fees to members for planned service fees where the member did not have a linked advisor.
Yes.
And do you remember querying this statement in paragraph 1.9b at
No.
the time that you signed the letter?
No.
Were you aware that this was the way in which the wealth business was seeking to position the issue as being not about whether NULIS had charged fees for services that had not been provided, but whether the representations to members were unclear?
No.
I'm trying to understand that though, because when you look at paragraph 1.9, isn't that positioning what's being identified here, what is happening in 1.9b?
Oh, sorry, can you expand on your question just to say what you think is being positioned here?
Isn't the positioning occurring in 1.9b to suggest that the problem with the planned service fees was that NULIS was unclear with members about whether it would charge planned service fees if there was no advisor linked to the member's account?
On a today reading of that, yes.
Just so I understand what you mean, when you say a today reading, you're not suggesting you read the words differently back in 2016?
So I would suggest it's a 7-page letter with attachments. Some of the concern at the time was around disclosure, but certainly not my intent not my understanding of the TERP matter at that time, at the time this letter was put together.
And then in paragraph 1.10, we identified and reported these flaws and we are fixing them. You see that?
Yes?
Again, I'm trying to understand if the authors of this letter have identified the wrong problem, then was it not an issue for you as the trustee that they were therefore not fixing the right thing?
Well, at this point for TERP, that was not the matter, and it was it was clear to me that the TERP members had no advisor and linked to their account, and that it was an error. So this letter is written at a time where I had only had visibility of the TERP review.
Yes. But the TERP issue is the same, isn't it? Whether who TERP are simply members who have been moved over into the MKBS, MKPS product.
Yes.
And the issue with them, as for every member who is in the MKBS, MKPS product, was where a plan service fee was charged, but there was no linked advisor.
Yes.
And your view is there was no entitlement to charge the fee in that circumstance.
Yes.
And that was the view you held at the time.
Yes.
And this is a letter written to ASIC, signed by you, suggesting that the problem was not that the trustee charged money when it should not have charged it, but that the trustee was not clear to members as to how the plan service fees work.
Yes.
And then in paragraph 1.10, it says we identified and reported these flaws and we are fixing them.
Yes.
So it identifies the wrong flaw.
1.9b would not be a full view of how I considered TERP at the time. So I would need to go and read the entirety of the letter for me to comment about whether or not there are other things in here that reflect my opinion about TERP at the time. But I was very clear in my mind, at the point we were in discussion with ASIC, that TERP members did not have an advisor linked to their account and they should not have been charged a fee.
So I may have misheard something that you just said. Did you say you were very clear to ASIC that that was the case?
I was very clear in my mind.
Oh, I see. You were very clear in your own mind as to what the problem was at the time that you were
TERP
meeting
members.
with ASIC?
Yes.
All right. Did you communicate to ASIC what you thought the problem was?
We had discussions about that I felt it was an error.
I think you'll get the opportunity to look at this document overnight. Can I ask you about some other parts of it? Can you go to page 4 of the document?
Yes.
And you see what is paragraph 2.12c, compensation methodology.
Yes.
Compensation methodology are considering the right compensation methodology for these members. This methodology should appropriately reflect any potential legal liability position which we are working through at the moment and also be practical to implement.
Yes.
Can you recall what the legal liability issue was that you were working through?
No.
Can I suggest to you that it was the suggestion from the wealth business that they could retain the plan service fees even though there was no linked advisor because there were other types of general advice available through, for example, MLC Direct?
That was not put to me as this letter was being written. and nor formally put to me as a proposal for compensation for the planned service fee matter.
All right. Can you recall alternatives being put to you as to the proposed remediation?
No,
You can only recall one possibility for remediation being
it came
put
to the
you.
board, yes.
And did you know at the time you signed this letter what the issue was about potential legal liability of NULIS?
No,
Do you know whether the office of the trustee knew?
at the 22nd of July, no, I don't.
Was that something that when you signed this letter you were curious about? Why are we not able to make compensation yet because we're trying to figure out a potential legal liability?
I don't recall questioning that paragraph at the time.
And then if we go down to section 3 at the bottom of the page, you see 3.1, we believe that enforceable undertakings are not necessary to ensure that we fully implement our commitments.
Yes,
And then it's explained in 3.2, we have a very strong organisational culture focused on our members and doing the right thing.
yes,
We have a strong track record of faithfully remediating via negotiated commitments.
yes,
We believe that negotiated commitments would deliver faster remediation and compensation outcomes to members at less expense to the public purse.
yes.
Why is that?
Well, my experience as a director with the organisation has been we don't always get it right and we do make mistakes, but there's never been a question that I've seen or a matter where I've seen the organisation not look to put customers back in the position they should have been had the error not been made.
I'm sorry, the
Had
error.
the error not been made. So my experience of the culture of the organisation was we might be a bit slow at it, but we will do the right thing by our customers.
And so that I understand, and so that we can focus the examination tomorrow, do you say that was your experience as at July 2016, or that in addition, in the subsequent 2 years, that's also been your experience?
I would say both.
Now, we'll come back to this in the morning, but you know, don't you, about the resistance that NULIS through the Wealth Division has put up to remediation in various respects?
I would not say that NULIS has ever put up resistance to remediation. So you're talking about the trustee now?
Yes.
So no, I would not agree with that.
I see. So you don't agree
And,
that with the trustee. What about the bank?
And I'm not part of all of the management conversations. I'm not part of the debate that goes on in the management team, and necessarily I don't have the detail of those conversations. I do believe it is for the PSF matters, and I'm sure we'll discuss this tomorrow as well, that it has taken us too long to get to the remediation point on in 2 instances. But we have got to the point where we are remediating and putting customers back in the position they would have been had the errors not occurred.
Why do you think it has taken too long?
I don't really know the answer to that. Partly, I would say that as soon as you have a large problem and a large error, by its very nature, it can be technical and complicated to work out how many members, who it affects, the quantum, the size, and wanting to appropriately have an investigation to understand that. But I would say that in both instances it's taken us too long. I haven't been part of the management process to be able to assess that. I'm only making a subjective view from the outside.
Commissioner, is that a convenient time?
Yes. Are we travelling for time, Mr. Hodge?
Commissioner, we're behind, but
I won't ask
I'll-
how far.
that's certainly...
9:30 tomorrow?
Thank you, Commissioner.
Yes, very well. Adjourned at 9:30.
The Royal Commission is now adjourned until 9:30 a.m. tomorrow.
Yes, Mr Hodge. Ms Smith.
Commissioner, I should probably note you may have observed on walking into the room that it's like walking into a sauna. The air conditioning is not working at the moment, it seems.
I've been told that and observed that, and
Yes.
steps are being taken as much as they can be.
Yes. Ms Smith, what I wanted to do was to take up where we had been yesterday, which is looking at that letter that you had signed with Mr Hagger and sent to Mr Tanzer. That is ASIC.0036.0001.2898.
Yes.
If we go to page 4 of that document, you'll recall yesterday I was asking you some questions about subparagraph C on that page in relation to compensation methodology,
Yes.
where it says that, and this as I understand it is referring to both NAB and also NULIS, because Mr Hagger is writing in effect on the NAB wealth business and you are writing on behalf of NULIS.
Yes.
And you are saying we are considering the right compensation methodology for these members. This methodology should appropriately reflect any potential legal liability position which we are working through at the moment and also be practical to implement. Now, I want to return to the questions I was asking you yesterday afternoon. Do you have a recollection of what that potential legal liability position was that was being worked through?
So at this point in the review process, the organisation was still reviewing the SWIFT and Encompass matters. So I don't recall from when we wrote this letter what we would have been talking about specifically, but on reflection, I expect that is what it's talking about.
No, I'm afraid that can't be right. If you go back a page to page 3, you see 2.12 says, in relation to TERP PSF matters,
Yes.
we confirm that and so this compensation methodology is not about SWIFT or Encompass, it's about TERP. So TERP has already been identified as a breach by this point
Yes.
more than 6 months earlier.
Yes.
So this can't be an issue about SWIFT and Encompass, you agree?
Agree.
It must be about TERP.
Yes.
So do you know what the legal liability issue was that was being worked through in relation to TERP?
Not from the trustee's perspective, I don't.
So you, as far as you can recall, weren't kept informed as to what the issue was with legal liability at this time?
So there hadn't been any updates to the trustee in respect of further legal liability in respect of TERP at this point in time. I would like to make one comment though. This letter was not about setting out the remediation program, nor was it about describing the event in itself. This letter was intended as a description and a commitment to the review program that the administrator and the trustee were looking to enter into with ASIC to satisfy ASIC in respect of the concerns they had over the control framework.
Thank you for your comment. If we can just return to my question in this paragraph. There is a statement of fact made here about what is going on which is that we, that is the NAB Wealth business and NULIS, are considering the right compensation methodology for these members. This methodology should appropriately reflect any potential legal liability position which we are working through at the moment. So
Yes.
if we just focus from the perspective of the trustee, did you know what the issue was about potential legal liability?
No, I do not recall.
And then can we bring up NAB.162.011.1706? Thank you. If you look at that screen, you'll see this is a chain of emails. You're not on the chain of emails, but you'll see there's an email starting in the bottom half of the page, which is an email from Paul Carter to some other people within the NAB Wealth business. Can you see that?
Yes.
And it says, having spoken to Nicole S., which presumably must be you, and then you see it sets out on the bottom half of the page on PSF.
Yes.
And I just want to understand a few things. You were obviously speaking to Mr. Carter about what was going on with PSFs.
So if I recall what this would have been about, this was about the interactions we were having with ASIC at this point in time, and talking about why we thought the control environment was different today, or at this point in time in June 16, to what it was when the events had occurred. And the conversation that Paul is reflecting that we've had is about my view on what I thought was different in the control environment and the way I saw that.
Do you remember having had this conversation with Mr. Carter?
I had many conversations with Mr. Carter. On looking at the email, I do believe that is what this is referring to.
Right. So you, over the course of 2016, you mean you had many conversations with Mr. Carter?
Yes.
And many conversations about the PSF issue?
I would have had a number of conversations about the PSF. Paul was the executive responsible for the superannuation business, and as the chair of the board, we would have spoken weekly to fortnightly.
He was, as you say, an executive for the superannuation business of NAB within NAB's wealth division?
Yes.
And he was also a director of National Wealth Management Services Limited?
Yes.
And National Wealth Management Services Limited was the company that effectively performed the management and administration for the trustee?
Yes.
And in the event that money needed to be repaid to members, which in your view it had to be, that's right, isn't it? It had to be repaid.
Yes.
And that was always your view from the moment you knew about the breach.
Yes.
And it was always your view that the full amount that had been taken in PSFs from members who did not have a linked advisor needed to be repaid to those members.
At this point for TERP members, yes.
All right. Did you understand that Mr. Carter had a different view about that?
What I understood, and whether it was at June or July or at what point in the cycle, I couldn't actually say when the conversations would have been had. At a very high level, I understood that there had been legal advice received by the administrator that had a different legal liability position to the trustee, and the management team, together with the Office of the Trustee and the Chief Risk Officer, were working through the occurrence of the event and the different legal opinions.
And so at some point in time, you're not sure whether it was June, July, August, you were told that the administrator had obtained a legal advice that suggested that it might not have a legal liability to repay this money. Is that right?
I did not see the legal advice.
No.
And
What I'm
had
interested in is what you were told.
I'll just pause to reflect in respect of kind of what I think I knew at the time. I had some very high-level conversations with Paul and the Office of the Trustee regarding the administrator's different position to the trustees. And my view at the time was, you need to work through it, we need to work through it quickly, and we need to come to a conclusion. And I didn't get into a debate about who was right and who was wrong, because I did not have all of the facts and all of the information in front of me. So my point at the time was, I wasn't involved in the detailed conversations. I knew that there was a difference of opinion, and I was pushing the management team and who is the administrator to come to a conclusion and for us to resolve the matter.
You did have all of the facts, though, didn't you, Ms. Smith? You had approved the PSFs in the first place in 2012. That's right?
Yes?
In 2015, you were told that there was this breach, and the breach was that money had been taken from members who did not have a linked advisor, where the money that was taken was supposed to be for a service being provided by a linked advisor.
Yes?
Those are all the facts you need, aren't they?
No.
Why not?
At the time, I understood that there were two different opinions in the organisation, and that was being worked through by the management team and overseen by the Office of the Trustee. So I was expecting due process to be taken and for a final determination to come to the board.
So the management team is the management team that Mr. Carter is responsible for?
Yes.
And that's the management team in the wealth division?
Yes.
And it's the wealth division that's been taking this money?
Yes.
It's been increasing its profit?
Yes.
If it has to pay this money back, it'll be the wealth division that has to pay this money back?
Yes.
It's hopelessly conflicted, isn't it? How can it advise you about what should be done or make representations to you about what should be done if it's the one that has taken the money and will have to pay it back?
So, yes, there is a conflict for the administrator in terms of the revenue. However,
Go on.
okay. However, the administrator wasn't sitting there on its own without appropriate representation from the trustee working its way through the process. As I mentioned yesterday, the breach review process has independence from the CRO and from the Office of the Trustee during that process. And in this particular event, there was also independent legal advice that had been sought and obtained by the trustee.
Is it fair to say the reason that a decision had not been made earlier than the 26th of October 2016 to fully remediate TERP members was because the administrator was taking a different position or considering a different position as to whether it had to repay the money?
I was not involved in the administrator's conversations, so I'll just finish. To say that the administrator was reviewing all of the facts of the circumstances of the events, of which was whether or not there was a liability on behalf of the administrator.
Are you comfortable with the passage of time between December 2015 and the 26th of October 2016 from when the breach was notified to ASIC and when a decision was made to remediate the TERP members in full?
No, it took too long.
And did you inquire as to why it had taken too long?
I was, during that period, for want of a better word, agitating and asking for the matter to come to a head.
Who were you agitating with?
With senior executives and the CRO.
So the CRO is Mr. Murphy,
Yes,
and the senior executives
Paul
are who?
Carter.
All right. Anybody else? Did you agitate with Mr. Hager?
No, not at the time, I don't believe.
You were signing letters with him to ASIC about the remediation program,
Yes.
but you didn't discuss with him what the delay was?
I don't recall having discussed it with Mr. Hager.
Was it ever explained to you what the delay was?
It was the matters I referred to previously in respect of the process that the administrator was going through in understanding the Encompass and SWIFT events.
Do you think that the trustee acted in the best interests of members by waiting until the 26th of October 2016 to finally decide to fully compensate TERP members?
Yes.
And why is that?
So first of all, members were fully compensated and a decision was made by the administrator and recommended to the trustee to fully compensate members. At the time and on reflection, my view was that management needed to work through the facts of the matter and that the board shouldn't be used as a blunt instrument to come to the right decision, and that the administrator came to the right decision for members without using the board as a blunt instrument to do so.
Can you see that the problem with the approach that you've outlined is that the board of directors has only one duty, and that is to act in the best interests of members, and that the administrator is conflicted because the administrator is the one who will have to give back the profits?
I think that the issue is timing, at which point the member is fully compensated for the extra time.
Well, now that's not quite right, is it? Because the compensation is based on interest, is that right? Rather than lost
No.
earnings? In the case of...
No, the
Your
trustees'
understanding is-
compensation policy requires and was a minimum of interest. If you are still invested in the fund, it is the higher of the earnings on your account or the BBSW plus X% interest rate as a floor.
Now, I want to show you another document. Can we bring up NAB.047.005.1696? While that's coming up, can I ask you this? In hindsight, as you reflect on the last 3 years of your term as chairman, do you think this event, that is the wait of 10 months or more than 10 months from the notification of the breach to deciding to compensate, is reflective of a general pattern of the NAB Wealth Division delaying in making the right decision by members?
No, I don't.
Right? So if we have a look at this document, this is an email from Ms. Debenham within NAB. You can see that you're one of the recipients of it.
Yes?
And it's an email setting out the concerns that have been raised by ASIC in relation to the NAB Wealth business and the trustee entities.
Yes.
Do you recall having read this email at the time it came in?
I expect if I received the email, I would have read it at that time.
Right, and well, you did receive the email. Didn't
Yes.
You see that? And do you recall that ASIC expressed concerns about the adequacy of processes within the NAB wealth business and specifically the trustee?
Yes.
Did you share those concerns?
So the whole, from this point, there had been reflection with management and the entire board around what ASIC was saying to us and what we believed our position in June 16 actually was. And I think I talked about yesterday and the point of the 22 July letter and the subsequent meetings that were held with ASIC after this email were about the view that we felt our control environment had gone through enormous uplift since the events had actually occurred. And so while ASIC was raising concerns with us, we felt that the environment that had led to the errors was not the environment we were operating in June 16.
I see. If we go to page .1700,
Just trying to make sure it's loud enough.
I think you've got that page.
I do.
And you'll see this is part of the chain of emails that's ultimately been forwarded onto you. And do you see a heading halfway down the page which is ASIC concerns?
Yes.
And what's explained there is, while satisfied that the TERP My Super Breach remediation should proceed as planned, ASIC remains fairly concerned about the whole manner of the trustee giving approval for the TERP trade-up and also the My Super product upgrade. So we just pause on that. Did you have concerns about the circumstances of the trustee giving approval for the TERP trade-up?
No.
Was there any investigation that you did into those circumstances?
No, not into the TERP trader. From the trustee's perspective, no.
All right, we'll return to that in a moment. And then you see it says, and also concerned with the mishandling of trustee conditions in the implementation of trade-ups and product upgrades.
Yes.
Did you have any concern about that issue?
There were some errors regarding insurance, so I believe that's what that's referring to.
But that didn't cause you to have any concerns about the system that was in operation?
Not about the entirety of the system, no.
And then you see, in ASIC's view, there was too much reliance on the administrator doing things post-trustee approval. A classic example being not ensuring that the M100 insurance policy was updated at the time of the TERP My Super changes being made.
Yes.
Did you have a concern about whether the trustee was too reliant on the administrator?
No.
Do you recall that ASIC was concerned that the trustee was too reliant on the administrator?
Well, in this email it says that ASIC was concerned that we were relying on the administrator doing too many things after our approval.
Do you have a recollection of that concern
Yes.
being raised with you?
Yes.
And do you have a recollection of whether you responded to that with ASIC?
Through the several meetings that I attended, and then the result of these concerns was the trustee entering into licence conditions and an independent external review.
All right, so just so I understand, did you share this concern that ASIC had?
I think that there's nuance in the concern that we did have some control breakdowns that I think looked like we were relying on the administrator too much, but I don't think that in my view that's actually what the issues were.
Right. I tendered that document, Commissioner.
Yes, now, I don't think we've, the letter NAB to ASIC of 22 July has been marked yet.
I think I may have tendered that yesterday with Mr Carter, Commissioner.
The letter NAB to ASIC?
Oh, I'm sorry. No, you're quite right, Commissioner.
The letter NAB to ASIC of 22 July 16, NAB 0036, 00012898 is Exhibit 5.47.
Thank you, Commissioner.
The emails between Debenham, Hagger, Smith and others of June 16, the subject line is what, Mr Hodge, in these emails?
NAB wealth breach events, enforceable undertaking, confidential - not for distribution.
Having that subject line, NAB 0470051696, Exhibit 5.48.
Thank you, Commissioner. Can we bring up NAB.005.067.6509? Now, we've gone back in time. This is the breach notification given by MLC nominees to APRA at the end of 2015.
Yes.
And you've exhibited this to your statement.
Yes.
And if we go over the page to .6512, this is the explanation for what occurred in relation to the TERP breach.
Yes.
And at this stage, it said the analysis indicates that approximately 47,000 members have been impacted. You see that towards the bottom of the page?
Yes.
Ultimately, there ended up being many more than that affected. Is that right?
Yes.
All right. And then you see in the middle of the page, there's a paragraph which is unfortunately.
Yes.
Can we just blow that up with the numbered points? Now, I just want to ask you to read that paragraph and tell me whether you understand that paragraph to be true.
I understand that is the view that management had as a result of their investigations into the TERP event.
I think if we just go back to my question, do you believe that that paragraph is true?
So I know factually that that the management paper did not outline point 1. I have an understanding of point 2 and 3 based on management's investigation into the matter, not first-hand knowledge.
All right. So let's just work through it. Point 1 is the management paper that was prepared by the administrator in April of 2012 didn't say that there would be a group of transferring members who did not have a plan advisor pre and post the transfer.
Yes.
And in fact, it didn't speak at all about members who didn't have an advisor.
Correct.
In fact, what the management paper said to you is this is a fee, the plan service fee, that is going to be charged for services provided by an advisor.
Yes.
And then point 2 is it was the administrator's intention to provide non-advised members access to general advice services through a different channel. So I just want to understand, management has ultimately reported to you that the administrator had always intended to provide non-advised members access to general advice services through a different channel? Is that right?
No.
Has management told you that this was always the administrator's intention?
I would need to go back and review board papers to see exactly what they said. But the breach review notice is not seen by the trustee at the point it's being lodged, nor lodged with the board paper afterwards. So
when was the first time you saw the breach notice?
as for preparation for my witness statement.
So this is the breach notice given on behalf of the trustee,
Yes?
and your recollection is the breach notices are never provided to the board when they're given.
They may have been at some point in our cycle, in terms of our reporting, but reporting changes in the way it goes to the board. So certainly more recently we do not receive them.
Now, if we just stay focused on point 2, something's missing from this, isn't it? Because the administrator was providing the same general advice services to members whether they were advised or unadvised.
I don't know if they would be the same as to what the financial planner was providing. Certainly not.
No, sorry. You've misunderstood my question. It's my fault. If a member has a linked advisor, the administrator will provide certain general advice services to that member.
Some general advice services, yes.
The member can call up and ask what their balance is, or to transfer products, or how they do certain things, and that'll be provided to a member with a linked advisor.
Yes?
And the same services are provided to a member without a linked advisor.
Yes.
There's no difference between the general advice services provided by the administrator to a member with a linked advisor and a member without a linked advisor.
Yes.
All right. And then you see point 3 is it was intended that the administrator would retain the PSF amounts deducted from the non-advised member accounts.
Yes.
Now, the passive voice is a little confusing there. It wasn't the trustee's intention that the administrator would retain the PSF amounts deducted from non-advised member accounts, was it?
No.
So the only intention that this can be speaking of is the intention of the administrator.
Yes.
So, again, so that we understand, management has told APRA, and they've told ASIC the same thing in identical terms, that the administrator intended to retain the PSF amounts deducted from non-advised member accounts.
The Chief Risk Officer, who's signed the breach notice,
Yes.
has advised that, yes.
And do you understand that that's true, that that was always the intention of the administrator?
Based on what the administrator has said to me, yes.
All right. So did that cause you concern if that was the intention of the administrator?
Yes.
And what did you do about that concern?
We remediated customers.
But I want you to think about this. You are dependent upon the administrator for providing services to members. Do you agree?
Yes.
You certainly hold the view that there was absolutely no entitlement on the behalf of the administrator to retain PSF amounts deducted from non-advised member accounts.
Yes.
You held that view from the moment you were told about what the breach was.
Yes.
The administrator has informed you at some time that it had always been the administrator's intention to retain PSF amounts deducted from non-advised member accounts.
Yes.
Did you say to the administrator, we need to understand what the process is by which you go about taking money that you are not entitled to?
Those specific words, no.
Did you say words like that?
No.
Did you make any inquiry as to how it is that the administrator could have formed the view that they should take the PSF amounts deducted from non-advised member accounts?
Yes.
And when did you make that inquiry?
There were reviews undertaken into all three specific events that led to this particular remediation program, so TERP, Encompass and SWIFT, as to the root cause of the error, how it occurred.
And what was the root cause of the error as you understood it?
Essentially that the administrator had not undertaken appropriate or had not provided appropriate information to the trustee at the point of the decision of implementing the PSF.
Now, I don't understand that. What was the appropriate information that the administrator should have provided?
It should have been clear of the different categories of members who would have had a PSF charged against them.
And if the administrator had told you, the trustee, in 2012 that they were going to keep deducting the PSF amounts for non-advised member accounts, what would have been the outcome?
I expect the outcome would have been that they, no,
The trustee would have said, no, you can't do that,
yes,
for the obvious reason that there's no lawful basis that you can take money for not providing the service that it's supposed to be charged for.
for the obvious reason that there's no advisor linked to the account and so therefore no service in respect of the fee being charged.
And did you inquire as to why the administrator had not informed the trustee of this in April of 2012?
There were several discussions and reviews into the why. Unfortunately, the relevant management team were no longer in the organisation, and so it's really then a subjective view as to intent and what had occurred.
All right, but this, recognising this problem, that the administrator had taken money that it was not entitled to take, you agree with that? That was a problem?
That members should never have been charged the fee?
Yes.
Yes.
And the administrator had taken that money?
Yes.
B, that the administrator had not told the trustee about what it was going to do, that was a problem?
Yes.
Did that cause you concern in 2016 about whether the trustee could rely upon the administrator to do the right thing?
I think I'd go back to whether it was unclear from the reviews undertaken as to why the trustee had not been included in the trustee board papers, and clear to the trustee that there were sets of unadvised members that the PSF would be applied to. That was a concern, but at that time it was not my concern that we could not rely on nor trust the administrator to fulfil their obligations under the contract, and nor to do the right thing.
Attend to that. Oh no, I don't need to attend to that document, Commissioner. That's already in as part of the evidence of Ms. Smith. Can we bring up ASIC.0036.0002.0927? So then we've looked at the 22 July letter that you and Mr. Hagger sent to ASIC. There was a meeting that occurred on the 22nd of August between representatives of NULIS and National Wealth Management Services Limited on the one hand and ASIC on the other?
Yes.
Do you remember whether you attended that meeting?
I attended 2 meetings with ASIC during this period, and I think I was at the August meeting, yes. I think it's in my witness statement, the 2 dates of the meetings I attended.
All right. And then ASIC then writes this letter on the 23rd of August, where ASIC is confirming that if you look in 2A Roman numeral 1, NULIS and National Wealth Management Services Limited will commit to undertake remediation programs.
Yes.
And ASIC doesn't consider the negotiated commitments are an appropriate way to resolve its regulatory concern.
Yes.
And then if we go over the page to the 3rd page, .0929, we see ASIC explaining that it does not consider the negotiated commitments are appropriate and that instead it seeks an enforceable undertaking, and it says an enforceable undertaking is an appropriate regulatory outcome in the circumstances of our concerns, and EU is an administrative settlement and the mechanism we would ordinarily use to resolve serious compliance concerns, even in circumstances where a regulated entity has complied with its statutory obligations to report any breaches, has cooperated and has been prepared to acknowledge ASIC's concerns. However, NULIS didn't want to give an enforceable undertaking,
No.
and NULIS wanted instead to have a change to its licence conditions.
Yes.
And can you explain to the Commissioner why there was a preference for changing the licence conditions rather than giving an enforceable undertaking?
There was discussion at the trustee board with all of the directors, and the preference of the board was to have licence conditions as opposed to an enforceable undertaking.
But why?
I'd have to go back to the minutes to determine kind of the considerations we had at the time. We weighed up kind of the benefits of or the perceived views of either an enforceable undertaking or licence conditions. Essentially, they meant we would do exactly the same thing. One just imposed licence conditions on us, and the other would have been called an enforceable undertaking.
Out of curiosity, did you regard yourselves as getting off lightly, that ASIC wasn't suggesting that it might actually take enforcement action against NULIS or National Wealth Management Services Limited?
Absolutely not.
Absolutely not.
Absolutely not.
Sorry, go on.
We didn't take it lightly.
No. Did you regard yourselves as getting off lightly?
Oh, no.
Did you think that there was the possibility that they would take enforcement action against you?
Yes.
Did they write to you and talk to you about that?
Yes.
And what was the type of enforcement action that they talked about?
Exactly what you can see here in the form of the matters of the licence condition that were imposed. That was what was on the table from ASIC at the beginning of the conversation, and that's what we entered into.
I'm sorry, I think one of the difficulties in this area is that I use the word enforcement action in a different way from people
from
within
the
the
accounting
industry.
brain. Yeah.
Sorry?
From the accounting brain.
No,
So-
it's not an accounting brain thing. When I talk about enforcement action, I mean a proceeding commenced in a court alleging a contravention of the Act. But for some reason, that's not what enforcement action means in this area.
I don't believe that ASIC was discussing enforcement action with us in any form other than the licence conditions that we, either through the licence conditions that we ended up entering into.
Right, so you can't ever recall having to contemplate at the trustee level the possibility that you might face a civil proceeding?
At this time, no.
All right. And was it ever raised with you by management, the possibility of a civil proceeding? I don't mean at the full board level, but just with you?
I don't believe so.
All right. And then...
Any contemplation of a criminal proceeding?
Not at this time, no.
Ever?
I believe in respect of the PSF events that are the latter part of my witness statement, that ASIC is still investigating, and so that's a very long-winded way to say no, but ASIC are still investigating in respect of the the final PSF matter.
Did you think yourself that taking money to which there was no entitlement raised a question of the criminal law?
I didn't.
Go on.
Attend to that document, Commissioner.
Letter ASIC to Smith and Hagger, 23 August 16, ASIC 003600020927, Exhibit 5.49.
We bring up ASIC.0036.0001.2916. Now, this is a little confusing because you'll see this is headed draft talking points addressing matters from the meeting with ASIC on 22 August 2016 and subsequent correspondence. These seem to be talking points from some later date after the 23rd of August, but it's not clear what date it is. Have you seen this document before?
I don't recall seeing it before.
All right. And I think you were pointing this out before, that the alternative basis that ASIC offered in that letter of the 23 August 2016 to address its concerns was by NULIS consenting to a variation of its licence conditions.
Yes.
And so ASIC had presented you with two options: an enforceable undertaking, which was its preferred option, or alternatively, an amendment to the licence conditions. Is that right? And then if you look down in paragraph 2.4 at the bottom of the page, you can see ASIC was indicating that the insurance review was required and it had to be under either an enforceable undertaking or the licence conditions.
Yes.
And then if we go over the page, you'll see a query at the top of the page, which is if NULIS was to choose to consent to a licence condition reflecting similar obligations as outlined in the proposed EU, and then effectively it's what's the process by which the licence condition will be satisfactorily completed and then the licence condition revoked.
Yes.
And do you recall whether you were involved in drafting this document?
I don't actually know the purpose of the document, so other than it saying talking points, I don't know what it was used for. So whether or not I would have been involved in the drafting of essentially I would not be involved in drafting. My role as a director would be to receive a drafted document, and I would reflect on that for what I would believe to be accuracy in the trustee's point of view.
All right. Attend to that document, Commissioner.
Draft talking points, have we a date for it, Mr Hodge?
It's not dated, Commissioner, but I can tell you it must have been provided before the 16th of September 2016.
And is there any indication of authorship or origin?
It is likely draft talking points for Andrew Hagger and Andrea Debenham.
Draft talking points, ASIC 003600012916, Exhibit 5.50.
And then can we bring up ASIC.0036.0001.7353? So this is a letter dated the 16th of September 2016 to you and Mr Hagger.
Yes.
And you'll see in the first line it's referring to a meeting with Mr Hagger and Ms Debenham. And to that document we've just looked at, which is draft talking points.
Yes.
And Ms. Debenham, what was her role?
Basically a liaison with the regulator, so supporting the regulator interaction into NAB Wealth.
All right. And you see then in the second paragraph, the last sentence says, ASIC has not yet received a response from the boards of NULIS, National Wealth Management Services Limited and NAB Wealth.
Yes.
Now, was the decision as to whether NULIS would agree to a change of licence conditions a decision about which you would receive a recommendation from management?
No. The trustee took independent external legal advice in respect of whether or not we would enter into an EU or whether we would ask for licence conditions. I would have to go to the board paper as to whether or not there could have been a recommendation from management in that. But essentially it was a discussion of the board and a full board decision.
Did you discuss with Mr. Hagger whether NAB Wealth had a preference between an enforceable undertaking and an amendment to the licence conditions? No. Not that you can recall?
No.
Or no, you definitely didn't?
No, I 2.5 years later, I'd probably say the answer's no.
Is it, from your point of view, to be expected that Mr. Hagger and Mr. Debenham, Ms. Debenham, neither of whom are representing the trustee, would be attending a meeting without anybody from the trustee to discuss whether there would be an enforceable undertaking or change to licence conditions for the trustee?
Well, I think they would both be in their capacity representing the trustee.
I see. They would be there representing the trustee?
Yeah.
Okay.
How?
How?
Yes, how?
Well, essentially, the administrator is acting under, the service provider to the trustee. So the trustee doesn't do everything itself. It has an administrator that undertakes all sorts of activities on its behalf. In respect of meetings with the regulator, where the trustee believes it needs to put forward its own voice or an independent position, that is actually when I have attended, or we've ensured that the COO of the Office of the Trustee would be attending those meetings. In this instance, this was, ASIC had put forward, we really had a view on what ASIC wanted from us. We were in discussion about whether that would, it was exactly the same thing as whether it was an enforcement, whether it was an EU or licence conditioned. It was the term, the legal term or the construct that they were getting us to do the review that was different. So we didn't believe that there was a conflict for Mr. Hagger or Ms. Debenham attending a meeting with ASIC without anyone else present.
So you considered whether there was a conflict or not?
During this period, we considered when I should go or the Office of the Trustee should go and attend meetings with ASIC, yes.
If an enforceable undertaking was going to be given, it was to be given by both NULIS and also National Wealth Management Services Limited?
I don't believe so. NWMSL is not a licensed entity. It would be the trustee entering into the enforcement action.
If we go over to page ASIC.0036.0001.7356.
You might tell me I'm wrong now, so.
I'm sorry.
You might tell me I'm wrong as I just said that.
Well, if you look in paragraph 12, you see the answer from ASIC is, as stated in the 23 August letter, in the event that NULIS and National Wealth Management Services Limited are prepared to offer an EU to ASIC, we confirm that we are willing to meet with you and APRA to discuss the scope of the ASIC assurance review.
Yes.
And that would suggest that both entities would be offering the EU.
It would.
but the licence condition change was only for NULIS.
Yes.
Was there any discussion about whether, that you can recall, that you participated in, as to whether having a change in licence conditions for NULIS would attract less publicity and media scrutiny than offering an enforceable undertaking?
I think we talked about all aspects of the implications of whether it was an EU or licence conditions, one of which would be about adverse publicity.
Yeah, so my question, I'll rephrase to you. Was there a discussion that you can recall about differences in adverse publicity depending upon whether an EU or a change to licence conditions occurred?
Yes.
And do you recall that the effect of the discussion was that there would be less adverse publicity if there was a change of licence conditions rather than an enforceable undertaking?
Yes.
And was that a reason that NULIS decided to push for a change to licence conditions rather than an enforceable undertaking?
No.
So you discussed it, identified that there would be more adverse publicity if there was an enforceable undertaking, but that wasn't the reason why you decided to push for a change to licence conditions.
So I don't think we pushed for licence conditions. I think both were on offer from the regulator, and we said our preference was for licence conditions. So that would be my first comment. The second comment I'd have would be, I did say that there were a number of matters talked about and discussed based on legal advice as to what the differences were between an EU or licence conditions. While we felt that an EU might have more adverse publicity, we did feel it was in the margins and was not a driver for the decision around whether we had an EU or licence conditions.
All right, so if we identify what the differences were, as you can recall them, one was that there might be more adverse publicity around an enforceable undertaking.
Yes.
Another was the enforceable undertaking would be given by NULIS and National Wealth Management Services Limited, whereas the change to licence conditions would only be a change to NULIS's licence conditions.
No, I don't recall that being a discussion or a point at the time.
Okay. What are the other differences that you can recall?
One that comes to my mind was that the long-term publication around where an EU sits on ASIC's registers versus once we complete the licence conditions, they are removed. And I'd have to go back to the legal advice to look at the differences between what we felt were, what we thought the differences were. What I can say is it was really in the margin. We really didn't think that there was an enormous amount of difference between an EU or the licence conditions. The point was actually that we were entering into undertake a piece of work that ASIC was requiring of us, and the instrument that they did that with, while we did discuss it, because we had a decision to make, I think it was really just on balance the board preferred the licence conditions.
Attended that document, Commissioner.
Letter 16 September 16, ASIC to Smith and Hagger, ASIC 0036 0001 7353, Exhibit 5.51.
Can we bring up NAB.155.027.3782? Now, Ms. Smith, this is the letter of the 24th of October 2016 sent by Mr. Hagger to the Board of Directors of NULIS. Have you seen that before?
Yes.
Have you reviewed it recently in the process of preparing to give evidence?
I would have reread it.
I'm sorry?
I will have reread it during this process.
So
If you need a hard copy, Mr Hodge, there's one available.
it may assist
Yes.
Ms. Smith to have a hard copy. So by the 24th of October 2016, the administrator writes to NULIS and makes a recommendation about remediation,
Yes,
and that's this letter.
yes,
You'd already, I think, received a board paper in support of the recommendation.
I believe this was attached to the board paper.
But I don't think we're disagreeing about this, but we'll see in a moment. The board paper is dated the 21st of October and would presumably attach a draft of the letter, and this is the final signed letter.
Yes,
And if you go over the page, you see paragraph 5.
yes,
The trustee will need to draw its own conclusion as to whether it prefers the investment policy alternative or the trust expense alternative.
yes,
Each alternative results in a different compensation methodology.
yes,
The first methodology is the opt-in approach,
yes,
and the opt-in approach applies on what's described as the investment policy alternative.
yes,
And the second methodology is the trust expense alternative,
yes,
and that would provide for full compensation.
yes.
Were you aware before you received this letter and the relevant management paper that the administrator was considering these two alternatives?
I was aware, no more than what I've said earlier this morning in respect of what I understood the administrator was working through.
That is, you understood that the administrator was working through some questions that affected whether it had to make full compensation or not.
Whether or not, no. What I was aware of whether or not at a high level it was a trust expense or whether it was considered a charge under the investment policy.
All right. And do you remember when you were first made aware of that question?
No, I said earlier this morning, I couldn't pinpoint the exact date that I would have been having conversations around what exactly management were working through.
Can I suggest this to you? The moment you were told that was a question, were these fees charged as a trust expense or as an investment policy or under the investment policy? You knew what the answer was, didn't you?
I had a reaction to the answer based on not all the information that management had.
Well, let's just think about the information that you had. We looked at this yesterday afternoon. We can go back to it if it would assist you. In April of 2012, management came to you and presented a lengthy presentation in which they said that they were going to change from charging money under the investment policy to charging money as a trust expense, didn't they?
So I didn't, my reaction was, I don't understand all the facts. If you'll need to bring forward a full, a paper setting out the information for full consideration. I can't give an answer in a fireside conversation as to what my view is. That was my response to when I heard it.
But you had an immediate reaction?
I had a reaction that was based on the knowledge that I had about the part of the facts and the legal circumstances that I had.
And based on the knowledge that you had, the investment policy idea was impossible, wasn't it?
My reaction was not, it's impossible. My reaction was, I can't give you an answer whether I think that's right or wrong without all of the information in front of me.
You had a reaction of sitting on the fence.
No, I don't believe that was...
I understand your answer to be, Ms Smith.
No, I don't believe I was sitting on the fence. I was being asked questions of whether I thought what my opinion was on the investment policy, and my answer to that was, I didn't have the information that the management team had in front of them to be able to draw a conclusion one way or the other. And if they wanted my view, then they would need to put forward analysis of the two different views for me to be able to consider the facts and have a considered opinion.
Can we put that on one side of the page, or one side of the screen, and bring up on the other side of the screen NAB.005.788.0496? On the right-hand side of the screen now, Ms. Smith, you can see the document we looked at some length yesterday, which is the management paper presented to you on the 19th of April 2012.
Yes.
And if we go to the second page of that document on the right,
Yes.
we can see that while it's coming up, that the thing that the directors resolved to approve, amongst other things, was the proposed changes to advisor payments under the trust deed, as detailed in section 7 of this paper.
There's
see
a
at
hard
the top-
copy. I will give
the
it
top
a
of the
hard
page.
copy, I think. Give her the-
Yes. Yes.
You'll have a hard copy, Ms. Smith, to assist you. You see at the top of the page, the second page.
Yes.
So what the board had resolved was to approve the proposed changes to advisor payments under the trust deed as detailed in section 7 of this paper.
In 2012, yes.
Yes. Well, that's the only approval that matters, isn't it? Because what is approved here determines the basis upon which the PSFs were charged.
Yes.
All right. And then if we go to NAB.005.788.0534 in the document on the right-hand side,
Sorry, which document?
it's in that hard copy that you've got there.
The big one?
Yes.
Yep.
If we go through, there's a PowerPoint presentation.
Yes.
You go to page 35, the PowerPoint presentation.
Yes, that we were on yesterday.
It's explained in the PowerPoint presentation, which is coming up. The trust deed allows the trustee to debit agreed advisor payments from a member's account as fund expenses, and as such, these should be approved by the trustee rather than fees or charges to be imposed unilaterally by MLC under the life policy.
Yes.
And then if we go to page .0565,
Yes.
you'll recall that the approval that was given was the proposed changes to advisor payments under the trust deed as detailed in section 7 of this paper. And this is section 7 of the paper.
Mm-hmm.
You can see that.
Yes.
And what you and the rest of the board approved was the trust deed allows the trustee to debit agreed advisor payments from a member's account as fund expenses, and then it sets out what those expenses are going to be.
Yes.
Given that this is what you approved in 2012, you surely had no doubt in 2016 that the amounts that had been charged were charged by the trustee from the trust.
So I'll just go back to the response I provided earlier, which was So the board's role is one of governance and oversight. Generally, I will not get involved in management process that leads to information coming into the boardroom. I might, at the point that management is bringing information to the board, I might be asked my opinion or view as to the trustee, does it cover what the trustee might want? But I'm not involved in process leading to recommendations or outputs to the board itself. Management were in process of working through information. I was absolutely actively agitating that this process was taking too long. I did understand at a very high level what they were debating. I hadn't been provided, and still haven't been provided or seen, the legal advice that led to the two different positions in Mr. Haggar's letter. So, while we made a decision in 2012 and the trustee had taken legal advice as to the validity of the payments and them being under the trustee, management were working through a process. I was agitating for that process to be faster and for them to come to the board with a final view of what the position was. And as I mentioned yesterday, while that process took too long, I trusted that there was enough independence in the process with the COO of the Office of the Trustee representing the trustee and independent external legal advice for the trustee view. And so I would say I didn't get involved in the process. I allowed the process for management to go through due process, and in the end, what management brought to the board was a remediation package to remediate members.
The management that you speak of is the management of the administrator, is that right?
Yes.
All right. And you're saying you thought it should have been done faster, is that right?
Yes.
But you trusted that because there were some other voices, the Chief Risk Officer and the Office of the Trustee, that they would be having some influence over the process.
Yes.
And that therefore you could trust management, notwithstanding that management was in this, what I'd suggest is a hopelessly conflicted position, where if they agree to full compensation, they will have to pay it.
Sorry, can you
Let me break
actually...
it down.
No,
You
if
agree-
you just go back to the be specific about the question.
You agree that management of the administrator is in a hopelessly conflicted position?
I believe that they are in a conflicted position. I do not believe it's hopelessly conflicted.
And that the conflict that they have is that if they agree to full remediation, the administrator will have to pay it.
Yes.
And you were satisfied that the way in which this conflict was handled was okay because of the voices of the Office of the Trustee and the Chief Risk Officer.
Well, the administrator also has a contract in place which sets out what they're entitled to receive fees for. And so, ultimately, you'd go back to what the contract says, what they're entitled to, and then the checks and balances that the trustee has in place to ensure that the right information is considered at the right time to determine the right outcome.
I tender that document on the left-hand side of the screen, Commissioner. Oh, actually, I've already tendered that with Mr. Carter, Commissioner.
And we discussed it yesterday.
Letter's gone in, has it already? Yes.
Can we bring up NAB.005.562.4413? So this is an extract from the board paper, or from the board papers of the meeting on the 26th of October 2016.
Yes?
Now, if we go over the page to .4422, we see what's being recorded here is that the directors noted and discussed a paper from Mr. Carter,
Yes?
and that there is a resolution to approve the characterisation of the PSF as a trust expense
Yes?
and the proposed remediation approach outlined in the paper,
Yes?
and that's the full remediation approach.
Yes?
Do you recall whether before this date there had been a delegation to directors of NULIS in relation to the compensation approach?
No, I don't.
All right. Can we bring up .4423?
Yeah, give it to her. It's too slow.
Yeah, there's another email where it says this is what we discussed yesterday. Now then, if you look at the bottom of that page, do you see, following the TERP breach, a compensation approach was recommended by management to MLC nominees for approval?
Yes?
Do you know what that compensation approach was?
I believe it was full remediation.
Do you think there'd already been a recommendation for full compensation before this
Or
date?
TERP.
For the TERP breach?
Yes.
Is that right? And it says this was approved by 2 director board delegates of NULIS.
Yes?
And do you recall who those board delegates would have
No,
been?
I could have been one of them, but no, I don't.
And then you see it says this approach is now being reconsidered to take into account the legal analysis that has since been finalised.
Yes?
Do you have a recollection of what the reconsideration was?
The matters we've been discussing this morning.
Sorry, I'm not sure I understand. Why would, if the approach was full compensation, why would it have been being reconsidered?
So I can only respond to say that the circumstances of TERP, SWIFT and Encompass, as I understand them, all relate to the same primary issue. And so while SWIFT and Encompass were being reviewed, I expect that TERP was part of that overall analysis.
So your recollection was full remediation had already been approved for TERP members?
I would have to go back and look at the specific remediation paper, but yes, I do.
All right. And so then if we go over to 4425,
Yes?
and this is where what's identified is the total value of PSFs charged for members who don't have a linked advisor.
Yes?
And we see it's $33.7 million at that time.
Yes?
And then there's an explanation of how the compensation will work and that it's to be full compensation.
Yes?
Do you recall that there was also a discussion at that meeting about the fees for no service report that ASIC was about to publish?
No,
You don't recall?
I don't recall.
You don't recall it having come up?
I recall discussing it, but I don't recall if it was at this meeting.
I see. Do you recall that this full amount of planned service fees remediation had not been included in the fees for no service report?
Yes, I did. I do recall that, but the point I knew that, whether it was before the ASIC report was released or after, I couldn't answer.
Do you recall whether you knew why it had not been included?
I believe we hadn't approved the remediation and advised ASIC formally of that amount.
Right, attend to that document, Commissioner.
Extract from board minutes of MLC nominees, NULIS PFS nominees, 26 October 16, NAB 00556244113_E, Exhibit 5.52.
Can we bring up NAB.153.001.3895? I'm told it may not be on the core book. If that's the case, then I'll just move to the next document. Can we bring up ASIC.0036.0001.3991? This is a letter dated the 12th of December 2016, and if we go over to the second page, we'll see it's again signed by you and Mr. Hagger.
Yes.
And is this a letter that you've reviewed in the course of preparing to give evidence today? You're not sure?
It's been lots of documents.
I understand.
But I have read it before because my signature's on the letter.
And you see about 2/3 of the way down the page, there's a paragraph 1.5. And in subparagraph A, it says that the reason the product changes were aimed at providing greater fee transparency, improved member control over the fees they paid, all the while not increasing the fees members paid.
Yes.
And the approach was to be more member-centric in intent than many of our competitors that elected to continue with commission-based legacy products.
Yes.
Now, I'm interested in understanding your view about that proposition. As far as you were concerned, the introduction of fees rather than to replace commissions was a significant change.
It was a change, yes.
It changed the rights of members because they didn't need to pay the fees unless the services were provided.
Yes.
And you would regard it as unreasonable to simply retain the fees even if the services weren't provided?
Yes.
All right. And then, and just to confirm one other thing, that's always been your view? That this is an unreasonable proposition to suggest that NAB should be able to retain the fees even if no service was provided?
I don't think NAB nor financial planners should be able to retain the fees if service is not provided.
Right. And then you see in 1.5b, the trustee board approval process for the product changes had regard to the intent that plan member services were maintained.
Yes.
Importantly, other services were available to members, including phone-based general advice and support, whether there was a linked advisor or not.
Yes.
And that's consistent with the point that you've already made, which is it made no difference whether you were linked or not, whether you had access to these telephone services.
Yes, they were cut. Yes.
And then if we go over the page to .3992, you'll see there's then an explanation of the approach to PSF remediation.
Yes.
And it said alternative interpretations of the nature of the PSF and therefore consequent alternative approaches to remediation were investigated.
Yes.
And that, as you understand it, is referring to this issue of the investment policy as compared with the fund expense alternative. Is
Yes.
that right? All right. And that was investigated, as I understand it, not by the trustee, but by the administrator.
Yes.
All right. I tender that document, Commissioner.
Letter Smith and Hagger of NAB to Kell of ASIC, dated 12 December 16, ASIC 0036 0001 3991, Exhibit 5.53.
Thank you. Now, there were some other issues that were going on in 2016, along with the PSFs for the trustee.
Do you mean the successor fund transfer?
There was the successor fund transfer, that was one issue. There was also an issue about advice service fees.
Yes.
And the issue about advice service fees was that NAB Wealth had discovered that there were advisors who were receiving advisor service fees even though they weren't providing services. Is that right?
There's a couple of different events referred to in my witness statement. All of them have permutations of essentially fees being deducted in some way where a service was not provided. So if you mean the first one, 406.
Well, let's just run through the types of events. One type of event is the event where the advisor service fee was being charged even though there was no advisor linked to the account.
Yes.
Another type of advisor service fee issue was where there was no evidence that the service was being provided.
I don't believe that any of the events that I've referred to in terms of the descriptions I've given for the causes of those, I've described any of them as saying there was not, okay, so yes, because where there's not an advisor and you're being charged an advisor service fee, you can't be being provided with a service.
All right. Well, you're, I think, on page 14 of your statement.
Yes.
And the events that you're referring to there are fourfold.
Yes.
The first event, which is event 471986,
Yes.
that concerned an issue where members continued to have ongoing advice service fees deducted from their accounts despite a request having been received to remove the allocated advisor from a member's account.
Yes.
And that was an issue first identified in the middle of 2014.
That's correct.
And do you recall when it was reported to APRA and ASIC?
At the end of 2014?
On the 22nd of December 2014?
Yes.
And then the second event was 262512, which was an issue where ASFs were deducted from member accounts and paid to both external and related party advice licensees where there was either an inactive advisor or an inactive dealer.
Correct. And
that issue was identified in August of 2015.
yes.
And do you recall when that was reported?
Both of that particular event was determined to be not a significant event, so it wasn't reported through the ordinary breach review committee process. And I believe that the first, or I should say the second part of that event relating to inactive dealerships was advised to ASIC via a letter.
In November of 2016.
Yes.
And then the third event was 406-30382, which you've described as concerned an issue relating to a control breakdown in the process of advisor remuneration.
Yes.
And that was an event whereby the advice service fees were retained by, I think, by the administrator, is that right?
That's correct.
Rather than being paid to the advice licensee for the relevant financial advisor.
Yes.
And that was an issue identified in May of 2017.
Yes.
And that was reported to ASIC when?
July 2017.
And then the fourth event was 519-21166.
Yes.
And that concerned an issue where advice service fees continued to be deducted from a member's account after NULIS or another RSE licensee had been advised that the member had died.
Yes.
And that was an issue identified when?
In May this year.
And when was it notified to ASIC?
May or June. I think it was June.
And that was identified, was it following some investigation after round 2 of the Royal Commission hearings to determine whether NULIS was deducting fees from people who had died?
Yes.
And can I suggest to you there's another issue that continues to be unresolved, which is going back and the wealth business doing a thorough review to determine whether services have been provided in exchange for advice service fees charged.
You might need to be a little bit more specific with your question.
Are you aware of an ongoing issue between ASIC and the wealth business in relation to reviewing whether services have been provided in exchange for the advice service fees deducted by the trustee?
Yes, it's referred to in my witness statement in respect of the advice licensees within the bank.
And we'll come to the detail of that in a moment. If we start just with the 4 events, are you made aware as the trustee of these events at about the time that they are discovered by the wealth business?
Yes, or shortly thereafter.
Shortly after they're discovered or shortly after they're notified as a breach?
Shortly after they're determined to be a reportable breach.
All right. And in the case of the event that wasn't determined to be a reportable breach, when was the trustee made aware of that?
I don't recall if they have been made aware of that. I became aware of it through the preparation of my witness statement.
And does that fact, which is that you became aware of it through the preparation of your witness statement, does that cause you any concern about the adequacy of the reporting to the trustee?
No.
Why not?
That particular event was deemed to be not significant and reportable. It was, I believe, at the point that scenario 1 was determined to be, scenario 2, I apologise, was around $300,000 in compensation to be paid. At the point that scenario 1 was determined to not be reportable, it was $8,000 in remediation. The trustee does receive regular oversight through risk reporting into the Risk and Audit Committee as well as into the board in respect of the management of events. There's been ongoing uplift in the in that oversight through the course of time, and there's still further uplift in respect of the types of information that the board is receiving in respect of events and the management of those.
Has the trustee been satisfied with the level of monitoring of whether services are provided in exchange for advisor service fees?
I think the trustee has done has turned its mind to, on multiple occasions, the control environment that exists for advisor service fees, and how and what that control environment is.
Has the trustee been satisfied with that control environment?
I think the through starting in 2015 through to 2017, the independent reviews requested by the trustee have highlighted a need for uplift in the control environment.
So just so I understand what you're saying, you're making the point the trustee has sought reviews of the control environment?
As it relates to advisor service fees, yes.
And based on those reviews, it considers that there needs to be changes made to the control environment?
Yes.
And that is because the trustee considers that the control environment is inadequate in relation to monitoring the provision of advice services in exchange for advisor service fees?
No. There are controls. There need to be more controls, and I wouldn't use the word inadequate.
All right. Now, one of the other things that was occurring in 2016 was the successor fund transfer,
Yes.
and that was something that you were very significantly involved in.
I think the entire board was significantly involved in the successor fund transfer.
I understand, but you were the chair of the board, and this was a very significant undertaking, and you had to shepherd it through.
The role of the chair is to ensure that the board has adequate information at the right time in order to arrive at decisions that are being asked of it. So ensuring that's my role at any point, including through the SFT.
And one of the issues that the board had to consider was whether it should continue to permit commissions to be grandfathered after the successor fund transfer was completed.
Yes, that's correct.
And it considered that at a meeting of the trustees on the 10th of June 2016. You don't remember off the top of my head. I'll
I'm
bring it
sure
up for
you're
you. It's
correct on the
NAB.
date. You've got the paper.
I'll bring it up. NAB.005.562.2915.
Sorry.
This has already been looked at, so it must already be an exhibit. The document ID that I have for it is NAB.005.562.2915. Should say it looks like it's listed as an extract, which is NAB.005.562.3035. Commissioner, is that a convenient time to take a break? So
Yes,
the
when do you
witness-
want me to come back, Mr Hodge?
In 15 minutes, Commissioner. We can make it 10 minutes, Commissioner.
Like your second bid more than your first, Mr Hodge, 20 past 11.
Thank you.
Yes, Mr Hodge.
Commissioner, we were looking at an extract from NAB.005.562.2915,
Yes.
and we're trying to go to agenda item 4, which is NAB.005.562.2934. All right. And we can see, Ms Smith, that what happened at the board meeting on 10 June 2016 was that the directors of NULIS resolved to approve to maintain the current grandfathered commission arrangements pertaining to the products.
Oh, sorry, I've been given the wrong paper, but yes. Yes.
I'm sorry, you'll have to use the screen while your solicitors look for a hard copy.
I'll just use the screen.
Do you recall, Ms Smith, the discussion about this issue?
Yes.
Was it the case that the trustee had a preference for not paying commissions anymore?
At this time, the trustee hadn't turned its mind to, from a strategic sense, whether or not it, prior to this was the first major deliberation in respect of grandfathering for the trustee.
The trustee, though, back in 2012, had made this significant change to the Master Key Business Super and Master Key Personal Super by removing commissions and changing to fees.
Yes.
And presumably it did that because it took the view that it was better for members to have fees, explicit fees, rather than commissions.
So, sorry, I'll rephrase my answer, which is to say this is the first time since FOFA was introduced, including the grandfathering of commissions, that the trustee had considered in any material way whether or not to grandfather commissions.
Right. Well, it just let it happen, is that right? That is, it just let commissions keep being paid after FOFA came into effect.
No, the legislation regarding fee for service led to a provision of grandfathering commission. So from a product perspective,
Yes.
that was what occurred at the time.
I want to try to understand this. It's the case, isn't it, that if the trustee wanted to alter the remuneration schedule for advisors to remove commissions, that it could do so?
I can't blanket answer yes to that.
Well, you know that in 2012, one of the things that you did in relation to the Master Key Business Super and Master Key Personal Super was to change those products by removing commissions and putting in fees. That's right?
Yes.
So that is something that it was always open to the trustee to do?
It was for that product at that time, yes.
Did you consider whether it was open to do it for other products?
This was the first time in respect of when we did the successor fund transfer that we considered it in any material way.
I see. I just want to work through what the possibilities are of when the trustee might deal with this. So the second possibility is what you are talking about, which is if a successor fund transfer happened and the old fund had products which had commissions, then the new trustee would have to consider whether or not it should permit those commissions to keep being paid.
Yes.
And another possibility is a product trade-up.
Yes.
And what happens with a product trade-up is that a member is in one product within the fund, and the trustee can decide to trade up the member to a different product.
Yes.
And it might trade up the member to a product that doesn't have commissions,
Yes.
and then commissions would cease.
Yes.
And NULIS has, over the course of the last 2 years, been presented with opportunities to consider that possibility
Yes.
and to consider whether it should trade up members from a commission-paying product into a non-commission paying product.
Yes.
And it's done that in the case of ex Aviva members.
Yes.
And in the case of ex Aviva members, there wasn't a very substantial amount of trail commission being paid by them.
I wouldn't know the amount off the top of my head of what trail commission was being paid. I think for the ex Aviva members was more specific that there were not a lot of, there were more members who didn't have an advisor linked to their account than did. So for the, was looking at the entirety of the membership.
And when they were traded up into a non-commission paying product.
Yes.
In relation to the 5 Stars product,
Yes.
do you recall what happened in relation to members who are in the 5 Stars product?
We haven't traded that product up at this point.
And the 5 Stars product is regarded as a legacy product.
Yes.
It's a very high fee paying product.
Yes.
And at various times, the issue has been raised with the trustee as to whether it should trade up those members.
So the trustees had a program of looking to move its legacy old business, off-sale business, into on-sale products for quite a long time now, and it has had an active program of closing down old products and moving them to on-sale products, and 5 Star Gold Star is the last of those products to be traded up.
But the question of whether, if we just focus for a moment on 5 Star, the question of whether the 5 Star product should be traded up is something that has been bounced up to the board on a few occasions.
So it's been part of a planned strategy for trade up. What happens, so moving members from one product to another is both legally quite complex, but also operationally very complex. So we have a practice of having a workshop at the board, understanding all of the nuances of the rights of members in the old product, how we might deal with them in the new product, before we actually get into decision-making mode in the boardroom of the trade-up program itself. So I believe the first workshop we had in respect of 5 Star Gold Star was about 4 or 5 months after the SFT program, and then we've considered it on 1 or 2 occasions since then.
And at this time, when are the 5 Star products scheduled to be traded up? When are they scheduled to be traded up?
Within the next 18 months, I believe, is the date.
I see. So the board has decided to trade up that product?
It has a plan to trade up that product. We haven't made the decision to actually trade it up, but we have a plan to do so.
I see. Is the issue with trading it up that you need to consider what's going to happen in relation to advisor remuneration?
Yes, and at a high level we have considered that.
And is that the most significant issue for the question of whether to trade up the 5 Star product? What's going to happen to advisor remuneration?
No, the 5 Star, it's a series of products, and when we say it's 5 Star Gold Star, there's actually many permutations of product design underneath what is labelled as 5-star, and lots of different rights that members have as a result of entering into the product when they first became a member. And so there's a lot of complexity in understanding and making sure that we don't diminish members' rights as part of that product trade-up program.
And how, in the case of the members in the 5-star product, would it be possible that their rights would be diminished by the trade-up?
If we take away a right that a member had at the point of entering into the product and don't ensure that there's equivalency in respect of that right.
And what sort of right would it be in the case of 5-star?
It's a right that exists under the trust deed.
I'm sorry. What specific right? Or you're not sure?
So part of the analysis that we go through for the, leading into the to the actual decision is to obtain a legal review over all of the permutations of the product design to enable the board to turn its mind to maintaining equivalency of rights.
We might come back, or we will come back to that. That, I think, has reached its most recent consideration at a workshop in about the end of 2017. Is that right?
As I said, we've had two specific discussions on 5-star, Gold Star since the FOFA considerations for the SFT.
Can we look then at this particular document, which you believe is the first consideration of grandfathering commissions after FOFA came in? And is it fair to say there were two legal issues that confronted the trustee? The first was whether the grandfathering commissions even permitted commissions to stay on foot?
I might, if, yes.
And the second issue was whether or not it was in the best interests of members to keep commissions on foot?
Yes.
And management came to you and said it's lawful under the grandfathering provisions of FOFA to keep commissions on foot?
Yes.
And did you understand they said this on the basis of the idea that the trustee was providing a platform?
So during the consideration of the legality to maintain commissions or to continue to grandfather commissions, external legal advice and QC opinion was sought in respect of...
Just a moment, Mr Hodge. Sit down.
In respect of that matter. And I believe that was one of the matters contained in what was quite complex and lengthy legal review.
I understand. There was a legal issue which was, is it even possible to say...
Can we grandfather?
That we can grandfather.
Yes.
And the trustee had to rely upon whatever advice was provided to it about that question.
Well, the trustee sought legal advice and turned its mind to whether or not, based on that advice, that it was open for the trustee to be able to grandfather. Yes,
what I'm getting at is the trustee isn't going to, I assume, go behind the advice and second guess whether it's actually lawful or not to grandfather commissions.
I think that the trustee was seeking the advice to determine that it was lawful.
Yes. And then the second issue is the question of whether it's in the best interests of the members to maintain commissions.
Yes.
And that is squarely a question for the trustee to decide.
Yes.
And management said, we think it's in the best interests of members.
I assume that's probably in the paper, yes.
And management offered a rationale for why it was in the best interests of members?
Yes.
And what was your understanding of that rationale?
I'd have to go and see exactly the words that they said on the, in respect of the paper.
Well, what I want to understand is, what did you understand to be the rationale for why it was in the best interests of members to grandfather commissions?
Essentially, so I might step back a little bit. In terms of what the trustee does in making a determination about best interests, the trustee ensures that there's an appropriate process over the decision that factors into account, takes into account all relevant factors and, requires due consideration. So that's how the trustee goes about determining best interests. In respect of the FOFA matter, the trustee was considering best interests as a concept for the successor fund transfer as a whole. The FOFA matter was maintaining equivalency of rights, so we didn't actually put people in a better position. We put people in an equivalent position, which is required under successor fund transfer requirements. The trustee, in my mind, turned their mind to best interests of the SFT as a whole and determined that the SFT, including the grandfathering of commission, was in the best interests of members.
Now let's take that in parts. Is it your understanding that if the consequence of an SFT was that the member would be in a better position, that the SFT can't go through?
Sorry, I don't...
You said it's required that the member be in the same position.
No. So, successor fund transfer, and I won't quote the specifics of the piece of legislation that requires us to be able to move a member from one fund to another without that member's position, is a series of obligations that we kind of term as successor fund transfer requirements. So we're moving a member from one fund to another, and the trustee is doing that unilaterally and making that decision.
Two trustees are doing that.
Yes. There's a transferring trustee and a receiving trustee.
Yes.
As the trustee is doing that, the trustee has legal obligations to ensure that there are equivalent rights in respect of from the old fund to the new fund. And so the trustee was considering the successor fund transfer in that context and ensuring that equivalent rights were provided from the fund that they left and the fund that they went to. And the trustee determined that the successor fund transfer was in the best interests of members.
Now, I don't know why you're doing this, but there are two separate issues, aren't there? One is the successor fund transfer in the best interests of members? A separate issue is whether maintaining the current grandfathered commission arrangements is in the best interests of members. Those are separate issues, aren't they? My view would be that the successor fund transfer is considered as the best interest classification, and then there could be in the ordinary course of any successor fund transfer changes to benefits and options and those sorts of things. There could be changes to fees. In this instance, there weren't, because we were matching from one fund to another, equivalency of all rights, in order to move the superannuation business out of the life company and into a trust structure. Ms. Smith, look at the resolution. The resolution is a resolution of the directors of NULIS to approve to maintain the current grandfathered commission arrangements pertaining to the products which form part of the TUS following the proposed SFT to the MLC Super Fund.
So there were many decisions that the trustee had to make in order to give effect to the SFT. Because of the size of that program of work and the complexity of some of the decisions in order to replicate rights from the life policy into the trust environment, they occurred over multiple meetings and multiple decisions were made. Each of them viewed with maintaining equivalent rights as members moved out of the life policy and into the trust environment.
Do you regard the payment of commission as a right of the member?
I'd say it's a feature of the product.
Well, you've explained to us that there needs to be equivalency of rights.
Yes.
The entire point, can I suggest, of a commission, as you and I have agreed many times already, is that the advisor gets the commission regardless of whether they provide the service. Agreed?
Yes.
The member doesn't have a right to require the provision of the service.
The member has a right to... yes, correct.
No, please, go on.
No,
What is it
it's
that the
okay.
member has a right to do?
No, I agree with the comment.
And I'm trying to understand then this idea that somehow the equivalency of rights under an SFT for the members is a justification for maintaining grandfathered commissions. Is there some further explanation that you can offer for that?
I'd make one final comment, which was the SFT came about as a result of the NAB selling the life business. There were different ways that that could occur, and the trustee agreed and believed that it was in the best interests of members for us to successor fund transfer all of the funds out of the life policy and remove a layer of intermediation that existed between the trustee and its members that would enable the trustee and provide an operating platform for the trustee to continue its simplification program and its trade-up program.
Again, so that I can understand this. Is it the case that the directors of NULIS were satisfied that it was in the best interests of members to maintain grandfathered commission arrangements?
In the context of the SFT, and yes, it was.
And when you say in the context of the SFT, what does that mean?
Well, at the time that we agreed to the grandfathering, the trustee had turned its mind to grandfather commission and had asked for and kind of put in motion a requirement to consider grandfathering and how long it should continue for as part of the products offered by the trustee. That resulted in a series of conversations which led up to a strategy put forward to the board at the end of last year, which was to move our commission-paying products to non-commission-paying products as part of the final trade-up program that we will execute through 5-Star and Gold Star.
When you came to make this decision that we are looking at on the 10th of June 2016 to approve maintaining grandfathered commission arrangements, what was the basis, you say, upon which you concluded that it was in the best interests of members to do so? That
we were not putting members, we were putting members in the same position that they had been prior to the SFT, and that the SFT was in the best interests of members.
All right, so that seems to involve two propositions. The first is that members weren't any worse off as a result of grandfathered commissions being maintained because they were already paying grandfathered commissions.
They were in the same position.
They were already paying commissions and they'd keep paying commissions.
Yes.
Now, on that point, there were two alternatives available to you. One was to stop paying commissions and one was to keep paying commissions. Is that right?
Potentially.
Do you agree that for a member, if a member is not paying a commission, the member is in a better position than if the member is paying a commission?
Ultimately, I'd say the less fees a member pays, the better their retirement outcome will be.
So we agree, if the member is not paying a commission, the member is in a better position than if the member is paying a commission.
Yes.
So the first point, can I suggest, can't have led you to the conclusion that it was in the best interest of members to maintain grandfathering.
So I think I don't want to get into a legal argument.
This isn't a
but
legal
no,
argument.
no,
You made a decision.
Best interests is not about the best position. I've tried to explain that in the context of the SFT and the decision to grandfather, there were a whole range of decisions that the trustee was making in respect of rights and product features, and ensuring equivalency of those from the old fund to the new fund. It was in the context of the SFT being in the best interests of members that a decision was made to grandfather commissions.
Well, that's the second point that you raised, that in the context of the SFT, it was in the best interests of members.
Yes.
And that seems to carry with it the idea that if you didn't grandfather commissions, the SFT would not go through.
I think in the time frame we had to complete the SFT, that is a potential risk that would have occurred.
And is that something that is recorded and explained in this management paper, do you know?
I believe it's one of the items that's called out, yes.
I see. So an issue is that you might have to delay the SFT. Is that right?
Well, I think that the group would have sought to make the sale of the life company in a different way, which could have been through I might get the language wrong, but Part 9A transfer, which would have meant that the trustee would have, that the superannuation business would have still been invested through a life policy. And so it could have, but there could have been other ways for the bank to succeed with the sale of the life business.
So just again, so that we understand it, the two things in your mind that were relevant to this decision were first, equivalency of rights. Is that right?
Yes.
And as we've agreed, there are no rights that a member has as a consequence of commission.
So rights are a legal test, and whether or not the commission is a legal test requirement, I don't know. But essentially, we were looking to replicate all benefits and all rights from one fund to another as a result of the SFT.
Surely you can't be saying to the Commissioner that you as a trustee believed that maintaining commission was maintaining a right or benefit of the member.
No, I'm saying to you that when the trustee considered to grandfather commission, it believed, it did so believing that the successor fund transfer was in the best interests of members.
Now, if we go to page .2938,
Just give the witness the hard copy, please.
so 2938, Ms. Smith,
Yes?
you see implications for the SFT date and associated future member benefits.
Yes?
And the first sentence is, a decision to approve the continued payment of grandfathered commissions to advice licensees would not impact the ability for the current SFT date to proceed as intended.
Yes?
So is that the point that you're making, that so long as you agreed to grandfather commissions, it wouldn't have any effect on the SFT date?
Yes.
And then the second option that we can see considered halfway down the page is cease the payment of grandfathered commissions by terminating the remuneration arrangements with advice licensees.
Yes.
Now, I just want to understand this. NULIS doesn't actually have any legal obligation to pay commissions at the time this is considered, is that right?
No, that would be, I think that is correct.
So this isn't NULIS terminating the remuneration arrangements, this is some other trustee terminating the remuneration arrangements.
It would be, it would have been MLC nominees and PFS nominees didn't pay commission, so MLC nominees.
And then you see, if we can blow up under option 2, member impact.
Yes.
So the principal issue that seems to be identified by management with ceasing grandfathered commissions is that there would be what it describes as a significant impact to member attrition, which it says is considered possible.
Yes.
Is that a view that you share?
I think it's a potential impact.
All right. Did you turn your mind to how likely it was that this would occur?
Yes.
And how likely did you think it was?
Likely.
And you thought it was likely that if you turned off commissions, financial advisors would advise their clients to leave the relevant MLC super fund, is that right?
Yes.
And did you ask how many of the relevant members were actually receiving active advice?
So the contents of this paper were heavily debated in the boardroom in the context of the decision to grandfather or not, including the nature of who was paying, what they were paying, and so at the time, in fact, the trustee was asking for what are the alternatives and what are the risks associated with those alternatives as part of the decision-making process in order for it to arrive at an ultimate decision and whether that was the right decision.
Is that, do you mean at the board meeting where this paper was considered?
So leading into the boardroom, we knew we would be considering FOFA grandfathering, and through the Office of the Trustee, the board had asked for all of the considerations and alternatives to grandfathering to be put to the board together with the risks associated with those alternatives. And so that's the point of this paper, is for the trustee to understand not only yes or no should it grandfather, but what are the alternatives and what are the risks associated with the alternatives. So when I mentioned before that part of the trustee's best interest considerations are about the process it goes through, considering relevant factors in order to arrive at a decision, that's what this paper is endeavouring to do for the trustee.
The Board of Directors has made the inquiries of the management and this paper is the response.
Yes.
And does this paper say how many members are receiving active advice?
It doesn't.
Wouldn't that be an immediate relevant issue to considering how serious the possibility of attrition is?
I believe it was one of the factors that the board has discussed and so would have come into the boardroom as part of the discussion.
So you think you asked for it beforehand, it doesn't feature in the paper, but when you're in the boardroom, somebody told you?
What the board asked for was alternatives and for the risks of those alternatives to be brought forward to the board.
But that's what's been done in this paper, isn't it?
Yeah, correct.
And the paper doesn't tell you how many members are receiving active advice.
No, but I do know that we did have a discussion in respect of the nature of who was paying what and what it looked like.
Do you recall how many members, what proportion of the member base was actually receiving active advice?
For commission, I no. Are you talking commission versus advisor service fees?
Well, that's what this is about, isn't it? It's about turning off commission.
Yes.
So of the members paying commission, how many of them were receiving active advice?
Don't know.
Was that something that was told to the board?
No.
And then it said that this attrition will be due to consequent financial advisor dissatisfaction. And so I just want to understand the board's view of the mechanism of this. Why does the board think that financial advisors are going to advise their clients to leave the MLC super fund if commissions get turned off?
Probably history of experience of moving to an advisor service fee model before the industry did, and the impact that had on the sale of MLC products in the market at the time.
Well, that was moving early before before FOFA came into effect.
And so the rest of the industry at this point have grandfathered commissions, and no one in the industry has made a determination to turn them off.
But you see, the problem is this. By 2016, if a financial advisor advises their member to move to a different product, a product offered by AMP, for
Yes.
example, you know that the financial advisor can't receive a commission.
Correct.
So they're not going to move to a different product because they can receive commission in a different product. Do you agree?
Yes, but there's a broader impact than just that.
And what is the broader impact?
It's the ongoing support of the MLC business by advisors. So we're focusing on one point, and I understand your point, but I'd go to, this was a process, a view of a process that the trustee was trying to understand the risks associated with the decisions put in front of it. It was done so ensuring that equivalent rights were maintained and members were put in the same position on day one to day two, believing that the SFT was in the best interests of members. It was also done with a view that the trustee believed it needed to turn its mind to a strategy around the continuing and ongoing grandfathering of commissions, which I believe we have done.
When I asked my question before, which is what is the broader impact, your response was it's the ongoing support of the MLC business by advisors.
Yes.
Can you explain to the Commissioner what you mean by that?
In answer to the specific question you were asking me at the time,
I mean, yes, that's right.
what I meant by that is, of course, when an advisor moves a member to another product, being AMP, they no longer receive the commission, but also it would be an active view of moving or not putting members into MLC.
Now, financial advisors also owe a duty to the members to act in the members' best interests.
Yes.
So what I'm trying to understand is, was the thinking of the trustee that, consistent with that best interest duty, the financial advisor would move a member from MLC unless they were receiving commission?
I think we were thinking that there was a potential for attrition risk as a result of making a decision without a plan for how we would implement that decision to remove grandfathered commission.
And is that because you didn't expect advisors to act in the best interests of their members, you expected them to respond unfavourably if they lost the revenue stream of commission?
I'm not going to comment on whether when and how an advisor acts in the best interests of in giving advice. But I think we thought that the risks called out under option 2 were real, and that in the context of the timing of the SFT, it was appropriate to grandfather commission.
When you say you're not going to comment on whether the financial advisor was going to act in the best interests of the member, if you just look through these points, you see the first point is that due to high levels of member attrition, a significant reduction in funds under management would arise.
Yes.
And the second point is then that the remaining members would likely incur increased fees and costs, since MLC would have its fixed expenses that it needs to spread over a smaller member base.
Yes.
And then the third point is any increase in member fees would reduce the competitiveness of each product within the market, which would negatively impact the ability of financial advisors to fulfil their best interest duties in recommending the trustees' products when compared to similar market options. Can I suggest, in light of that, you must have been thinking about how the best interest obligation of a financial advisor?
I was not thinking about the best interest obligation of a financial advisor.
I understand. And was that because the proposition from your point of view was quite simple? You expected that if you cut off this revenue stream from financial advisors where they weren't obliged to provide a service, that they would move their clients to a different fund?
It was a risk that we considered had potential to be real.
It was a risk that had the potential to be
I
real.
know that was poorly worded, I apologise. I think it was a risk that we considered. So there were 3 options put to the trustee. Each of those had some advantages and disadvantages, and on balance, the trustee believed that the grandfathering of commission at this point in time and the SFT was in the best interests of members.
What I'm struggling to understand is, do we agree that if you grandfather commissions, there is a 100% chance that the relevant members will keep paying commission without any right to service?
Yes.
So there is a 100% chance of that, which must be to the disadvantage of members compared to not being in that situation, and some chance, not articulated in any real way, that financial advisors will decide to move their members away if their revenue stream is cut off. Was that the balancing that was going on?
No.
And anywhere in this paper, does it explain what the effects will be on the MLC wealth business if commissions are shut off?
No.
But you knew that one of the beneficiaries of grandfathering commissions was the MLC wealth business.
Related party financial planning businesses, including NAB financial planning, yes.
And the people authoring this paper are from the MLC wealth business.
They are from the MLC wealth business, yes.
And then if we go over the page, so we've seen one potential detriment of ceasing grandfathered commissions is said to be membered impact. And then the second one's over the page under other impacts is, first, if the trustee was to contemplate terminating commission payments, separate legal advice would need to be obtained to determine whether commission payments could be terminated without exposing MLC nominees or NULIS or any other entity of the NAB group to liability for breach of contract.
Yes.
Was that an issue that was relevant to the trustee's decision?
So I can only go to my comment before, that this paper and all of the options in the paper were part of the trustee's decision-making process regarding what it should do and the benefits and the risks associated with any decision. So that is in the paper, and it would have been part of the board's deliberations and considerations at the time.
All right, you don't have any specific recollection of the consideration of that issue?
No, but I do have a recollection of the heavy debate that this had in the boardroom about being in the interests of members, and that this wasn't where it stopped for the trustee. While this was a point in time as we did the SFT, it was with a view that we would go on to have strategic discussions around our view of grandfathering of commission. And as I mentioned to you, that's resulted in a strategy to be implemented to move our members in off-sale products, which are commission-based products, into on-sale non-commission paying products.
That was a strategy that was ultimately arrived at the end of last year?
Yes.
And that was a strategy that over the course of 3 years, you will move them out of commissions?
Over the next, I don't believe it's 3 years, but yes. Yes, you're right. It is a 3-year strategy for the entirety. I was thinking about 5-star, Gold Star in my response.
And that is because the reason underlying that strategy is that you recognise that it is not in the best interests of members to be paying commission.
That we think it is in the best interests of members to be in our on-sale modern products that are maintained and have lower fee arrangements all over, better features, better options, an array of reasons.
You recognise, don't you, that it is not in the best interests of members to be paying commissions?
I think it is in the interests of members to be in our on-sale products that have an array of features that are different to the off-sale commission-paying products.
You recognise, don't you, that it is not in the best interests of members to be paying commissions?
I think it is in the best interests of members to have fees that are as low as they can possibly be, and that the member has control over the fees and the services and the features that they are paying for.
You recognise...
And so, if that means that that would be inclusive of it is in the best interests of members to be in products that do not pay commission versus products that do pay commission.
Thank you. Now then, the other point that is made under the heading Other Impacts is, in addition, the program of work that will be required to remove commission arrangements attached to member accounts would be both costly and time-consuming and would cause delays to the SFT and subsequent plans to trade up legacy products. You see that?
Yes.
Was there any explanation given to you as to what that program of work would be?
I don't recall if we had a conversation at the time, but I could give you my view.
And what would it be?
That the products that pay commission arose at, for anything from over the last 15 to 20 years that those products actually were put in place. And so the contractual requirements, the nature of the commission would vary from product to product and would require us to have an understanding of how and when we can change those commission terms and enable us to have a strategy to engage with members and advisors around the program of turning them off. It's not as simple as just one product, same features, flick a switch and turn it off.
Presumably, it's possible within the systems being operated by NULIS and MLC to put commissions down to zero.
Yes.
So when you say there's a program of work, this particular consideration is just about whether you will just put commissions down to zero.
So this particular consideration was not that at all. I think how we go about turning commission off is now subject to a strategy, a consideration by the board at an upcoming strategy workshop in. If it hasn't happened this week, it's I believe was due for August.
And the strategy is around managing engagement with financial advisors.
That would be one element of it. I don't know everything in it. I was trying to enunciate that I felt it was not necessarily as simple as it sounds as turning it to zero, that it requires consideration of the contractual requirements in place, what they are, how much, whether we, do we need to give notice in what products, and what that looks like.
And it's said that it would cause delays to the SFT if this was to occur.
Yes.
Do you recall what sort of delay was involved?
No, I don't. But we considered that was a fair and real proposition that was put forward by management. And if you consider that I'll stop there.
What I'm trying to understand is in this balancing exercise, you have a situation where if you turn off commissions, there is a 100% chance that the members will be financially better off as a result of not paying commissions. And you choose not to do that for reasons that presumably do have an effect on the members. For example, it might delay the SFT and that might cause some financial impact to them, effect on them. I'm just trying to understand how you balance the certainty of the detriment of commissions against these other uncertainties.
So I'll just go back to the point I was trying to make regarding the successor fund transfer program, which was to match the equivalency of from one fund to another and move the superannuation business out of the life policy. That was considered to be in the best interests of members to do that. In order to do that, in the time frame that we had and deliver to the successor fund transfer, that meant we had made a decision, it could be 18 months earlier, that we would look to have no change in any features or any elements of offers made to members. We would be matching equivalency from the 30th of June to the 1st of July as the SFT was executed. So at this point, the trustee was not trying to turn its mind to the bigger picture that it's later turned its mind to around the ongoing grandfathering of commission.
I want to move to another topic. I'm sorry, Commissioner, did you have any further questions about that issue?
None that I will ask, Mr Hodge.
Thank you, Commissioner. I want to ask some questions about My Super.
Yes.
In 2013, two of the trustees were developing My Super products.
Yes.
One was MLC nominees, the other was PFS.
Yes.
PFS had a Plum My Super product.
Yes.
MLC nominees had, I think, two My Super products. One was the MLC Super product, the other was the NAB staff product.
Was,
Or was NAB staff in
NAB
PFS?
was PFS.
Thank you. And it, as part of that process, developed a product but also a transition plan for ADAs.
Yes.
And ADAs are accrued default amounts,
Correct.
and they are amounts that have been contributed by a member pursuant to the default contribution from the, or contributed for a member pursuant to the default contribution by their employer.
Yes.
And do you recall for the ADA transition plan that MLC put in place and PSF put in place, how quickly it was intended that the ADAs would move over into the MySuper product?
It was, I'm sure you're going to tell me, but it was, I'd say, a 2-year transition. It could have been shorter, it could have been longer.
Well, the obligation was to complete all transitioning by the 30th of June 2017.
Okay.
Do you recall that?
Oh, I know there was an obligation, yes.
Do you recall discussion about the MLC transition plan?
Yes, it was a documented transition plan developed and put forward to the trustee for approval.
Yes, but do you recall board discussion about the transition plan?
There would have been.
Do you recall any issues being raised about the transition plan?
Not specifically, but I'm sure that there was discussion around elements of the transition plan, including making sure there was equity for members and those sorts of things as assets transitioned. There were large movements of assets, making sure that as we that fees and assets matched the movement. That fees matched the movement of assets, and so members were paying appropriate fees for the assets they were actually invested in as they were transitioned from higher asset growth defaults to lower asset growth defaults, those sorts of things.
Now, one of the features of the MySuper product is that it's a no commission product,
Yes,
and it's also supposed to be a simpler product. There's not a range of options, you're just
Yes.
in one option.
yes.
And in the case of MLC, do you recall what the defensive to growth split was for the MLC MySuper product?
The old or the new?
Did it change at some point in time?
Yes, so the ADA transition resulted from, I think, across the two trustees, about 40 different defaults going to the one. So
Into MySuper?
into MySuper.
Yes, but the MySuper split, do you recall
Oh,
what that was?
it's a 70-30.
Yes. And one of the things I'm trying to understand, and we might bring up a document which is NAB.005.562.4470.
We have the number again, Mr Hodge, we're not
Yes.
succeeding.
It's NAB.005.562.4470. While we see if we can find that, can we try a different document, which is NAB.005.561.4232? Thank you. So this is a meeting from December of 2013. You can see it's a meeting of the combined MLC nominees, NULIS and PFS nominees board.
Yes.
And if we go over to page .4234, you'll see this is a paper about the transition from ADAs to MySuper.
Yes.
And then if we go over to page 5 of 14, which is .4236, and you'll see this is setting out the transition from ADAs over into MySuper products.
Yes.
And I think actually if we can probably see this more clearly if we go to .4244, which has some projected cash flow statistics. Now you'll see this is setting out the cash flows into MLC MySuper, and what's being planned in 2013 is that there will be a 5% transfer of ADAs per quarter for 2014, 2015, and then gradual transition of the remaining ADAs in 2016.
Yes.
And I'm interested in understanding whether the board considered, so far as you can recall, whether that was too slow.
We did have discussions around timing and how quickly we could give effect to the ADA transfer. And based on the information and the complexity of the merging of multiple different defaults, as well as the change to asset allocation and the resulting movement of the resulting change in underlying assets that was required to bring about, that this was determined to be a safe, appropriate within the requirements of the required ADA transition timeframe, and would deliver a very big asset transition very safely, and ensure that no errors or issues arose as a result of the transition of ADAs.
Now, one of the consequences of that, or the speed with which the transition occurs, can I suggest, is that more members remain for longer in a higher fee-paying ADA before moving over into the MySuper product.
So that would have been for the MKBS PS members,
Yes.
paying plan service fees.
Yes, those members would have had higher fee-paying.
Yes.
But they also have higher administration fees, don't they?
They have different administration fees, yes.
They're higher, aren't they? The administration fees for MKBS and MKPS are higher than the administration fees for MySuper.
Yes, I believe they are.
And as you say, they would have been paying, or would have been paying PSFs,
Yes.
and that would be to the disadvantage of their members.
Well, not if they're receiving a valuable service for the PSF, which I believe the trustee would have thought that was the case.
And they could be paying contribution fees.
They could have been paying contribution fees.
And was this something that the board balanced in some way to consider what disadvantages there might be to members who remained in the ADAs?
Yes, it was part of the discussion and deliberation around what's the right balance between safely delivering within the required timeframe and the fact that members would benefit by paying lower fees in the new MySuper option.
Do you recall whether the board considered back in 2013 what the effect on the scale of the MySuper product would be by waiting until 2016 to transfer the majority of members over into MySuper?
I don't recall us having a conversation about that specifically.
Each year, the board is required to make a MySuper scale determination assessment,
Yes.
and it has to determine that members in the MySuper product in the, for example, MLC Super Fund are not disadvantaged in respect of scale when compared to members who hold a MySuper interest in other funds.
Yes.
And do you recall whether the board considered the potential problem of this, what I'll suggest is a slowness of transitioning ADAs over into a MySuper product in considering that MySuper scale assessment?
No.
You don't recall it having been thought
No.
about? All right. Was it your understanding that it was the common practice within the retail funds to be taking much longer to transition ADAs over into MySuper products when compared with the industry funds?
Not at the time. The plan and the decision around how we would manage the transition was approved, but I am aware of subsequent criticism of retail funds and how the length of time taken to transition.
So you're aware of subsequent
Criticism.
issues that have been raised and criticisms?
Yes.
And do you have a view about the merits of those criticisms?
I think generalising, it's a generalisation would be my first comment.
Sorry, a generalisation that
of
the
the
retail
criticism.
funds have done?
Yeah,
done
of the
this?
criticism. So there are two facts that I think are important. The first one is for most industry funds, they actually had one default, which meant they didn't have any, ADAs to transition in the context of the trustees of MLC noms and PFS noms. So it was a much easier process. So that's a generalisation in itself from my perspective. But the trustee did turn its mind to how safely could we consolidate the complexity of our default arrangements that had been built up over many years of employers designing a default from both an investment and an insurance perspective, and how quickly we could move from that and change asset allocation and move to what was designed to be the MySuper option. And in the balance of things, I think that the trustee was looking to make sure that we did so in a timely fashion within the required timeframe given to us, in a way that we did not cause any issues or errors or events in what was a complex asset transition process.
Have we now got, I'm sorry, attend to that document, Commissioner.
Exhibit 5.54, NAB Wealth Board Papers 4 and 5, December 13, NAB 005 561 4232, Exhibit 5.54.
Thank you, Commissioner. Have we now got NAB.005.562.4470? Commissioner, can I suggest we adjourn for lunch now and come back in an hour?
1:30?
Thank you, Commissioner.
Yes. 1:30.
The commission is now adjourned until 1:30 this afternoon. Please be seated.
Yes, Mr Hodge.
Thank you, Commissioner. Could we bring up NAB.005.562.4470? So, Ms Smith, this is an extract from the records of the papers of the board meeting of the trustees on the 26th of October 2016.
Yes.
And you can see it's one of the board's annual My Super Scale Determination Assessments.
Yes.
And what that refers to is that each year the board of the trustee is required to resolve that it is the members of the My Super product are not disadvantaged by virtue of the size of the product.
Yes.
All right. And then can we go over to page .4472? So we see this is the second page of the two-page paper prepared by management for the My Super scale determination.
Yes.
And you see there's a heading which is conclusion. And you can see that what is said there by management is, having completed the scale test as summarised in the appendices, management does not believe members in the respective My Super options are at a disadvantage relative to members of My Super products in other superannuation funds as a result of scale, particularly when the qualitative features and aggregate administration and investment fees and costs are considered.
Yes.
And this is consistent with what would happen each year, which is that management would express a view to the board as to whether or not the members were disadvantaged in terms of scale.
Yes. Yes.
And then the board would need to rely upon the information presented by management in order to reach a resolution as to whether it accepted or resolved that the members were not disadvantaged in terms of scale.
Yes.
And I think I asked a form of this question before lunch, but in doing that each year, do you recall whether there was consideration given to what would happen if NAB or MLC or the trustees had moved more quickly to transfer ADAs over into the My Super product?
No.
You don't recall a discussion along those lines? All right. And then can we go to the next page, which is 117/249 at the bottom? So we see this is an appendix provided to the board which sets out calculations across the superannuation industry in relation to My Super.
Yes.
And it shows the total value of accrued default assets.
Yes.
And it shows what's been happening, what's changed with respect to accrued default assets over the preceding 3 years.
Yes.
And you can see that as at 30 June 2014, the total accrued default amounts across the entire superannuation industry were worth about $73.1 billion,
Yes.
of which MLC held $17 billion.
Yes.
And the next year, the value of ADAs across the entire superannuation industry had fallen to $59.2 billion.
Yes.
And the value of MLC ADA funds had only fallen to $16.1 billion.
Yes.
And by 30 June 2016, the value of total ADAs across the industry had fallen to $41.3 billion.
Yes.
And the value of MLC ADAs had now only fallen a small amount again to $13.9 billion,
Yes.
with the consequence that by 30 June 2016, MLC Super Fund had more than a third of the ADAs across the entire superannuation industry.
Yes.
And did that seem striking to you?
I don't recall thinking at the time it was striking. The ADA transition was being executed in accordance with a plan that had been approved by the board.
Did you wonder why it was that your plan for transition had led you to holding more than a third of the ADAs across the entire industry by the 30th of June 2014?
I think I made a general comment about that earlier, where I said that the transition for an industry fund was relatively simple, and we didn't go and compare ourselves to other retail funds, nor did we go and compare ourselves to anyone else. What we did was put in place a transition plan commensurate with the complexity of the program of work that we had in front of us to move from many different defaults to one default with large asset transitions included in that plan.
Well, let's just pick at a few parts of that. These figures that we're looking at for total accrued default amounts, even from the 30th of June 2014, can I suggest that's unlikely to include any significant number of industry accrued default amounts? Do you agree?
Potentially.
Because the point you were making earlier was that effectively the industry funds moved their pre-existing default product and made whatever changes were necessary to turn it into a MySuper product. That's your understanding?
Well, I expect that to be the case.
All right. And MySuper had come into effect in a compulsory way from the 1st of January 2014.
Yes.
And in fact, most funds had already established their MySuper product before the 1st of January 2014.
Yes.
All right. And when you say we didn't compare ourselves to anybody else, isn't that the whole purpose of the MySuper scale assessment?
What I meant when I used that expression was that when we put in place what we believe to be an appropriate ADA transition plan based on our organisation and the complexity of the program of work that we had in front of us, that we didn't go and ask other organisations or look at what other organisations were doing with their ADAs. The trustee turned its mind to the facts of the default funds in front of it and what we believed was the right time frame for us to make the changes.
But again, just so that I understand that, the administrator came to you and proposed a time frame. Is that right?
The administrator developed a time frame. It was discussed at the board and the board approved it.
And did the board push back and say that time frame is too slow?
There was a great deal of conversation around are we moving fast enough and testing the tension between how quickly we could transition ADAs and how we could manage risk and complexity during that process.
Did the administrator ever manage to accelerate the time frame?
No, I don't believe so.
In fact, it slowed down, didn't it?
Right at the end of the ADA transition, there were a small group of ADAs that were slowed down, yes.
Well, in the end, if we go to page dot...
I just...
Yes?
Oh, it's okay.
No, please.
No, that's right.
Ms Smith, if there's other evidence you want to give to answer that
that's fine.
question, you should add something. All right? Can we go to dot 4474? So you see then this is Appendix 2 of the paper, which is the analysis of MySuper experience over the year to 1 July 2016.
Yes.
And by this stage, by the time of the preparation of this paper, we can see that what is now being contemplated is that the completion of the transition of all remaining ADAs won't occur until March 2017. Do you see that?
Yes.
And was it explained to the board why the transition was slowing down?
Yes, it was discussed at the time, but I would have to reread the paper to remember the detail behind why it was slowed down.
Do you see in the bottom half of the page, there's the statement, various MySuper investment structure enhancements have been implemented over the last 12 months?
Yes.
And you see there's 3 bullet points, one of which is changes to fund managers and portfolios for Australian shares.
Yes.
The second of which is increased cost of manufacture budget by 5 basis points funded from the profit margin
Yes.
to enable increased exposure to unlisted infrastructure and private equity, which may result in an increase to the actual indirect cost ratio.
Yes.
And the third of which is increased allocation to extended credit and low correlation strategies of approximately $620 million.
Yes.
Now, just on the second bullet point, the profit margin that's being referred to there, is that the profit margin of NULIS or is that the profit margin of another entity within the NAB group?
From the 1st of July 2016, it's the profit margin of NULIS.
I'm sorry, I didn't hear the answer.
Oh, sorry. From the 1st of July 2016, it's the profit margin of NULIS.
And is it your recollection then that there was a decision that had to be made by the trustee to take less of the money in profit so that there could be more money applied to managing investment for exposures to unlisted infrastructure and private equity?
Yes.
And do you recall when that decision was made?
No, I don't.
All right.
I'm looking at... No, I don't.
And then you see the last sentence says, the competitive investment underperformance of the MySuper option has not arisen due to lack of scale.
Yes.
Did that prompt you to ask why it has arisen?
The performance of the MySuper option has been actively monitored and looked into by the trustee from over the course since the MySuper option was established, and has resulted in a number of changes. And this was one of the first changes, which was to increase the cost of manufacture so that we could take exposure to different asset classes.
Do you recall whether by this time anyone from management had suggested to you that one of the reasons for underperformance by the MySuper product when compared to what it might be was that the ADAs had not all been moved over into MySuper?
No.
Is that ever something that has occurred to you?
No.
All right. And then if we go over to page .4478, I'm sorry, should we go over to page .4477? And you'll see there's an assessment done of the competitiveness of fees
Yes.
relative to comparable MySuper funds. And you see in the middle it says, unfortunately, when standard fees are compared against the Chantwest universe of MySuper products, MLC Super Fund MySuper and NAB Staff MySuper rank 66th and 44th respectively.
Yes.
Do you recall whether you considered whether that was an acceptable comparative performance in terms of fees for the MLC Super Fund?
Is your question whether or not we thought that was good enough, or...
Yes.
No, we didn't.
And so what did you do about that?
So first of all, fees are just one one option to review, and what we're really trying to look at is after fee performance.
But that's even worse, isn't it, for your fund?
Well, that's why for MLC My Super, the performance of the fund is not where we believe it should be, not where we want it to be for our members. The NAB staff super fund performance is different to the My Super fund performance.
Yes, the staff super fund performs much better than the general fund.
It's a different asset exposure as well as a different asset allocation.
Yes, and if we just focus on that, I think there's a difference of something like 76% in the case of the staff fund allocated to growth assets as distinct from 70% in the case of the general fund. Does that sound about right?
It sounds about right.
And there's a very marginally higher investment cost with the staff fund compared to the general fund.
I think that is also right.
It's about 0.66 in the case of the staff fund and 0.61 in the case of the general fund.
Yes.
Is that 0.05, is that something that you think is the difference between the performance of the staff fund and the general fund?
No, the staff fund has had longer term exposure to unlisted assets, and that's essentially the differential in performance is exposure to unlisted assets.
And
As well as the asset allocation of the higher allocation to growth assets.
one of the difficulties for the MLC Super Fund My Super product was that there was not sufficient money allocated to investment management to enable proper investment in unlisted assets.
So I would rephrase that. So the design of the My Super option had come from other defaults that we had in the Plum environment, and the past performance of those options was competitive. The additional increase of the 5 basis points was to try and address some of the lack of exposure to unlisted assets, or the comparative lower exposure to unlisted assets, which tend to be more expensive. And so that was part of the address of going towards addressing the underperformance.
Can I ask you to keep your voice up, Ms Smith?
Sorry.
We're all having difficulty, even wearing headphones. The
Okay, apologies.
transcriber's having her difficulties.
Is another difference that the My Super product actually has a significant allocation to passive assets, or I'm sorry, I should put that a different way, has a significant allocation to passively managed assets?
It does have a significant allocation to passive assets, yes.
Its investment style is not actually active, it's active/passive, I think is the way it would be termed.
So all superannuation funds, including our trustee, use passive assets to try and keep the cost down, and then use your investment budget to gain outperformance in other areas. So it's just a combination of using active and passive managers to come up with a performance outcome.
And if we go to page .4478, this deals with the competitiveness of investment performance relative to comparable My Super funds.
Yes.
And we see, I suppose I should say, no fund, or by and large, no fund performed particularly well in the financial year ending 30 June 2016 compared to other years. Do you agree?
Yes.
But in that year, we see in the second paragraph, the performance of the My Super products in the predecessor funds has been relatively weak, producing a one-year return of 1.9%, which was bottom quartile according to Chant West's Universe of My Super Products.
Yes.
And that would be a bottom quartile return before fees, I assume.
No, I believe it's after fees,
One of the
investment fees.
after investment fees, but before administration
Correct.
fees. That's one of the features of the way Chant West compares things, is that it doesn't take into account administration fees.
Yes.
And then it said, however, this is based on comparison of the entire universe of My Super Products without taking into account wide-ranging product differences, in particular varying asset allocations and active versus passive investment management.
Yes.
And that's one of the things that can be difficult, can I suggest, for a consumer, which is just looking at what the fees are that are charged, even if they're investment fees, and comparing investment fees, won't necessarily tell you how much of that investment fee is actually being used to actively manage investment and how much of it is being taken as profit.
Yes.
And then this paper goes on to make the point that you've already made, which is one of the reasons why MLC's My Super returns are lagging against the performance from other comparable fund offers is predominantly due to a lower allocation to unlisted assets.
Yes.
I tender that document, Commissioner.
Extract from minutes of MLC nominees, NULIS and PFS nominees, 26 October 16, NAB 005561447, Exhibit 5.55.
Thank you. Are the My Super scale assessments taken seriously by the board?
Yes.
Can we bring up page 4474 again of that document that we've been looking at? And then bring up another document which is NAB.005.562.6778. And so this is the 2017 My Super Scale assessment. And if we then bring up, so if we bring up on one side of the screen NAB.005.562.4474, and on the other side of the page, on the other side of the screen, NAB.005.562.6782. I just wanted to ask something about the comparison between what had happened over the 12-month period. So on the right-hand side, you've got the 2016 changes, and you see there's 3 bullet points. So one is changes to fund managers and portfolios for Australian shares.
Yes.
The second is increased cost of manufacture budget by 5 basis points.
Yes.
And then the third is increased allocation to extended credit and low correlation strategies of approximately $620 million.
Yes.
And then over on the left-hand side, which is 2017, it has first the same words, various My Super investment strategy enhancements have been implemented over the last 12 months to improve performance returns for members in conjunction with asset transition for the accrued default amounts. But that's the extra words there. It says, in conjunction with asset transition for the accrued default amounts. And I just wanted to know, did you understand that the My Super product was likely to perform better in light of the transition of ADAs over to My Super?
That it would?
Yes.
No.
All right. And then in these 2 bullet points that are on the left-hand side for 2017, so it looks like this is the follow-through. In 2016, you'd increased the cost of the manufacture budget.
Yes.
And then in 2017, now there was increased exposure to unlisted infrastructure.
Well, and that continues. Getting exposure to unlisted assets is, by its very nature, they're not liquid and not something that happens like you can buy a share on the stock exchange. And so that to get into good unlisted assets takes time and consideration. So while the budget has been increased, actually gaining access to appropriate investments to put into the portfolio takes time.
Yes, that's right. There's 2 steps involved. The first is you have to have the budget to be able to do that investment.
Yes.
The second step is to be
Yes.
to actually carry out the investment. As you say, that can take some time because you have to. We're talking about buying unlisted assets. You have to find the assets and set them up.
Well, and decide that, to find appropriate assets that you want to take in exposure to in the portfolio, yes.
Yes. So and what's happened is in 2016 there's been this increase to the budget,
Yes.
and then in 2017 you start increasing the exposure.
The investment team go away looking for appropriate investments to put into the portfolio, yes.
And that's the investment team in the NAB Wealth business?
Yes.
All right. And is there any reason to think that if your budget, if the manufacture budget had been increased 3 years earlier, that you couldn't have started investing in unlisted assets then?
No.
Did anyone come to you and talk to you about that?
About increasing the budget
Earlier than
3
this?
years earlier?
Yes.
No.
When you eventually increase the budget, the consequence is that the profit that ultimately goes back to the NAB group decreased.
Yes.
And you're dependent upon a part of the NAB Wealth business to come to you and talk to you about whether some profit needs to be given up in order to increase the manufacture budget?
From the 1st of July, yes.
From the 1st of July 2016?
Yes.
What was the case before then?
It was the same. There's only a distinction in terms of the visibility of the profit to the trustee at that point from the 1st of July 2016.
Was that because before the 1st of July 2016, the trustee had even less visibility of the profit or had no visibility of the profit because it was being made at the insurance policy level?
Yes.
All right. And presumably, though, was it still, as you understood it, a decision for the trustee as to how much of the profit would be given up in order to enable better investment?
Yes.
Okay. And did it strike you looking at this that, again, there's a conflict of interest here, which is that somebody from the NAB Wealth Group needs to come to you and say, we want to give up some of our profit in order to improve the performance of the members' investment?
So, yes, there's a tension in the conflict of interest of running a fiduciary business for profit as part of, a conglomerate organisation. It's not that we're sitting there waiting for management to come and tell the trustee. It's an interaction. Performance wasn't where it needed to be. We understood the two major elements of that. Partly the 70-30 exposure versus where we compare to other trustees who are taking higher allocation of, say, an 80-20 or an 85-15 exposure to growth defensive asset split.
Sorry, do you think there are single diversified strategies being employed by some trustees with an 85-15 split of growth to
the-
defensive?
Yeah, there are.
All right.
And so the Chant West survey covers quite a large asset allocation split. We're not all not all of the defaults not all of the options in that are a 70-30 split.
You're not, I just want to be clear, you're not dealing with an issue of the life cycle
No.
My Super products. As you
No.
know, for young people in life cycle products, their allocation will not infrequently be something like an 85-15 split.
No, I'm just talking single defaults that are
Alright.
in the Chant West survey.
Okay.
So that is one reason for where we sit in the survey. But the second one is the lower allocation to unlisted assets. And it was through that we were, the trustee, with management, determining what needed to be done to improve the performance of My Super. And one of those elements was to increase the budget to obtain greater exposure to growth assets.
Attend to that document, Commissioner.
NULIS board meeting 26 October 17, comprising 2017 My Super scale determination NAB 00556267778 exhibit 5.56.
And then can we bring up NAB.005.605.0123? This is a report prepared by Chant West for the trustee,
Yes?
and this was part of a benchmarking exercise.
Yes?
And I just want to ask you about one thing, which is if we go to page NAB.005.605.0147. And this is dealing in this part of the report with benchmarking between the MLC super fund and other funds. You may not be able to see that. I just want to ask you about one particular thing, which is, as you know, one of the common explanations that's given for a difference in performance between retail and industry funds is the level of exposure to unlisted assets. You're aware of that as a general issue that's raised?
General theme, yes.
And that's one of the issues with the performance of your product was the lack of exposure to unlisted assets.
The lower allocation, yes.
And it's said, and this is a point that Chant West is addressing, that industry funds can invest in unlisted assets because they're less concerned about liquidity.
Yes?
And the point that Chant West is making here is that, and you see that in the second last paragraph, we believe these arguments apply less to My Super funds because of their default nature.
Yes?
And so I just want to make sure we agree that the level of liquidity is not an explanation in relation to your fund's My Super product for the lower level of performance, or the lower, I'm sorry, I withdraw that and put it again. The level of liquidity is not an explanation for the lower level of exposure to unlisted assets in the case of your My Super product.
No, and off the back of this report, the trustee undertook a review of liquidity and in a view to ensure that we could, that we were maximising liquidity requirements and in order to get greater exposure to unlisted assets. It might not have been off the back of this report, but we have undertaken a review into liquidity as we came out of the life company. So we had constraints in respect of liquidity is in investing through the life policy.
So you had constraints on liquidity when invested through the life policy
Yes.
in relation to My Super?
Well, all of the assets of the superannuation funds were invested through the life policy prior to the 1st of July 2016.
Right. And could you just explain to the Commissioner how that affected the liquidity of the product?
That the life company has liquidity requirements that the trustee then had to, or the trustee was then required to meet as a result of the way it invested it through the life policy.
I see. So am I right in understanding this? Before 1 July 2016, the needs of the life insurance company in terms of liquidity had an effect on how it was that the trustees' money could be invested?
There were liquidity requirements in place, yes.
And the liquidity requirements of the insurance company affected how the super funds money could be invested?
Potentially, yes.
And in a negative way?
Potentially, yes.
By, for example, reducing the ability to obtain exposure to unlisted assets?
That would be an impact of liquidity investing, yes.
And how was that conflict of interest managed?
So essentially, I'm not sure that the life company's liquidity requirements ever meant we didn't take investments that we needed to through any of the investment options that we were offering. However, from the 1st of July, the trustee no longer had life policy liquidity requirements in terms of its investing, and has looked at whether or not it can increase its exposure to illiquid assets in order to generate better returns for members.
I see. The problem effectively went away because the insurance company was sold.
Yes.
And then the money could be invested directly or managed more directly without concern about the liquidity requirements
of the life policy, yes.
All right. I tender that document, Commissioner.
Exhibit 5.57, Chantwest Report, MLC Superfund Benchmarking, January 17, NABs 005 605 0123, Exhibit 5.57.
And then can we bring up NAB.005.563.6689? So this is a report to NULIS prepared by, is it Jana or Jana?
Jana?
Jana. And Jana is wholly owned within the NAB group?
They were wholly owned. There's been a management buyout of Jana, and I think the group does own less than 50%, but I couldn't say if it was 48 or 40.
Okay. And when did that buyout occur? Do you know?
Last year.
And Jana provides a report. In fact, I think it provides a quarterly report to the investment committee concerning the performance of the fund's investments.
Yes.
And you were on the investment committee?
Yes.
And you would have reviewed these reports?
Yes.
Can we go to page NAB.005.563.6695? And you see in the middle of the page it says there has been much focus on the performance of the My Super option given the importance of this option in terms of size of funds under management.
Yes.
And in Jana's view, the performance of this option since inception, December 2013, is in line with expectations.
I see those words.
And then, but under peers.
Yes.
And then it goes on to say, for the product design and objectives that were understood at the inception of this option and the investment environment that has occurred.
Yes.
I just want to try to understand that the underperformance of the My Super option compared to competitors, was that expected by the trustee?
No.
And so when Jana says that the performance is in line with expectations, but then it does say for the product design and objectives that were understood at the inception of this option and the investment environment that has occurred, what do those qualifications mean as you understand it?
I'm trying to give you a succinct answer. And they're not my words, so I'm trying to imagine what was kind of being written by Jana at that point. I expect what they are saying that is that based on the asset allocation that was put in place for My Super at inception, that is the performance is expected as a result of that.
The performance, I think I understand what you're saying, which is having regard to the way the product was designed, the performance over the relevant investment period, which by this stage is the last 3.5 years, is in line with what would be expected.
Based on the asset allocation and in particular the exposure to the unlisted allocation we've been talking about, yes.
All right. And do you see then a little further below that, there's a sentence before the italicised numeral. The sentence is, as a result, Jana has considered the following 3 questions.
Yes.
And then number 1 is, relative to the product design at the inception of the option, how has JCIS performed in managing the mandate?
Yes.
Could you just explain to the Commissioner what JCIS is?
They're the implemented consulting team who are making the asset allocation decisions.
They're the team within NAB that is making the asset allocation decisions.
Yes, that's correct. Choosing investment managers, etc.
And you see then, Jana believes that the initial fee budget, including the budget allocated to ICR, which is indirect cost ratio,
Yes.
put a significant limitation to the level of illiquids in the portfolio.
Yes.
In addition, the operational requirement of the creation of a new option with $0 day one and no legacy assets has meant that even if the fee budget had been larger, the My Super option was always going to have a lower allocation to illiquids relative to peers, and there was nothing that JCIS could have done to change this outcome.
Yes.
And then if we go over the page, you see 4 years on, the fee budget has been relaxed slightly and the project to transfer all ADAs has been completed. However, the structural peer relative underweight to unlisted assets occurred at a period in the market where these assets have delivered some of their strongest historical gains due to lower interest rates.
Yes.
And that passage seems to suggest that there were 2 issues with the MLC My Super product. The first was the lower initial fee budget. I think you agree that that was an issue.
Yes.
And the second was that given that the My Super product started with no assets, and also by implication, I'd suggest by the length of time it was taking to transfer the ADAs over, that it was not possible to build up an exposure to unlisted assets earlier. Do you agree with that?
So I haven't thought about that before, notwithstanding the words on the page. But the unlisted assets that were held in the previous defaults were transitioned into the current MySuper default. And so the MySuper default did have exposure to unlisted assets as a result of the ADA transition.
Right. I think what we're agreeing on is the words on the page from the investment consultant appear to suggest that the delay in transferring ADAs over to the MySuper product was one part of the explanation for the lack of exposure to unlisted assets.
The words on the page do read like that, yes.
But you don't remember that having been something that was discussed at the investment committee level?
No, and I don't recall any attribution analysis in respect of that element of underperformance of the fund.
And you don't, well, sorry, if there's going to be attribution analysis, it would be here, wouldn't it, in this report? Isn't this the attribution analysis that you get?
There'll be, it could be in this report. There's multiple reports that the committee receive, both from the managers managing the money as well as Jana kind of overseeing that.
And the other thing that I want to suggest is that the statement 4 years on the fee budget has been relaxed slightly suggests that Jana did not consider that the fee budget was adequate. Do you have a view about that?
I won't opine on Jana's view, but I will say that it has been discussed at the investment committee with both Jana and the investment team as to the adequacy of the fee budget, and based on a fully allocated portfolio, where we can expect the performance to be for MySuper.
I'm not quite sure that's an answer to my question, but it might be helpful
So
if
I won't opine on Jana's words, but what I will say is that the investment committee has turned its mind to the adequacy of the fee budget and whether or not that will produce performance in line with the trustees' expectations of where it expects MySuper to perform for our members.
If we go to page 123/174, which is .6704. And you see at the top of the page there's a table. What it's setting out is how the MLC MySuper product has compared over the quarter, 1 year and 3 years, compared with the performance of the 60th percentile of MySuper products in the super rating survey.
Yes.
And you can see, and the reason this is dealt with is because the trustee had recently decided to add a secondary investment objective in relation to the MySuper product.
Yes.
And the secondary investment objective was to exceed the 60th percentile of the super ratings balanced option crediting rate survey over a rolling 5-year period.
Yes.
And because the product's not yet 5 years old, it's not possible to say definitively that it won't achieve that.
Yes.
But the portfolio manager doesn't think that it can achieve that.
The portfolio manager now believes it can achieve that. That's the point I was trying to make when I said, notwithstanding I won't comment on Jana's words, there's been an active conversation about the fee budget and the portfolio's manager's ability to achieve the performance requirements that the trustee believes are appropriate for MySuper.
All right, so just if we work through that, you see the last sentence of the paragraph is, MySuper is behind this secondary objective, although we note that the portfolio manager has voiced a strong objection that this objective will be very... I'm sorry, Commissioner?
Portfolio manager has voiced a strong opinion. I
I
think
beg
he
your
said
pardon?
strong objection.
Strong opinion that this objective will be very hard to meet at the current fee budget, and Jana shares a similar view.
Yes.
Is that, so that's the issue that was presenting itself as at the August 2017 meeting?
Yes.
And has the fee budget since been increased again?
Not at this stage. We've that conversation, as I said, went on with the portfolio manager, coming to the view that the fee budget was adequate in order to achieve the objectives set by the trustee.
I see. Is the constraint on the trustee in allocating a greater fee budget simply the need to remit profit to the group?
No.
What other constraint is there?
It's finding a balance between how much you'll spend in the portfolio for the return that you'll achieve. And so part of some of the success that the portfolio manager has achieved has been kind of the creation of and exposure to alternative assets at much lower fee budgets than we would have expected in the past, which is kind of the pressure of testing price. So trying to keep price down and trying to make sure that in doing that you've got a tension between performance and cost to the member.
When you say cost to the member, that's what I'm trying to understand. The My Super product will have two fees in it, or at least two fees. One will be an administration fee, the other will be an investment management fee.
Yes.
And the budget for investment management presumably comes from the investment management fee.
Yes.
And if you allocate more of the investment management fee to investment management, that reduces the profit to the group?
Yes, or alternatively it increases the price to the member.
Oh, I see. Whatever happens, what you're saying is, look, the group wants to make a certain level of profit, so if we have to spend more money on investment, then we'll have to increase the price.
Potentially.
Can I tender that document, Commissioner?
Minute of NULIS nominees, 22 August 17, and Jana June 17 quarterly investment report, NAB 005 563 6689, exhibit 5.58.
And then can we bring up NAB.005.563.5083? This is an extract. So this is a Jana report from a year earlier, which has gone to the investment committee, Ms. Smith.
Yes.
And if we go to page .5093, so we see the same running theme in relation to My Super. You'll see the sentence which is, performance has been weak over the past year due to the unlisted exposure issue highlighted below.
Yes.
And then you see the second sentence of the next paragraph. As mentioned last quarter, CIW and NAB Asset Management recently agreed to expand the investment fee budget for My Super to enable the strategy to partially address significant investment capability gaps that exist in the portfolio relative to that of peers.
Yes.
What is CIW?
It's an acronym that just doesn't spring to mind.
It's not the trustee though, is it?
No, it's not.
It's some other part of the NAB wealth business.
Yes.
And NAB Asset Management, is that effectively the investment manager that's being referred to by NAB Asset Management?
Yes.
So this seems to suggest that the agreement to expand the investment fee budget wasn't something for the trustee to agree with the investment manager. It was something that was agreed between one part of the NAB Wealth business and another part of the NAB Wealth business.
So prior to the 1st of July, and so this investment committee meeting is in August 2016, the trustee was charged a fee in respect of my super by the life company. And the profit bearing occurred and cost bearing occurred in all of the other, in the life company and then NAB Asset Management. So prior to the 1st of July, which was the previous quarter, it wasn't the trustee's decision to decide to increase or decrease profit. It was the relevant other entities. What they did do was increase the exposure to assets, reduce profit, and the fee to the member stayed the same.
Let me see if I've understood. Before the 1st of July 2016, the trustee couldn't control how much of the investment management fee got allocated to investment management.
Essentially, that the cost of manufacture was within the life company. So how much the life company was, how much profit they were taking, and the cost of manufacture sat with the life company and the underlying trusts, yes.
The life company would decide how much of the investment fee was taken as profit and how much was used in order to manage the investments for the benefit of members.
Yes.
And the trustee was unable to control that.
Effectively, yes.
And then once the sale of the life insurance company happened, it was then for the trustee to decide, as you understand it, how much of it will be taken as profit? Hence
my point earlier about the SFT being in the best interests of members and the removal of the intermediate in the entity. I can't say that word. The entity sitting in between the trustee and taking for the trustee to enable the trustee to be the decision maker of how and where those decisions were made. Yes.
Your point is the SFT was linked to the sale of the life insurance company.
Yes.
The sale of the life insurance company removed one related party that was having control and being able to take from the members' money?
That the trustee had to go through to invest members' money, yes.
Right. Does that suggest to you any conclusions you might draw generally about dealing with related parties with members' money?
You could ask me a specific question. I think the answer I would give is that the more control the trustee has over where and how money gets spent and profit gets made, the better the trustee is able to manage conflicts.
Now, since 1 July 2016, the trustee, as you understand it, has had control over how much of the investment fee will be used for management of assets as distinct from profit.
Yes.
But the trustee hasn't made a decision to allocate more of the investment fee to the management of assets.
For my super at this stage, no.
Right. And is the way that it works that the entirety of the investment management fee gets paid over to the asset manager?
No.
I see. So it's just whatever is agreed as the fee budget gets paid over to the asset manager?
No, there's it's a percentage basis point.
A percentage of whatever the investment management fee is gets paid over to the asset manager?
Yes.
And the rest of it is retained by the trustee,
Yes.
and then the trustee makes a distribution back to its holding company of the profit that it makes.
At the end of the financial year, yes.
Now, just so I know, does it do that on a quarterly basis or an annual basis?
Yes, it pays dividends quarterly on the profit it earns throughout the year.
And what company owns NULIS?
NWMSL is the immediate shareholder.
So the administrator owns the trustee.
Yes.
And do you know what amount of profit was distributed back to NWMSL last quarter?
I can't remember what the dividend payment was and whether we made one or not. There were, I believe, 2 quarters where we didn't make dividend payments as a result of the PSF matter.
As a result of the PSF matter?
There were 2 quarters where I believe we didn't make a dividend payment, and whether we did one last quarter, there could have been.
Oh, because the profit had to be used to compensate members. Excluding the PSF matter, what's the typical level of dividend payment that's made back on a quarterly basis?
I don't know, on a quarterly basis. Cash earnings, I could tell you what the cash earnings are, but I don't know what
On an annual basis?
the full dividend. I'd have to add up the 4 that I can't tell you, but I can tell you what the cash
I
earnings are.
can't hear you, Ms Smith. Speak up.
Oh,
Start
sorry,
your answer
I
again.
apologise. I'm not used to speaking loudly. I don't know what they are on a quarterly basis.
Yeah, go on.
Would it, well, on an annual basis, would it be $50 million, $100 million?
Oh, $100 million at least.
At least $200 million?
No,
Right. Somewhere between 100 and $200 million.
Yes.
Right.
less.
Sorry, less than.
Less. I mean,
Closer to 100 than 200.
yes.
I tender that document, Commissioner.
NULIS nominees 25 August 16 and Jana MLC Superfund Performance Report June 16, NAB 005 563 5083 Exhibit 5.59.
Now I want to move to a different topic than the last topic, which is to understand what has happened over the course of the last 18 months in relation to the dealings between the trustee and the NAB wealth business and ASIC. Do you recall that by the end of 2016, there was an issue as to a review that needed to occur by NAB as to whether services had been provided in exchange for advisor service fees?
Do I recall at 2016?
As at the end of 2016?
I'm not sure when I would have become aware that the licensee within the group, the advice licensee within the group, had an issue with ASIC.
Well, it would have been well before, you were aware from mid-2015, weren't you, of when the first event notification, or first breach notification started to be given?
So
I'm
they're
sorry,
not
December
the same.
2015.
They're not the same matters.
I understand. There was, well, I think I understand. You were aware from at least December of 2015 that there was an issue between the NAB Wealth Group and ASIC as to the charging of advisor service fees where services hadn't been provided.
For the trustee, yes.
Yes. And that began with a narrow focus, which was where there was no advisor allocated to the account.
Where a member had called us up and asked for the advisor to be taken off their account, there, in some instances, not all, but in some instances, there was a breakdown in elements of the controls that meant the advisor was taken off the account, but fees continued to be deducted.
Did you become aware at some point that the issue with respect to advisor service fees had expanded to deal with a question of whether advisors were providing services in exchange for the fees they were being charged.
Yes, but I don't know that when I became aware of that being a problem for the advice licensee.
All right. Now, were you aware that at the end of 2016, NAB proposed a methodology whereby it would review the provision of services based on a concept of fair exchange of value?
Only as I prepared for my witness statement was I privy to that letter and that proposal.
All right. And the proposal, you tell me if I'm accurately summarising it, the proposal was that NAB would review the delivery of services not based on whether the service that had been agreed to be provided had been provided, but whether there was a fair exchange of value.
So I have had the opportunity to read that letter, if it's a letter, it is, very briefly through the course of my witness statement preparation. So I don't know whether what you've just said is accurate or not.
All right. Can we bring up NAB.079.005.5287? This is a chain of emails. I was just interested in understanding whether it's a chain of emails you've looked at in the course of preparing to give evidence.
It could be one of the emails I reviewed to give evidence. It's in respect of the advice business.
And if we go to page .5289, so what we see is an email sent on the 22nd of December from Ms. Hopwood, who's within the NAB Wealth Group.
Yes?
And she's explaining that NAB is refining the methodology for assessing the provision of services based on the principle of fair exchange of value.
Yes?
And then if we go over to the next page, which is .5290, I'm sorry, if we go to the preceding page, which is 5288, that's my fault, Commissioner. See, that same afternoon, ASIC emails back and says that it doesn't agree to the fair exchange of value concept.
Yes?
And you're aware now that the position ASIC took was, if you agree to provide a service, you have to actually provide that service in order to retain the fees for it. You can't say, but there was a fair exchange of value.
But you can't say there was a
You can't say there's a fair exchange of value and therefore I'll keep the fees.
Sorry.
Let me take it back and break it down.
yeah.
You're aware that the position of ASIC was an unsurprising position, which was if you agree to provide a service and you've charged a fee for that service, you have to have actually provided that service.
Yes.
And NAB's initial position was to want to retain the fee without having to establish that it had provided that agreed service.
If that's what is meant by a fair exchange of value, then having not read I'd have to read the entirety of the email, but I'm sure that you're right.
You had not been aware of this
No,
while you were the trustee.
no.
You only...
No, sorry. I will clarify that. I was aware that that ASIC were having discussions with the advice licensee around the concept that was in the market around fee for no service. So I conceptually understand that that's what ASIC is talking about. You can't charge a fee unless you've actually provided a service.
And that's a position you agree with.
It is a position I agree with.
And were you aware that it was not necessarily a position that the NAB group agreed with?
I haven't had a conversation with anyone in the advice licensee group or the broader management team or even the CRO as to whether or not that was their view.
I tender that document, Commissioner.
Exhibit 5.60, emails concerning assurance review of advisor service fees, January 2017, between Hopwood, ASIC and others, NAB 07900552287, exhibit 5.60.
Now then, at some point in time, in either October, November or December of last year, you were provided with a copy of a document from ASIC titled Outline of Suspected Offending by the NAB Group.
Yes.
Can we bring that document up? It's asic.0036.0002.2531. This is the document we're talking about.
Yes.
And you read the document?
Yes.
And did it concern you, the document?
Yes.
And what were the aspects of it that concerned you?
In the context of, I was thinking as the trustee at that point, so in the context of fee for no service as it relates to what the trustee may have done at that point.
Well, it identifies various contraventions that it thinks the trustee may have engaged in.
I'm sure that it does.
But it also identifies various contraventions in relation to advice licensees.
Yes.
And the advice licensees were taking money or being paid money by the trustee from the trust funds.
Yes.
And presumably that also concerned you, quite apart from whether there was a contravention by the trustee. It concerned you that the advice licensees were taking this money?
If they were not providing a service, yes.
And then if we go to page 7 of that document, .2537, we see in relation to ongoing customer complaints, documents produced under notice regarding amounts paid in response to customer complaints during the period 1 January 2012 and 24 February 2015 disclosed some 40 complaints dating back to 2011, which were resolved either fully or partially in favour of the client.
Yes.
Had you been aware before receiving this document that the NAB wealth business had been receiving complaints dating back to 2011 about ongoing fees and poor service?
So I will be specific in my answer. These are complaints in respect of the advice business.
Yes.
I don't receive reporting, the trustee does not receive reporting for complaints in respect of advice provided. If it, we would receive complaints as they relate to superannuation members, yes. So
Go on.
So, in terms of the nature of the complaints listed here and their date of history, no, I don't recall being advised for these specific ones.
So that I understand, do you mean the trustee is advised if an advice licensee has been paid by the trustee but not provided services?
I don't believe we get specific reporting on that, no.
Okay, so I think
The
there might be
advice
some
licensee
inaccuracy.
would be remediating and making good the customer under those circumstances.
Yes, but the trustee is deducting money from the member's account and paying it to the advice licensee.
Yes.
And I had thought from an answer you gave a moment ago that you were suggesting the trustee would know or would be aware if there were complaints about the advisor where the advisor was being paid out of superannuation money.
I think I don't know, actually.
All right. And then if we go to page...
Just a moment. Mr Commissioner, we have not been notified that this document would be the subject of publication. There is a passage towards the end of the document that we may wish to make a claim for confidentiality. We have not been notified of the intended use of this. We would seek an opportunity to take instructions about that matter towards the end of the document before it is displayed.
Hodge, what do you say?
Commissioner, if that's the case, then we should adjourn. So
I come
I can
back at
understand
5 to 3.
Thank you, Commissioner.
All said. Commission is now adjourned. Please be seated.
Mr Young?
Commissioner, at 1:37 p.m. we were provided by email, that is to say my solicitors were, with a list of 18 documents it was desired to tender this afternoon. We don't have access to those documents aside from 4 of them. So we're not in a position to ascertain our position with respect to confidentiality. The documents go to an ongoing exchange with ASIC that is explicitly the subject of without prejudice privilege. It goes to issues that are continuing as between ASIC and NAB. The documents do not concern an investigation affecting NULIS. We would like an opportunity of making a considered confidentiality application in respect of those parts of the documents that concern without prejudice privilege material that is the subject of ongoing exchanges between ASIC and my client. This is a factor not present in the document that was the subject of the Commissioner's ruling yesterday. Those documents concerned without prejudice privilege in respect of matters that had concluded as between ASIC and my client. These documents go to an ongoing exchange and a continuing exchange of without prejudice communications between ASIC and my client. And if they are to be...
Just a moment, about past conduct?
About not only past conduct, about past conduct and current remediation proposals.
about remediation for past conduct.
Yes, but it concerns exchanges about the detail of remediation proposals that have been advanced by either ASIC or NAB or both and discussed between them. Now, we are concerned, Commissioner, that if these matters are published at this stage of events, it will affect or may affect the future of those discussions. It may prevent future exchanges taking place between ASIC and my client if matters cannot be raised and discussed confidentially. Now, they're the matters about which we wish to take instruction.
Just pausing there, Mr Young, so that I understand this properly. You mention remediation for past conduct. Is that the point that provokes the question?
Well, as I said, it's one aspect of it.
Well, one aspect's one thing. I need to know what it is that you say is to be borne in mind in considering the course I should take.
Commissioner,
You mentioned current remediation proposals in respect of past conduct. I understand that. Is there any other matter to which you wish to draw my attention?
well, we're hampered, Commissioner, because we have not had access to the documents it is proposed to display. So I can't tell you precisely what those documents go to. We have a concern that they go to ongoing exchanges between ASIC and my client concerning remediation is the one matter I've mentioned, and ongoing proposals to and fro concerning remediation. But we're also concerned that the ongoing negotiations concern other aspects of liability or culpability relating to previous conduct, and how those matters might be resolved between ASIC and ourselves. Those sorts of exchanges commonly occur between the regulator and a party, but they always take place confidentially and on a without prejudice basis, and this is no exception. Now, I asked yesterday...
Mr Young,
Yes.
is one of the issues which I will have to consider whether allegations of regulatory breach are matters for negotiation and resolution or to be determined according to processes of law.
No, that's not a matter that you will have to determine, Commissioner.
Oh?
No.
Under my terms of reference?
No.
Oh? I'm a little surprised by that answer, Mr Young. I would have thought that it fell within the terms to know or to consider how the regulator should deal with allegations of regulatory breach.
The regulator has powers to resolve matters at the moment under statute in a variety of ways, many of them not involving court processes. So that's the established legal position as it stands.
Commissioner, I'm sorry, could I apologise for interrupting my friend, but just make a suggestion for how we deal with this. The instructions I've got are different from what has been the instructions that Mr Young has received, because I'm told these documents have been in the court book and are available to be accessed by all of the parties for some days. Now, perhaps there's some misunderstanding, and perhaps there's some issue that for some reason NAB has been unable to access those documents. They obviously haven't had the time in the last 5 minutes to be able to check whether in fact they have already looked at these documents. Can I suggest that we stand down Ms Smith, interpose the next witness, and that will give the NAB team some time to actually look at those documents.
And is the next witness from NAB?
No, the next witness is from
Yeah.
Australian Super, Commissioner.
Well, if I say to Ms Smith, not before 9:30 tomorrow morning?
I'd be content with that, Commissioner. I'm told by Mr. Donnelly, who'll be taking the next witness, that we probably won't see out the day with the next witness. So it's really we're in your hands, Commissioner. One
Well, I'd
possibility
be
is-
minded to stand it over till not before 9:30 tomorrow morning for Ms Smith, so that, and we go on with the Australian super matter as far as we can.
Thank you, Commissioner.
Yes, Mr Young?
Two things, Commissioner. Yesterday, I asked for a list of all documents that it was proposed to be gone to in the course of cross-examination and displayed so that we could consider overnight any confidentiality concerns and objections we may have.
Mr Young, I think it may be better if these matters are taken up between solicitors rather than with competing propositions being advanced from the bar.
Yes,
Can I suggest you direct yourself to whether we should stand Ms Smith down and NAB down until not before 9:30 tomorrow?
well, that's the second matter I wish to mention. The documents in question are documents that Ms Smith had no involvement in and was not a party to, and the ongoing investigation we are concerned with does not concern the conduct of NULIS. Now, but that is the matter that is the subject of this documentation. We fail to apprehend at the moment why this matter and the tender of these documents need involve Ms Smith at all, nor detain her, because on our instructions, her answer will be that she had no involvement.
Well, you will not
in these
give you
matters.
will not give her answer, Mr Young.
I'm
You
not.
will not. Do you understand me?
I'm not attempting to give any answer, Commissioner. I'm attempting to explain the situation why we think this matter ought not to detain Ms Smith.
Yes. And you will not indicate what answer you think she may give.
I've done nothing of the sort, Commissioner.
Do go on.
I repeat my submission that in our submission there is no reason why this documentary issue need detain Ms Smith, unless Mr Hodge can point to a reason why he needs to ask questions of Ms Smith concerning these documents and this course of events.
These are matters that we will take up at not before 9:30 tomorrow morning. Ms Smith, you're excused. If you could be good enough to be back at the hearing room at 9:30 tomorrow morning, unless you are advised to the contrary. It may be that you will be advised to the contrary. We will see.
Thank you.
Thank you. Yes, Mr Hodge?
Commissioner, we'll just need to stand down for 2 minutes while we rearrange the bar table.
I'll
if
come
that's
back at 10 past.
okay. Thank you, Commissioner.
All stand. The Royal Commission is now in session.
Overnight, National Australia Bank made an application pursuant to the practice guidelines of the Commission in Section 6D(3) of the Royal Commissions Act for a non-publication direction in respect of certain documents. The application seeks directions that 7 documents be in whole or in part not available for publication beyond the staff and lawyers assisting the Commission and, of course, NAB. I consider that the application for non-publication direction should be refused. My reasons for doing so include, but are not limited to, the reasons that I gave in respect of the earlier application by NAB for a non-publication direction. I add the following further considerations which in my view support the conclusions that I have expressed. NAB seeks that part of 4 of 7 documents not be published. It seeks that the whole of 3 documents not be published. One of the documents in respect of which the non-publication direction is sought is a document apparently from ASIC entitled Outline of Suspected Offending by the NAB Group. The non-publication direction that is sought concerns paragraph 60 to 65 of that document entitled Further Reviews and Annexure A to the document entitled NAB Group Methodology for Further Reviews. The parts of the document for which the direction is sought concern ascertaining the extent of the charging of fees for no service and what approach should be adopted for compensating those who have been charged. The other documents in respect of which non-publication directions are sought all relate, at least primarily, in some cases exclusively, to discussions about remediation proposals. Some of the documents are documents sent by ASIC to NAB. Some of the documents are sent by NAB to ASIC. Although I suspect it does not greatly matter, I notice that not all of the documents from ASIC to NAB are expressed to be either confidential or without prejudice. The terms of reference of the Commission include terms requiring me to inquire into the effectiveness of mechanisms for redress for consumers of financial services who suffer detriment as a result of misconduct by financial services entities. That is paragraph E of the terms of reference. They also require me to inquire into the effectiveness and ability of regulators of financial services entities to identify and address misconduct by those entities. That is paragraph G of the terms of reference. The matters which are the subject of the sought non-publication direction are matters which go centrally to terms of reference E and G. NAB emphasises that discussions with ASIC have not reached agreement and have not reached a conclusion. But as NAB says in its written submissions, the Commission is required to strike an appropriate balance between 2 interests. On the one hand, public interest in the open and transparent operation of a public inquiry into a matter of public interest, and on the other hand, the public interest in protecting the privacy of an individual, or the public interest in protecting private commercial interests. In attempting to strike the balance that is to be drawn between those competing elements, it is to be noted that it would be in the interests of NAB to pay the least sum available by way of remediation. It would be in the interests of persons charged fees in circumstances where no service has been provided to be provided with adequate compensation. It is in the public interest that there be an open and transparent inquiry about how both the regulator and the regulated deal with the issue of remediation. For these reasons, the application for non-publication direction is refused. Mr. Hodge.
Commissioner, before Ms Smith is recalled to the witness box, I need to say some things in response to some things that were said from the bar table yesterday and that might be taken to be an implicit criticism of the staff of the Royal Commission, and that also were premised upon a misunderstanding on the part of those giving instructions for the National Australia Bank as to the process of the Commission. You were told, Commissioner, that at 1:37 p.m. yesterday afternoon, the National Australia Bank was provided by email, or the solicitors for the National Australia Bank were provided by email with a list of 18 documents that it was desired to tender yesterday afternoon. And that is true. That was a departure from our usual process. We do not, as a matter of course, and to put it beyond doubt, we'll never again provide in advance a list of the specific documents that we intend to tender in an afternoon session. We did that as a matter of courtesy and convenience to attempt to assist with dealing with the without prejudice claims that had already been made by the National Australia Bank with respect to the documents that they had produced to us. You were also told, Commissioner, in relation to the outline of contraventions from ASIC that I was taking Ms Smith to, that the National Australia Bank had not been notified that this document would be the subject of publication. That is incorrect, and I need to explain some matters about the way in which the process of clearing documents works, as is explained in the practice guidelines of the Commission. The list of 18 documents that was provided yesterday afternoon to the National Australia Bank included documents that had been produced to the Commission by the National Australia Bank and documents that had been produced to the Commission by ASIC. All of the National Australia Bank documents had previously been notified to the National Australia Bank and cleared for confidentiality prior to the hearings. The National Australia Bank applied the redactions to its own documents and provided the Commission with those versions to be uploaded to the court book. All of the ASIC documents that were listed in that list of 18 yesterday afternoon had already been uploaded to the court book, and they were accessible to all of the parties given leave to appear on a confidential basis. In accordance with what has been the Commission's usual practice for the entire year in respect of every module, in respect of which the National Australia Bank has been given leave to appear in all of them, the ASIC documents were cleared for confidentiality with ASIC prior to being placed on the court book. And in fact, in some cases, the Commission had slightly departed from its usual practice and also provided ASIC documents specifically to the National Australia Bank in order to ask them whether they wish to make any specific claim over those documents. One of those ASIC documents that NAB says was said to you yesterday it had not had any notice of was in fact provided to the National Australia Bank in a tender list in advance of being placed on the court book. That is ASIC.0036.0003.0730. When it was originally notified to the National Australia Bank, the National Australia Bank did not make any redactions to this document when it was cleared for confidentiality, but then claimed, as of last night, that it should be wholly redacted. The process for clearing documents for upload to the court book has been followed by the solicitors assisting and is consistent with the published guideline, which is Practice Guideline 3. And it is the practice that has been adopted with all parties granted leave to appear and access to the court book. Practice Guideline 3 explains at paragraph 20 that counsel assisting the Commission, subject to the Commissioner's control, will determine which and when documents are tendered. Paragraph 21 provides, before the commencement of a public hearing, each person granted leave to appear at that hearing may be given confidential access to documents that are likely to be tendered as exhibits at the public hearing. Paragraph 22 provides, one purpose of providing this access is to enable a person to identify whether any application should be made for a suppression order in relation to a document or any part of a document. A copy of a document of this kind will not otherwise be provided to any person. Generally, a document of this kind will be subject to a direction made by the Commissioner that it not be published until the point at which it is tendered. Of the ASIC documents that were listed in the list of 18 documents that were provided to the National Australia Bank yesterday afternoon, all but 2 of those documents were uploaded to the court book and accessible by the National Australia Bank on Sunday night. 2 of those documents were uploaded to the court book on Monday morning and accessible by the National Australia Bank from that point of time. It would have been open for the National Australia Bank, in accordance with the practice guideline, to make any confidentiality application with respect to those ASIC documents placed on the court book since Sunday, from Sunday, and in respect of the 2 on Monday morning, since Monday morning. The court book is designed to allow parties who are given leave to appear to access the court book on a confidential basis for the purpose of identifying whether any application should be made for a suppression order in relation to a document or any part of the document. I accept that it may be that the solicitors for the National Australia Bank somehow did not realise that they had access to those documents. But I want to be absolutely clear that even if that is the case, that on the basis that that is the case, that there was no fault on the part of the staff of the Commission or the solicitors assisting the Commission, and that everything has occurred in accordance with the practice guidelines that have been published by you in February of this year. Finally, I need to note one other matter in relation to this, which is that one of the events that may have brought us to this point is a particular way in which the National Australia Bank went about producing documents to us in response to notices to produce that you issued, Commissioner. In the course of the Commission's investigations, the Commission identified that one of the case studies that it would pursue in relation, or one of the issues that it would pursue as part of the case study in relation to NULIS and the National Australia Bank related to fees for no service. And to that end, Commissioner, you issued a notice to NULIS to produce documents in relation to fees for no service issues that required those documents to be produced before 4 p.m. on the 9th of July 2018. The lawyers acting for the National Australia Bank and NULIS did produce documents on the 9th of July 2018. They produced 31 documents on that date in relation to the fees for no service category. 31 documents in response to the notice. On the 20th of July, the first set of documents regarding the fees for no service category was produced. After that date, the National Australia Bank produced in excess of 3,500 documents regarding the fees for no service issue, of which in excess of 3,000 were produced to the Commission last week. On the 2nd of August, that is Thursday of last week, the National Australia Bank apparently withheld documents from the production to the Commission on the basis of without prejudice privilege. And then on the late afternoon of the 3rd of August, that is Friday afternoon, the National Australia Bank wrote to the solicitor assisting and said in order to facilitate the timely progression of the Commission's inquiries, NULIS and NAB no longer intend to withhold those documents from production on the basis of without prejudice claims and will instead seek a non-publication direction if the Commission determines that it wishes to publish any of the information or documents in question. In respect of the ASIC documents that were on that list, Commissioner, some of those documents, of the 7 documents produced by ASIC to the Commission that were on the list of 18, 4 of those documents were produced by the National Australia Bank to the Commission on the afternoon of the 3rd of August 2018, and 3 of them have never been produced by the National Australia Bank to the Commission. It may be that unfortunately that particular manner of responding to your compulsory notice has contributed to some of the difficulties that the National Australia Bank has faced in dealing with these confidentiality claims. Commissioner, I don't know whether Mr. Young wants to say anything in response to that.
Yes.
We would like to say several things, Commissioner. First and generally, we will need to take instructions about some aspects of the statement made by Mr. Hodge. Secondly, I wish to emphasise that we have endeavoured at every point of time to ensure that so far as possible matters concerning confidentiality claims were dealt with and progressed outside of the hearing process so as not to interrupt the processes of the Commission. That is why we requested notification as to what documents were going to be tendered so that we could consider our position in relation to a confidentiality claim. Thirdly, a learned friend said that it may be that my instructing solicitors misapprehended the position concerning access to the ASIC labelled documents uploaded to the court book. There's no equivocation about that, Commissioner. My solicitors did not appreciate that they could, on Sunday or yesterday, obtain access to the ASIC designated documents. Now, that was the position as of yesterday lunchtime when we received the email concerning the 18 additional documents. Now, that may have been a fault on the part of, or at least a mistake on the part of my instructing solicitors, but I want to assure the Commission that that was the genuine position as of yesterday. And I don't think that that is questioned by Mr. Hodge.
I don't question that.
Simply draw attention to paragraphs 21 and following of the Practice Guideline 3 that I published on 8 February last.
Yes. Now, Commissioner, as I said, there are some matters we wish to take instruction on. There is one document, my learned friend specifically mentioned, that we had made the subject of a confidentiality application prior to yesterday. But we will consider the position in all respects in relation to what Mr. Hodge has said.
Thank you, Mr.
Beyond
Young.
that, I don't want to say anything, Commissioner.
Thank you, Mr. Young. Yes, Mr. Hodge.
Commissioner, could Ms. Smith be recalled, please?
Ms. Smith, please. Is Ms. Smith in the hearing room?
She's outside the courtroom, Commissioner.
Yes, if you could arrange for her to be brought in, please. Ms. Smith, good morning. Would you be good enough to return to the witness box, please? Just one moment, Mr. Hodge. Let Ms. Smith settle. Yes, Mr. Hodge.
Thank you, Commissioner. Could we bring back up ASIC.0036.0002.2531? Ms. Smith, this is the document that we were looking at yesterday afternoon, you recall?
Yes.
And this is a document that you had seen before at about the time that it was produced by ASIC.
Yes.
And if we go to page 11 of that document, now, this concerns, at the top of paragraph 45, you'll see that ASIC was raising a concern that the National Australia Bank had contravened section 912 capital A1A of the Corporations Act in relation to the no advisor PSF conduct.
Yes.
And that was the conduct that remediation had been agreed to be made for. The no advisor, you understand?
Oh, yes.
The no advisor PSF
Yes.
conduct is the
Yes.
taking of PSFs.
Yes.
All right. And then in relation to the next section down, you see that this then deals with a separate issue, which is what's referred to by ASIC as the no obligation PSF conduct.
Yes.
And the no obligation PSF conduct, as you understood it, is concerned with the MKPS members continuing to be charged PSFs after they've joined the MKPS product.
Yes.
And was this the first time that a concern had been raised with you as to whether or not there was a proper basis for deducting the PSFs from any MKPS member? Or you're not sure?
There could have been earlier, it could have been raised earlier, but certainly this was the first formal correspondence from ASIC outlining their concerns.
All right. And then if we go over the page to page 12, and you see about halfway down the page, there's the heading remediation of fees for no service conduct.
Yes.
And you see in paragraph 58, this is addressing some specific matters or specific events in relation to fees for no service conduct.
Yes.
And those events, as we understand it, are ones that are referred to in your statement.
I would need to check my statement for the event numbers. I recognise one of the event numbers, but not all of them.
All right. In any event, you were aware that there were specific notifications that had been given to ASIC in relation to fees for no service?
For the trustee, yes.
Yes. And also that, more generally, the National Australia Bank, in respect of its wealth division, had given notifications to ASIC about fees for no service for specific issues.
I was not aware of the specific breaches or events that the advice business would have provided to ASIC in respect of fees for no service.
Right.
But I did understand that there were inquiries going on between ASIC and the advice business.
And then you see in paragraph 60 of that document, the statement, ASIC has engaged in extensive discussion and negotiation with NAB over the past 2 years regarding the methodology to be used by NAB, Apogee, Godfrey Pembroke, and then if we go over the page, GWM, JB Weir and Meritum to assess whether there are additional fees for no service breaches or failures in the period between 1 January 2009 and 31 December 2015 beyond those breaches reported to ASIC.
Yes.
Now, I just want to understand the state of your knowledge before you received this document. This is referring to discussions that have been ongoing between ASIC and the National Australia Bank about the methodology to be used in respect of NAB and its advice licensees to determine whether there are other fees for no service breaches. That's what you understood from the paragraph?
Yes.
And you understood that NAB Financial Planning and these licensees would have been receiving advisor service fees in respect of members of the superannuation trusts.
Yes.
And so you, as trustee or as the chair of the trustee, I'm sorry, I withdraw that, the trustee of which you were the chair would have been making payments to these financial advice licensees in respect of the trustees' members.
Yes.
And was this the first time that you became aware that there had been 2 years of discussions between ASIC and NAB about a methodology to be used to determine whether there were further fees for no service breaches?
The 2-year period, I would expect the answer to that is yes. But I was aware, and the board was aware for some time, that there had been ongoing discussions with the regulator regarding the provision of advice services.
And did you know what the nature of those discussions were?
No, to be specific.
Were you aware of a disagreement between the regulator and the National Australia Bank about the methodology to be used to determine whether there are additional breaches or failures?
Well, this letter points out that ASIC are not comfortable with the proposals put forward, so at this point I would have been aware.
I'm just wondering whether before you received this document you were aware of that.
I wouldn't know formally before if I had been aware that there'd been disagreement.
Right.
I did know that there was ongoing correspondence with the regulator and the advice licensee and the business.
And then if we look at paragraph 62 of the document, you see what is explained is that ASIC disagrees with NAB's view that it should test whether there was a customer-advisor interaction rather than whether NAB delivered on the express commitments it gave to its customers.
Yes.
Do you recall whether you were aware before receiving this document of the National Australia Bank taking a position that it would test whether there was a customer-advisor interaction rather than whether it had actually provided the services that it had contracted to provide in exchange for the fees?
No.
But you became aware upon receiving this document?
Yes, but I'm not sure I actually understood what it meant on reading the words. I've had to read them a couple of times, and for you to make the statement for me to actually get the point of what that means.
I see you, until this moment, you hadn't understood what that issue
What
was.
that actually meant.
All right. Do you recall whether you inquired of anybody at the National Australia Bank as to what this issue concerned?
I did not.
Had you realised that the National Australia Bank was taking the position that it would test whether there was a customer-advisor interaction rather than whether it had supplied the services that it had contracted to supply in exchange for the fees that it had received, what would your position have been?
You're asking me to speculate on what I might have thought had I understood that at the time. I can tell you what I thought at the time, rather than speculating on what I might think.
Well, I am going to ask you to speculate, but you tell us what you thought at the time.
At the time, I believed that the advice licensee was in discussion with the regulator. The regulator understood and was privy to whatever they thought the issues were with the advice licensee, and that an appropriate customer outcome would be achieved in terms of the advice licensee entering into a review program or a remediation program if they had not provided advice to customers.
I see, and I just want to test that. As the trustee, the view you took was resolving this issue of whether the advice licensees had received fees for no service was a matter between the advice licensees and ASIC.
Yes.
Now, the difficulty, can I suggest, with that position is that you are the chair of the trustee. The trustee has been deducting money from members' accounts and paying it to these advice licensees. You agree?
Yes.
And what I'm trying to understand is, given the trustee's duty to act in the best interests of the members, how you would think that it could say this is a matter to be resolved between the advice licensees and ASIC.
So it's not the only thing the trustee did or thought at the time.
Sorry, did you want to say something
Well,
more?
I was just saying it's not the only thing that the trustee did or thought at the time
In relation to
respect
this
of
issue?
this issue.
And what were the other things that the trustee did or thought?
So from, I would say December, would be the first recollection I would have. The advice licensee and the NAB had introduced a program they called the Customer Advocate Review Program, which was about reviewing how advice was given to customers. And that involved putting in place an external independent review process through what they called a customer advocate program to review the quality and the types of advice that were given to customers of the advice licensee. The trustee sought to understand, first of all, what that program was and the results of that program as it related to superannuation members. And so from 2015, the independent expert who was known as the customer advocate was presenting to the board the methodology and the program of review that was being undertaken and the results of that review. And that was regularly reported through to the trustee board. So the board was looking to understand the extent of issues in advice being given by the related party financial planners. Also, in 2015, the trustee board started really trying to get a better understanding and better knowledge in respect of the advice risk it was exposed to. And from 2015, the board asked for and required a second-line risk review in respect of advice risk that the trustee was exposed to, including issues and controls. In 2016, the board asked for and required a line 3 internal audit review over advisor service fee control environment. In 2016, the board asked for and required a second-line review over FOFA controls. In 2017, the board asked for and required a second-line review over advisor service fee controls. The board was actively seeking to understand its risks as it related to the payment of advisor service fees for members.
None of those things that you've spoken about have anything to do with this issue, which is whether in the period between 1 January 2009 and 31 December 2015, the advice licensees were taking fees without providing services to your members. Do you agree?
No, the customer advocate role was absolutely about reviewing the provision of advice by the advice licensees, and the trustee was trying to understand. That was the first independent review, or the first time there was independent analysis of the types of advice that were being provided by the advice licensees. The trustee was trying to understand the scope of that work and the impact of any findings as it related to superannuation fund members.
Let's focus on the issue here and see if we can tease this out. You understand that the issue that's being addressed by ASIC in this document is whether between the period of 1 January 2009 and 31 December 2015, the National Australia Bank advice licensees have been charging fees for no service.
Yes.
And you understand, and I'm sorry, I should say, and you understood that at the time when you got this document.
Yes.
And you understood at the time that at least some of the fees were being charged to members of the superannuation funds of which you had been the chair of the trustees.
I think that's a reasonable assumption to make.
And you understood that there was a dispute between ASIC and the advice licensees as to what methodology would be used in order to determine how extensive those failures to provide services were.
So I understood there was discussion. I'm not sure I understood there was a dispute at this point. Yes, they use the word disagree, but I understand there was discussion going on as to what and how the advice business would demonstrate whether or not services had been provided to customers of the advice licensee.
Right. So you understood that there was what you've termed a discussion as to how the advice licensees would determine when and how services had been provided to the members?
Yes.
And were you aware of that even before you got this document?
In all likelihood, yes.
And were you aware that that discussion had been going on for some period of time?
I was not aware of the length of the time of the discussion.
You were aware, though, that ASIC was taking one position and the National Australia Bank was taking a different position?
Well, this letter seems to indicate that.
Were you aware before you got this document that ASIC was taking one position and the National Australia Bank was taking a different position?
Not that I can recall.
Right. Presumably, if you were aware that there were
Discussions
and there hadn't been agreement, then it must be that they weren't on the same page.
I don't know that I thought about it in that way prior to whether I thought there was a disagreement or whether there was discussion.
All right. Once you understood, and you must have understood, I'd suggest no later than receipt of this document, that ASIC was taking one position and the National Australia Bank was taking a different position.
Yes.
As to the methodology by which it would be assessed when and how services had been delivered. did you think that that was an issue that concerned the trustee?
Yes.
And so did the trustee then take steps to become involved in that issue?
Other than to remain informed about the matter, nothing more specific than that.
If you assume for the moment that the position taken by the National Australia Bank was that it would test whether there had been a customer advisor interaction, and the position taken by ASIC was that the National Australia Bank needed to test whether it had delivered on the express commitments that it gave to its customers. So assume, as is set out in this document, that those are the two competing positions. Is that something that, in your view, sitting here now, the trustee ought to have taken a position on?
So my view is that when the advice licensee had determined what methodology it would use to review appropriate provision of services, that would be the point in time where the trustee would turn its mind to whether it thought it was adequate in respect of the superannuation members.
What I'm struggling to understand is how, consistent with the duties of the trustee to act in the best interests of the members, and consistent with the duties of the trustee to manage conflicts and always prefer the interests of the beneficiaries over the interests of the trustee or any affiliate of the trustee, how it is possible for the trustee to say that it will sit on the sideline and wait to see what position has been taken by the advice licensees?
I don't think the trustee was sitting on the sideline. I think the trustee was actively making sure it understood what, through CRO reporting, what was happening, and I would say that it was the right position for the trustee to have taken at the time.
Sorry, just so that I can understand that position, you said, my view is that when the advice licensee had determined what methodology it would use to review the appropriate provision of services, that would be the point in time where the trustee would turn its mind to whether it thought it was adequate in respect of superannuation members.
Yes.
So you would wait until the advice licensees had come to a decision as to what they thought was the most appropriate methodology.
They would determine a methodology, and I think at that point the trustee would need to turn its mind to whether or not that was adequate in respect of advice fees that were paid to licensees for superannuation members.
But why is it necessary for the trustee to wait to see what position the advice licensees are going to take?
So I think, so essentially I think that unless the trustee was not privy to the information that ASIC had. The trustee is not responsible for monitoring nor determining or the advice given by a licensed financial advisor, whether that be Godfrey Penbroke or whether that be Colonial First State or any other financial advisor. So the trustee in this instance, because these are related parties, had a lot more information than it would have otherwise had. And unless the trustee were to undertake a review of itself, the trustee was waiting for a position by the group, and then it would turn its mind to whether we thought, because they were related parties, that that was adequate. And I think that's reasonable in the context of the trustee's responsibility to its members, as well as the advice and licensee's responsibility to provide advice in accordance with the provision of the law that they're required to provide advice under.
I just want to understand that your view is, or your understanding is, that the trustee is not responsible for monitoring the advice given by a licensed financial advisor.
In the context of the trustee's responsibility is to determine whether or not we're making a valid payment. We don't monitor advisors and the provision of the specific advice.
I'm sorry, could you just say that again? You're saying in the context of the trustee's responsibility, it is to determine whether or not we're making a valid payment?
Yes.
So I'm just trying to understand how you can make a valid payment without knowing whether the service has been provided.
So I think at this point the advice licensee doesn't know whether the service has been provided yet or not either until they undertake a review. So at this point the trustee, based on the control environment it has and the controls it has in place to actually be able to make the payment, is making a valid payment for a member who has entered into an agreement with their advisor to pay an advice fee and instructed us to make that payment. That's what there's a whole series of controls that the trustee has in place to ensure that we're making a valid payment.
At least up until the end of 2015, the trustees, the MLC Plum trustees, didn't have any proper controls to determine whether service has been provided in exchange for payment, did they?
No, it had some controls that were not adequate in all instances that led to us reporting breaches to the regulator and as part of that remediation process to repay customers where advisor service fees were deducted. That included making sure that the controls were adequate in order to make valid payments.
If there was an advisor linked to a member's account, did the trustee have any controls to determine whether that advisor had actually provided the contracted services in exchange for the advisor's service fees?
Other than the contractual requirements of the provision that the advisor has via the PDS to provide services and the authorisation that we've been given at the point of the member and the advisor agreeing for the payment, and then ensuring that there is an advisor linked to the account and from the start to the authorisation and then to the payment. The actual monitoring of service is not something that the trustee has done. So it has a series of other controls to determine the validity of the payment.
And you understood, at least upon receiving this document from ASIC, that ASIC was concerned that between 1 January 2009 and 31 December 2015, NAB financial planning and other NAB advice licensees had not been providing the services that they had contracted to provide in exchange for the advice service fees that the trustee was paying to those advice licensees.
Sorry, can you repeat that?
Yes, you understood, at least by the time you received this document from ASIC, that ASIC was concerned that the NAB financial planning and the NAB advice licensees were not providing the advice services that they had contracted to provide in exchange for the advisor service fees that the trustee was paying to them.
That the MLC trustee, along with many other trustees, because it's not just superannuation that they're providing advice, not just our super fund or just superannuation. So what we understood was that ASIC did have a concern for the advice licensees in respect of what the industry now knows as fee for no service. The extent of that, or how much of that related to the superannuation business, or how many of our superannuation customers were affected, we did not know. And we expected that a review process put in place by the advice licensee and agreed with ASIC would determine the impact of whether or not the advice licensee whether or not they were providing advice or whether they were not providing advice for in respect of superannuation members.
Can I suggest this to you? That if the trustee was acting in the best interests of members, upon becoming aware of this issue, it would insist that these advice licensees that it was paying carried out a proper review to determine whether or not services had been provided in exchange for the fees.
I think the trustee expected that that would happen, and potentially, with the benefit of hindsight, should we insisted that happen quicker, then I would potentially think you're right.
And can I suggest to you that the reason that the trustee did not do that was because it simply could not manage the conflict of interests that exist between the NAB wealth business and the trustee?
No, I wouldn't agree that that is the reason.
Because the interest of the NAB wealth business was, as is apparent from the ASIC letter, in attempting to keep the fees and identify a justification for keeping the fees rather than assessing whether the contracted services had been exchanged for the fees.
So that is not a consideration that the trustee would ever take into account, whether it when it is acting in the interests of members. The trustee, my experience and my involvement on the board has been a very active board acting in the interests of members, and where there is wrong, either through error and a fee has been charged erroneously, or whether we find out that the advice licensee has not provided advice and needs to refund that payment, the trustee would not, under any circumstances, be thinking that we would be acting in the interests of the advice licensee or the bank over the interests of members.
Attend to that document, Commissioner.
Outline of suspected offending by NAB ASIC 0036 0002 2531 Exhibit 5.68.
Commissioner, could we bring up ASIC.0039.0003.0543? This is a letter from ASIC to Ms Cook, the General Counsel of the National Australia Bank, dated the 3rd of November 2017. Do you recall when you first saw this document?
I'd need to see the full letter to know if I have seen this document.
I'm sure a hard copy will be run up to you.
I don't believe I've seen this document before.
You don't think you've seen it even in the course of preparing to give evidence today?
No.
All right, let me ask you then about whether you're aware of some matters that are stated here. You see in the paragraph at the bottom of the page, it said, "We also note that the approach proposed by NAB is out of step with some of its major peers that have reported fees for no service failures and are close to finalising their customer review and remediation programs for these failures."
Yes, I see that.
Were you aware of that fact?
No.
I'm sorry, I should say, were you aware of that view of ASIC?
No.
You weren't aware that ASIC considered that NAB's approach to remediation of fees for no service was out of step with the other banks?
Not at this time, no.
When did you become aware of that?
At a meeting with ASIC on the 15th of June this year. Not 15th of June, a meeting in June this year.
Right, so the first time that you became aware of that was 2 months ago?
And whether or not ASIC, yes, that's correct.
So nobody in the advice business had communicated this to you before then?
No.
All right. And then if we go over the page to page 3, which is ASIC.0039.0003.0545.
Yes.
You see about halfway down the page, there's the heading NAB Further Review Methodology.
Yes.
And then you see in December 2015, NAB provided ASIC with a draft methodology.
Yes.
Were you aware that at the end of 2015, NAB had first proposed a methodology for assessing the extent of fees for no service?
No.
Were you never aware until now that that was the case?
Well, I assume by the letter in that was the one we were previously discussing, that there had been discussion around how NAB would undergo and undertake a review of advisor service fees. So when they put forward methodologies, I was not aware of, but I assume from that letter that there had been an exchange between ASIC and the group around a proposed review methodology.
But you weren't sure for how long this had been going
No.
on? Although presumably at some point in time, when you read that outline of contraventions, you must have known it had been going on for 2 years, because it... I can bring the document back up if that would help. I'll just find the correct doc ID. It's ASIC.0036.0002.2531. And if we go to page 12 of that document, which is .2542, you see paragraph 60, ASIC has engaged in extensive discussion and negotiation with NAB over the past 2 years.
Yes.
So presumably from the time when you received this document at the end of last year, you must have known that this had been going on for 2 years.
Yes, well, I mentioned earlier that the advice licensee and NAB had put in place a customer advocate role, and the distinction between how that role came to be and this matter, I'm not aware of the detail, and whether or not there's any difference between that role and how it came about to be and the concerns that ASIC now have.
Sorry.
So you've asked me a specific question, surely I knew. No, I didn't know.
I just want to be clear about what it is that you're saying you didn't know. You didn't know that there had been ongoing discussions for 2 years?
Yes, I did, but
Right.
I wasn't privy to the detail of those ongoing discussions.
Yes.
And so what I did know was that the customer advocate program had been put in place to review advice and the provision of advice services by an independent expert. And so I did know that there had been ongoing discussions with ASIC for some time, but what they were and whether that the customer advocate issues were the same issues that are being discussed now, and whether or not different issues were discussed in 2015 to 2017, I'm not aware of, because I was not part of nor privy to the discussions of the advice business nor what was being discussed with ASIC.
Understand. If we then go back to ASIC.0039.0003.0543, and we go back to page 3, which we were looking at, which is .0545.
Yes.
What I'm going to do is this, Ms. Smith. I'm going to ask you about some specific matters in this letter just to see whether you had been informed of them at some stage, and if so, when. And then I'm going to ask you what you think the position of the trustee ought to have been had it been informed of these matters, assuming that your answers are you weren't aware of them. So you see on page 3, it says, in December 2015, NAB provided ASIC with a draft methodology which proposed to undertake reasonable steps to gain an adequate level of assurance that customers who have paid to receive an ongoing advice service have been provided with the services as agreed in the service agreement between the customer and the advisor. You see that?
Yes.
Do you recall whether you were aware that at some stage the NAB had taken the position that it should review whether or not the contracted services had been provided in exchange for the fees that had been taken?
No.
All right. Can I suggest to you, had you been aware that the NAB proposed to undertake a review of whether the contracted services had been provided in exchange for the fees that had been taken, that you as the trustee would have been content with that?
We would have been content with that.
You wouldn't have had any issue with that. That would have been exactly what you would expect.
Yes.
That they would test, have we provided the services that we contracted to provide?
Yes.
All right. And then if we go over the page to page 4, this deals with some sample testing that was done. All I want to know is, were you aware that sample testing was done by NAB advice licensees as to whether the contracted services had been provided?
I knew that there had been sample testing done, but I was not aware of the purpose of that, or whether it was to test the provision of service.
All right.
And I will say that I'm not sure I knew whether it was being done in this context or the context of the Customer Advocate program, which was about reviewing files and determining which files should be reviewed first, and that program of work that the trustee did understand was ongoing and had discussions with the Customer Advocate and presentations from the Customer Advocate on.
And then if we go to page 5 of that document, which is ASIC.0039.0003.0547, you see the statement made by ASIC under heading 4 is, NAB's hypothesis for these sample tests was that it would identify no failures. After the results of the sample tests identified more failures than NAB had expected, disproving NAB's hypothesis, NAB changed its views for the purpose of its review.
Yes.
Were you aware that at some point in time, sample testing had identified more failures than had been expected by NAB?
No.
Were you aware that at some point in time, NAB had changed its view as to the methodology for testing whether services had been provided?
No.
You recall we looked at an email chain yesterday that was about fair exchange of value?
That I hadn't seen before yesterday, yes.
But I had understood you had been aware at some point in time of the idea of fair exchange of value.
I would need to go back to the email, and it is in this letter, and recall kind of what you asked me for yesterday.
All right, let me just ask you this then. do you recall being aware at some point in time that NAB had adopted the position that it ought to be able to retain service fees if there had been a fair exchange of value?
Well, not that I recall, no.
All right. Can I suggest to you that as the trustee, if you had been aware that that was the position being adopted by NAB, you would have objected to it?
So I think it kind of goes to the answer I gave a little while ago, which is what the trustee was waiting for was a methodology to be produced, and then turn our mind to whether or not we believe that was appropriate. And so that hasn't occurred, and we haven't seen that. But I would expect that the trustee would require that in order to pay a fee, we expect a service to be provided to the member.
Well, surely not a service,
The provision of advice.
contracted service.
Yes, that's right. Well, that's what I meant, sorry for the loose language, but that's what I mean, the
Understand.
provision of advice.
But the loose language is quite important here because there is a difference between charging a fee for a contracted service and charging a fee and then identifying a service that can be said to have been
So-
provided.
For someone that's worked in professional services,
Yes.
generally you're charging a fee for the provision of a service, and so the provision of advice. So it was not intended to be loose in any other way other than I expect if I'm charging a fee to a customer for my services that I'm actually providing the service.
All right. And if we go to page 6 of that document. You see there's 3 bullet points in the middle of the page. I just want to ask you whether you're aware of...
The big bullet points or the
Yes,
little
the
ones?
big bullet points. So you see the first big bullet point says, on 2 June 2017, NAB stated that if after its searches for digital data and attempts to obtain advisor attestations did not provide evidence of a customer-advisor interact and client does not respond to communications, NAB will conclude that there is inadequate evidence to determine that service was not provided. You see that?
Yes.
Were you aware that NAB had taken that position in relation to the methodology for assessing whether or not service had been provided?
I had no knowledge of the methodology that NAB had been proposing, other than that there was a disagreement between ASIC and NAB around that ASIC was not comfortable with what NAB had put forward.
Right, I tender that document, Commissioner.
Letter ASIC to Cook, 3 November 17, ASIC 0039 003 0543, Exhibit 5.69.
We then bring up ASIC.0015.0002.0296. See, this is a letter from NULIS to ASIC on the 1st of December 2015.
2017,
I'm sorry,
yes.
2017. Do you see that?
Yes.
And this is a document you've seen before?
If you go, I assume so.
Well, if we go to page 9 of the
I
document,
presume I might have signed it.
you signed it. Presumably you would have read it before you signed it?
Yes, and there was a review process put in place to for the letter to occur.
Right. So if we go back to page 1. You see 2/3 of the way down the page, the paragraph that says at the outset?
Yes.
And it says, at the outset, we would like to reiterate that it is the trustee's position that the PSF was properly applied to Master Key personal super accounts for the continued access to general advice and ongoing support services provided by the advisor that was linked to their account.
Yes.
Now, I just want to understand that. Was that an accurate reflection of your view of the basis on which the PSF was charged to members in the MKPS product?
Yes.
And one of the things we have some difficulty in understanding is the PSF is for a service agreed between the employer and the advisor. Agreed? And it is initially applied to the account of an employee in the Master Key Business Super product, yes?
Yes.
And then when the member transfers over to the Master Key Personal Super product, because they've
They're
left,
both the same product. They're a division of one product covered by one PDS.
when they transfer over to the Master Key Personal Super division of the product, because they have left employment with the
Yes.
employer, they continue to be charged the PSF.
Yes.
And at that point then, has the service that's to be provided changed, in your view, between when they were in the Master Key Business Super product and when they're in the Master Key Personal Super product?
It's still general advice services provided to the individual.
That states it at a level of generality that seems to enable keeping the fee regardless of whether the contracted service is provided. It's not simply a fee for general advice, it's a fee for the specific services agreed between the employer and the advisor. Agreed?
Yes, but also as the member moves into MKPS, it was for the same advisor who knows the member, who has provided services to the member, understands the product that the member is invested in and their individual circumstances to support the member and provide general advice services in the personal division.
Now, again, just so we can try to understand that, obviously now, NULIS has agreed to refund all of the PSFs charged to Master Key Personal Super members.
It has.
And you've explained that there are a number of considerations for that. One is the allegations of misleading or deceptive conduct that have been raised by ASIC.
In respect of the disclosure, yes.
Another is that the trustee cannot be satisfied that services were provided in exchange for the fee.
Yes.
And what I'm trying to understand is how the idea that this was a fee for access is reconciled with the idea that the trustee can't be satisfied that the services were provided.
I think it was a fee for services.
Yes.
And in the trustee's mind, members were receiving services.
Yes, your point is, I think, the trustee's position wasn't that it was for access to service, it was for service.
Yes.
And you understand those are two very different and important concepts. On the one hand, access to service, and on the other hand, service.
Absolutely.
And so insofar as this letter says that it's the trustee's position that the fee was for continued access to advice and ongoing support services, and then puts in brackets and in bold access to services, that is incorrect.
Yes, I believe so.
And can I suggest the reason that it is incorrect is because this was a negotiating tactic adopted by NULIS as a basis for not having to refund the money because there had been no services provided?
It was not a negotiating tactic adopted by NULIS, no.
Was it the position of NULIS that if the fee was for access to service rather than a fee for service, that it would not be necessary to refund the money?
Sorry, can you just say that again? I know it was only short, but
That's fine. Was it the position of NULIS that if the fee was for access to service
yes.
rather than for service, then it would be possible to retain the money?
No. The trustee, when it put the PSF in place, did so believing services were being provided to members.
Isn't this a letter from NULIS by which it's responding and rejecting to the outline of contraventions from ASIC in relation to the PSFs?
Yes.
And isn't a premise of the rejection of the contraventions that it was a fee for access to service rather than a fee for service?
I believe the letter does say that.
But that's a premise of rejecting the contraventions.
I can say in my mind, at the point of this letter, it was not in my mind that members were not receiving services for the PSF being deducted.
But why did you sign a letter saying that the fee was for access to service if you believe now and have always believed that it was a fee for service?
I would suggest that that was an error on my behalf, and in the 9 pages where we are setting out, our view of the letter, that I would say that was an error and not what I believed at the time.
It's on the first page
Yes,
of
I
the
know.
letter.
I know.
And it's the summary of the starting point for the trustee as to the basis upon which the fee was charged.
Yes.
You didn't draft it.
No.
Somebody else drafted it.
Yes.
Somebody within the wealth management business.
Yes.
And they gave it to you and you signed it.
Yes. Oh, yes, they gave it to me, I reviewed it, and I signed it.
And you say it didn't occur to you that this was an error?
My mindset at this point was that, of course, the trustee would charge a fee under the circumstances where it expected a service to be provided.
I tender that document, Commissioner.
Letter from NULIS to ASIC, 1 December 17, ASIC 00150020020296, Exhibit 5.70.
Can we bring up NAB.005.562.6921? So this is the papers in relation to the board meeting of the trustees on the 7th and 8th of December 2017.
Yes.
And you can see the relevant agenda item is advisor service fees.
Yes.
And what is recorded as having occurred at the meeting was that the directors noted and discussed Ms Pryor's paper dated 27 November 2017 entitled Risk Review of ASF Controls.
Yes.
And if we go over the page to .6922, So this is the first page. I just want to direct your attention to certain matters. This is concerned with advisor service fees rather than plan service fees.
Yes.
And you see the purpose of the paper is to provide the NULIS board with an overview of risks findings from a review of the adequacy of controls in place in relation to advisor service fees.
Yes.
And if you go down halfway down the page, you see a paragraph which explains in relation to a change to NULIS's risk appetite. This followed a number of ASF reportable breaches and issues that have been discovered and reported since 2015, coupled with ongoing regulatory enforcement action on ASFs and plan service fees across various NAB group licensees.
Yes.
And then you see in October 2017, ASIC has provided a position paper to NAB covering various NAB group licensees, including NULIS concerning ASFs and PSFs.
Yes.
And ASIC sets out its expectations in relation to fees for no service and remediation.
Yes.
And can I suggest that position paper must be the outline of contraventions that we were looking at earlier?
I expect so.
And do you recall whether that was considered at the full board level of NULIS?
Yes. I mean, to be absolutely accurate, I would have to go and check the board papers, but all ASIC correspondence, and particularly relating to these matters, have been discussed and seen at the full board.
All right. And then you say, of note, in the of note, in the context of PSF, ASIC observes that NULIS has no knowledge of whether the services are provided to customers, and NULIS does not require the plan advisors to provide the services. See that?
I do.
And then it goes on to say, whilst not stated by ASIC in the paper, it is possible that perspective of ASIC could be extended to ASFs, given that both ASFs and PSFs are trustee-facilitated expenses of the fund, to which arguably the same duty of care applies under best interest duties in the relevant SIS covenants.
Yes.
Was it your view that the trustee's duty of care in relation to its members extended to considering whether or not services had been provided in exchange for the ASFs?
For the ASFs?
Yes.
I think both ASF and PSF, yes.
All right. And it was also your view that the best interest duty of the trustee required it to consider whether or not whether services had been provided in exchange for the ASFs?
Whether or not, so I won't give you're asking me a legal question as to whether or not I think best interest applies in specific circumstances. I expect it's a requirement of the trustee in making in order for it to be a valid deduction from a member's account, that we have appropriate controls in place to determine that the payment is valid. And we would expect that if we are paying an advisor service fee, it is to an authorised advice licensee, and we have appropriate authorisation to make the payment, and that service would be provided. In short, I would expect that for PSF, we expect that services are provided in respect of the fee in order for it to be a valid deduction from the member's account.
Just so I understand, though, your view as to the nature of the duty of the trustee, does the trustee have a duty to monitor whether services are provided in exchange for fees?
I think I would say we have a duty to ensure that the payment is valid, and how we go about determining the validity of that payment is different for both ASF and PSF. And and that we have controls in place to ensure that we are making a valid payment, which would, in its premise, mean that services are being provided to the member.
We go over the page to .6923. You see there's a heading which is summary of findings,
Yes?
and then you see the second paragraph says, however, it is important to note that there are controls in place to 1, check that fees are paid to licensees,
Yes?
2, monitor excessive advisor service fees,
Yes?
3, obtain member consent prior to charging or changing an ASF arrangement,
Yes?
and 4, disclose the amount of the ASF charged to the member.
Yes?
Now, that though, can I suggest, doesn't extend to actually monitoring whether whether the contracted services are provided in exchange for the fees.
No. At this point, the trustee has a series of controls in order to believe it is paying a valid and authorised advisor service fee from a member's account.
Well, we'll come to that in a moment. Then you see at the bottom of the page, there's a heading which is next steps. Actions to remediate and uplift the control environment will be worked through with executive management.
Yes?
I'm just trying to understand, in relation to remediation, is that something that you would expect to have been left to executive management and risk rather than the trustee itself having a direct involvement in?
The trustee does not design controls. So, yes, I would expect that it is management's job to develop and design controls to manage the risk of the trustee.
I'm sorry, I think actually, to be fair to you, I think you're making a point which is I've actually misunderstood that sentence, which is actions to remediate is part of a compound phrase, which is actions to remediate and uplift the control environment.
Yes?
The remediate is not about remediating customers who haven't had
No.
services provided. It's just about fixing the control
It's
environment.
about the control environment.
I understand. And your point is, of course, that's a matter that we need to leave to risk and the executive management team.
Yes, with appropriate reporting back to ensure that it has occurred and that the control environment is appropriate to manage the risk and ensure that in the context of advisor service fees, valid payments are being made.
And then if we go to page .6925, see, this is the appendix to the paper which sets out further details on risks findings.
Yes.
And you can see summary of observations. Risk considers that overall the control environment as it relates to ASFs requires improvement to enable the trustee's expectations to be met in relation to its conduct risk appetite.
Yes.
And then you see 2/3 of the way down the page, key observations are outlined below.
Yes.
And the first key observation is all fees paid to advisors, and the summary of the observation is overall ineffective.
Yes.
And it explains that there are some controls in place that have been improved recently,
Yes.
but that there is no finance reconciliation performed to ensure that all ASFs are paid on to advisors and not retained by NULIS.
Yes.
And as it turned out, perhaps I have the time wrong, but there was a breach, or there has been a breach notified to ASIC, which I think you refer to in your statement, of advisor fees being retained by the trustee rather than passed on to advisors.
Yes.
And do you recall whether that was before or after this identification of the lack of controls?
I believe it was before.
Right. So the breach had already been reported, and what's being reported by risk to the trustee is that it describes the controls to ensure that ASFs are passed on to advisors as non-existent.
Yes.
And
Well,
then
yes.
and then it's explaining then in the next point, this is, I think, what you're talking about then, the current reportable breach being remediated in relation to an automated fee payment suppression control.
Yes.
And that's presumably a subset of a potentially larger issue of fees not being passed on to advisors. That is the first point. I'm sorry, the second point, there is no finance reconciliation, is to do with generally whether there is any control over or checking of whether advice fees have been paid on to licensees.
Yes.
And then the last point is in relation to a effectively subset of that, which is there was a particular system issue that automatically suppressed payments to advisors.
Yes.
All right. And then if we go over the page to .6926, the next key observation is monitoring of fees against services provided. That's described as non-existent. You see that?
Yes.
And it said NULIS does not have visibility of monitoring of fees against services.
Yes.
And then you see the fourth bullet point down, customer consent to advisor service fees dash initial plus ongoing changes.
Yes.
And that's described as ineffective.
Yes.
And in addition, the second bullet point from the top, the controls over fees are reasonable, commensurate with expected service, is described as ineffective.
Yes.
And then the fifth bullet point from the top, obligation and control documentation is also described as ineffective.
Yes.
And then the point at the bottom of the page, advisor onboarding enhancements are also described as ineffective.
Yes.
And insofar as this is raising concerns about the controls as they will apply in the future, as I understand it, the trustee was addressing that by requiring risk and executive management to remediate the controls.
Yes.
Insofar as those controls had failed in the past and resulted in members being charged fees for services that they should not have been charged, what steps did the trustee take to address that risk?
At this stage, I would say the trustee has not done a look back or decided to do a look back as a result of these findings. What has happened is a report into the Risk Committee in February of this year in order to have a report from the management team on what they are doing and when those controls will be remediated. While I would make only one comment in respect of this, that this was, I'll make two. This was a review asked for by the board as a result of the succession of events that the board had seen coming through in respect of advisor service fees. While there are some instances of saying no control or ineffective, it doesn't mean that there are no controls in place and that that we expect necessarily it would result in wholesale or even more than what we already know of advisor service fees being paid where they are not valid. As the control uplift occurs, as we saw with, I think it's the advisor service suppression event in my witness statement, as we put in place controls, that event was actually found through a control uplift program. And so as the controls are put in place, I would expect that any issues or concerns around whether or not there have been failings that led to issues would come out in the uplifting controls, and that would go through the reporting process, etc., to remediate customers where errors have occurred.
Just if you consider this, your point is just because there's a failure of or there are inadequate controls doesn't necessarily mean that there are more incidents of fees being charged for services that have not been provided than are already known about.
Correct.
The problem is no review has been done to figure out whether or not fees have been charged where the services haven't been provided.
So I expect as these controls get put in place, in the same way with the advisor suppression event that occurred, that event came to fruition and understanding as a result of a program to uplift controls, and that's where the issues and event that was raised for that were actually found. So as these controls are put in place, part of that process will include and bring to would kind of become obvious whether or not any further errors that we don't already know about have occurred.
Are you saying that for the period from 1 January 2009 to 31 December 2015, which is the period, the subject of the disagreement about methodology as between ASIC and NAB, that you think the improvements in risk controls, when they eventually come into operation, will help to identify any failures to provide services back then?
So I'm not sure if I'm answering your specific question, but I expect that the advice licensee, in its review of whether or not a service has been provided, will ensure that any superannuation members who have paid an advice fee and not received a service will be identified during that review process and will be remediated by the advice licensee.
Tender that document, Commissioner.
Extract from board papers, MLC nominees, PFS nominees, NULIS 7 and 8 December 17 concerning advisor service fees, NAB 005 562 6921, Exhibit 5.71.
Can we bring up ASIC.0036.0001.5091? Now, Ms. Smith, this is a letter sent by NAB on the 15th of December 2015 in response to that outline of suspected offending that we've looked at.
15 December 17, I
I'm
think.
sorry, Commissioner, 15 December 17 that we've looked at.
Yes.
Have you seen this document before?
I'm not sure if we responded jointly or separately to the 15 December in respect of ASIC's inquiries. So what I mean by that is whether the trustee responded separately to the advice licensee. So I would need to look through this further.
Right, well, if you go to the next page, and then, in fact, why don't we go to the last page, page 3.
I don't believe I've seen this letter signed by John Sharp.
Right, I tender that document, Commissioner.
Letter 15 December 17, NAB to Mullally at ASIC SIC 0036 0001 5091, Exhibit 5.72.
Can we bring up ASIC.0036.0002.0913? This is a letter dated the 8th of January 2018 from ASIC to Ms Cook at NAB.
Yes.
Have you seen this document before?
I'd prefer to look at the whole document to decide whether I've seen it, not just the front page.
There's a hard copies being provided.
Give her a chance to
I don't believe so.
All right. Commissioner, I'll just tender that document then.
Exhibit 5.73, letter 8 January 18, ASIC Cook, ASIC 0036 0002 0913, Exhibit 5.73.
Can we bring up ASIC.0036.0001.7316? This is a letter from NULIS to ASIC dated the 29th of March 2018,
Yes,
and
I signed it.
you signed it. You've seen
Yes.
this document before.
I have.
And if we go over the page to page 2,
Yes,
and you see the heading No Obligation PSF Conduct,
yes,
and we've talked about what ASIC calls the No Obligation PSF Conduct already
Yes.
this morning. And you see again the statement, NULIS deducts PSFs from Master Key Personal Super members after they have left their employer for access to services described in the PDS as group-based advice.
yes,
And then you see the third bullet point, NULIS does not require plan advisors to provide services.
yes,
And then the fourth bullet point, NULIS has no knowledge of whether these members receive any services in return for PSFs paid.
yes,
And then you see NULIS maintains that, and number 1 is the PSF was deducted from MKPS accounts for the continued access to general advice and ongoing support services provided by the relevant advisor linked to the accounts.
yes,
And point 3 is MKPS members have accessed the services on an as-needed basis to obtain this general advice.
yes,
And then point 4 is plan advisors are required to provide these services when requested by the MKPS members.
yes,
And this appears to be consistent with NULIS continuing to maintain that the PSF is charged for access to services rather than for services. Do you agree?
I think this is a statement of fact at this point in time, yes.
But it's a statement of fact that does not reflect your view
Yes.
as to the basis
The
upon
need to-
which...
Yes, correct.
And again, do you have an explanation that you want to offer to the Commissioner as to why you signed this letter, given that it did not reflect your view as to the basis on which the PSF was charged?
So I would make 2 comments. I think that at that point, the trustee was looking to inquire and make further inquiry as to whether or not we could determine whether we had any view whether services were in fact being provided. And at this point that this letter was approved, the trustee had asked for further work to be undertaken by the Breach Review Committee in respect of the monitoring it had in place and whether or not we could make a determination that services were being provided.
I'm sorry, I don't understand. the statements made by NULIS in this letter are that the PSF was deducted for continued access to advice and services rather than deducted for advice and services.
Yes.
And your explanation for why you signed the letter in this form is what?
That at the point I signed the form, this was the conclusion that management had drawn. And at the point I signed the letter, I also asked for further work to be undertaken in respect of the monitoring that had been in place over planned service fees, and that for a determination of the associated breaches, if the trustee could not conclude that services had been provided, be considered by the Breach Review Committee, and that would have an impact on the proposal being put forward to ASIC at this point in time.
You're saying simultaneously with signing this letter, you asked management to undertake some work to determine whether they could be satisfied that services had been provided?
Whether they could satisfy the trustee.
That services had been provided?
Yes.
And because you had requested management to determine whether services had been provided,
Yes.
you signed a letter to ASIC
Yes.
asserting that the fee was for access to service rather than the provision of service.
I would say in hindsight that I think I would choose different words to describe how I believed the PSF worked and the basis with which I had thought about the PSF up until this point. Notwithstanding, I signed the letter at this point in time.
Again, can I suggest this was part of a positioning for a negotiation with ASIC over what remediation NULIS would have to do?
Yes.
And we see then halfway down the page that NULIS makes the statement, or you make the statement on behalf of NULIS. NULIS's primary focus is its members, and NULIS considers that it is appropriate to take a proactive member-centric approach to resolve ASIC's concerns.
Yes.
And then it says, furthermore, whilst NULIS and ASIC may not agree on these issues, it is clear that ongoing dialogue concerning these issues is time-consuming and expensive for all involved and is likely to delay any resolution of ASIC's concerns.
Yes.
And one of ASIC's concerns was that this was a fee for service, not a fee for access to service.
Yes.
And that was being said by NULIS to be a matter that it was disputing with ASIC.
I'm not sure where it says we're disputing that with ASIC.
Well, you knew that ASIC was saying that this was a fee for service rather than a fee for access to service?
Yes, and I believed it was a fee for service.
And you believed that it was a fee for service?
Yes.
And nevertheless, you signed a letter saying it was a fee for access to service?
Yes.
And
I'd also signed off multiple other pieces of correspondence that said words like, it is a fee for access to and the provision of ongoing service.
then you see the next paragraph is NULIS intends to implement a remediation process to resolve ASIC's concerns.
Yes.
And NULIS is suggesting that it will implement this proposed remediation program and then that way further regulatory action by ASIC won't be required?
Yes.
NULIS is seeking to resolve the entire issue by the remediation program it is proposing?
Yes.
And then we see the next section down, details of the PSF remediation scheme.
Yes.
And the first sentence is, NULIS considers that the PSF remediation scheme is the most accurate and fairest method to remediate all MKPS members, not only the transferred members.
Yes.
And it says this will place MKPS members in the position they would have been in had the disclosures about the option to reduce the PSF to zero been made in the manner ASIC suggests.
Yes.
And what that refers to, can I suggest, is this, that ASIC has raised two issues about the PSFs. The first is the one that we've already spoken about, which
Yes.
is that it is a fee for service and not a fee for access to service.
Yes.
So it should not have been charged unless a service was provided.
Yes.
And the second was that in any event, the product disclosure statement and other documents providing to members were misleading because they did not tell the members that they could reduce the fee down to zero.
Yes.
And what NULIS is doing is suggesting that the basis upon which it will remediate is on the premise that there was a problem with the disclosure, rather than that there was a problem because the fee could only be charged if a service was provided.
So I go back to the comment I made at the previous point. The proposal that was, or the remediation scheme that this letter was based on was based on a recommendation and analysis by the management team that was only about disclosure. And the trustee believed at that point in time that further work needed to be done in order to determine whether or not the trustee, the remediation program and the trustee had, to go back to use ASIC's words, or to go back to the point of saying if a service hadn't been provided and we couldn't demonstrate, or we didn't understand or couldn't turn our mind to satisfy ourselves that a service had been provided, that it would affect the remediation program.
None of that is explained in this letter, is it?
No, but it was minuted by the trustee delegates in turning its mind to the remediation program that was put in front of it at this point in time.
And just so we understand what you mean by that, the trustee delegated to two people on behalf of the trustee to make the decision to approve the proposal for remediation.
Yes.
And those two people were you and Peggy O'Neill.
Correct.
And what you're saying is what management put in front of you and Miss O'Neill was this.
Yes.
And therefore, what else could you do?
No, well, what else we did was ask for what we felt were shortcomings in the review process that had been undertaken at that time to be dealt to by the Breach Review Committee. And on that, there would be review as to whether or not this was deemed to be an adequate but an adequate proposal put to ASIC.
And the way the proposal worked was this. It's summarised at the bottom of the page. The PSF remediation scheme would involve the following. You see, I'm sorry, we'll just wait for that to come up. 1, NULIS will identify all MKPS members who are charged the PSF.
Yes, because at this point ASIC didn't have an issue with entire members. They'd only raised an issue with us around transferred members, which was a much smaller subset of the membership. The trustee did not believe that it was appropriate to only look to remediate a very small subset of MKPS members. So if you go back to the previous page where it refers to transferred members.
Yes, that's...
It was a very specific set of transferred members, not all MKPS members.
Transferred members are the members transferred from the
No.
MKBS to the MKPS.
it was a defined set of members by ASIC that related to, I believe, around $7 million worth of PSF fees that had been paid.
I see. And the proposal is for MKPS members, if we go over the page, that NULIS will write to each member
Yes,
and offer the member, explain to the member the services that the member could access for the PSF.
yes,
Again, that's on the false premise that this was a fee for access to service rather than for service.
no, it was to also, no, I don't believe so.
Well, we agree, don't we? It was a fee for service rather than a fee for access to service.
Yes, and our disclosure was not explicit on the types of services the member could expect to receive from their advisor.
This isn't about telling them these are the services you should have received. This is about telling them these are the services you could access for the PSF. That's what it says. The services that the member could access for the PSF.
Yes,
And then D, what will be offered to the member is the opportunity to retrospectively opt out of the PSF.
yes,
And so if a member returns an election form or calls the NULIS Customer Service Centre, then they'll receive a refund.
yes,
And then once whatever the allocated time period for a response is up, NULIS will then consider what to do about people who haven't responded.
yes,
And it says in 3, the communications with members will clearly explain the reason for the PSF remediation scheme.
yes,
And those reasons would presumably reflect the continued premise being put forward by NULIS to ASIC that this was a fee for access to service rather than a fee for service.
no, that was not the discussion in the meeting at the time.
Nobody discussed what would go in the communications to clearly explain the basis.
No. But my, that's okay.
I tender that document, Commissioner.
Letter 29 March 18, NULIS to Malalia ASIC, ASIC 0036 001 7316, Exhibit 5.74.
Commissioner, I'm just concerned, is that a convenient time? I'm concerned
Yeah.
that the witness has now been giving evidence for
2 hours.
an
If
yes,
I come
almost
back
2
at
hours.
25 to midday.
Could I, oh, it's 11:30, perhaps if you come back, give the witness a 10-minute break, Commissioner? I'm sorry,
The witness or counsel, Mr Hodge, 20 to midday.
thank you, Commissioner.
Yes, Mr Hodge.
Thank you, Commissioner. Can we bring up NAB.005.562.7367? And then if we can go to, I'm sorry, I should just indicate, these are the papers in relation to the board meeting of the trustee on the 18th of April 2018.
Yes,
And then if we can go to page 86 of that document. Should be underscore 0086. Thank you. So this is the agenda item in relation to a paper being presented by Mr. Marriott to the board about the planned service fees.
Yes.
And the director, you can see what happened was the directors discussed and noted the paper.
Yes.
And then if we go over the page to underscore 0087, you see the paper summarising what has happened since the last meeting of the board on the 28th of February, 1st of March.
Yes.
And it's noting that at that earlier board meeting, it had been resolved to delegate the authority to you and Ms O'Neill to approve management's recommendation proposal in relation to PSFs.
Yes.
And this is the point you were making before, that management came and put a proposal to you
Yes.
and you approved it.
Yes.
And that discussion and approval occurred on the 19th of March 2018.
Yes.
And the proposal was, as we've already seen, one that followed the principles that would apply for misleading or deceptive conduct.
Yes.
And then we see the delegates approved the proposal to be submitted to ASIC.
Yes.
And the second point is no admission of liability, compensation to be paid on an ex gratia basis rather than as a compensation payment for loss suffered as a result of a breach.
Yes.
And then the bullet point after that is intention to remove the PSF from the small proportion of current members currently paying the PSF.
Yes.
And then further down you see management are undertaking further analysis in respect of members paying larger PSFs by dollar value, which management do not currently believe is a breach, noting that it is subject to further advice and is yet to be considered by the Breach Review Committee.
Yes.
Now that seems to be management undertaking some further review that is different from the further review that you described 20 minutes ago.
It was including the actual fees charged to members, and it included where members had appeared to be paying fees larger than we would have expected in respect of the planned service fee for general advice services.
Now you see, we just need to make sure we've got this as clear as possible. What this paper seems to be recording is that the analysis that management was going to do was in respect of members paying larger PSFs. You agree?
Paying, yes.
And the point you're making is the reason that was an issue was because it appeared as if some members were paying larger than expected PSFs.
And that our monitoring had not identified that, and our monitoring didn't, yes.
Pick up that they were paying such high PSFs.
Higher than we would have expected, yes.
And that seems to be a different thing from what you had indicated to the Commissioner earlier, which was that the review that was being undertaken was a general review into whether services had been provided in exchange for PSFs.
No, we couldn't, we had discussed whether or not we would be able to do a review of whether or not services were provided. But essentially, over 70% or roughly 70% of the planned service fee are actually charged by external financial advisors, so not related. And we needed first of all, a remediation strategy that could be applied across all our members. So while we might have been able to go and test related party planners and whether or not they were providing services. We didn't believe we could extend that to all our members, and so that wasn't seen to be an appropriate approach in the context of determining the provision of services. I didn't intend to be misleading in my commentary before, but essentially what we were looking into was our monitoring of the PSF, and that would, in my view at the time, give us more information as to what was going on and determine whether or not the trustee could make any other determination other than we didn't have evidence to be able to say categorically that members were receiving services and so would affect the remediation program.
When we were addressing that issue before the break, you recall we were addressing it in the context of the difference between a fee for an access to service and a fee for service.
Yes.
And we were discussing the fact that the letter from NULIS to ASIC continued to present the position that it was a fee for access to service.
Yes.
And you were explaining that although the letter was incorrect in asserting that, because that was not your view, that you considered it to be a fee for service.
They weren't my words that I would use to describe the PSF, yes. Albeit that I signed the letter.
Because you considered it to be a fee for service, I had understood you to be saying that you had asked management to look at what evidence there was of services having been provided for the fees. Was that not what you were saying?
It was to look into what monitoring the trustee had in place in respect of PSFs and to consider the controls that the trustee had and whether they were adequate for us to be able to make a determination of whether the trustee had in fact, could turn its mind to say that yes, services were being provided.
I see. So your evidence was, and at this point that this letter was approved, the trustee had asked for further work to be undertaken by the Breach Review Committee in respect of the monitoring it had in place and whether or not we could make a determination that services were being provided.
Yes. That would include, and while I wasn't specific at the time, it did include a review into members who were paying fees that were higher than what we expected.
This board paper suggests that it was limited to reviewing fees that were higher than what were expected.
It was at the time, the intent of the delegates was for the trustee to determine whether or not it had any further breaches in respect of the element of the no obligation or whether or not we could determine services had been provided.
But none of that was written down.
We did have minutes of that particular meeting.
Oh, I see, of the meeting of the delegates with the
Yes.
executive management.
Yes.
All right. Have you seen those in the course of preparing for this?
No, but I would have reviewed them after the meeting.
All right. And do you recall that they recalled that what was to be investigated was whether there was a breach because services were not provided in exchange for the fees?
I don't, but what we did discuss in the meeting and what the delegates were specific on was understanding what the trustee had actually breached, and we didn't believe that all necessary review had been undertaken for us to make that analysis at that time, and that was what we were expecting to come back to us once that review had been undertaken and completed.
I thought you said a moment ago that because 70% of the PSFs were being paid to external advice licensees, it was not possible to review or practical to review whether or not services had been provided by them in exchange for fees.
So what I was expecting was that we were asking management to turn their mind to all of the controls that the trustee had in place, including a review of the actual monitoring we had over the fees being paid, and to come back with a position on whether or not the trustee had breached any further requirements.
Right, let me make sure that in summary I've understood the evidence that you're giving, which is that in order to attempt to reach a resolution with ASIC, you put forward one position, which was that it was a fee for access to service rather than a fee for service, and a remediation proposal, which was an opt-in remediation proposal.
I think at the point the opt-in remediation proposal was considered valid was around disclosure breaches. And I think you mentioned that before.
And so you say were actually going to get management to go back and check whether there was a different breach, which was a breach of not having provided service for the fees. Is that right?
Well, we weren't providing the service. Whether or not the controls we had in place were appropriate in respect of determining whether or not a valid service had been provided to a MKPS member.
I don't understand why you would need to investigate that. You have a risk report that we have already looked at, which says you had no controls for determining whether or not services had been provided for fees.
I think that review was in respect of advisor service fees.
You think it was only for advisor service fees?
I need to go back and look whether it called out PSF. So I recognise that that we did have a review calling out weaknesses in controls. I think what the trustee was trying to do at the March meeting was ensure that all relevant factors in respect of breaches it may have made had been appropriately reviewed and considered.
Let us assume for a moment that that ASIC had accepted the opt-in proposal. What would have happened in relation to this further review that was apparently being undertaken?
It would have come back to the trustee delegates.
And again, you say you were making a proposal to ASIC to resolve the entire issue in relation to PSFs, but with the contemplation that in fact you might discover that there had been no services provided in exchange for the fees.
Sorry, can you repeat that again?
Yes, let me break it down. You were seeking to resolve this with ASIC, the entire PSF issue, on the premise that it was a fee for access to service rather than a fee for service?
No, it was based on it being a disclosure breach and it being that we had not disclosed that the member could turn the fee off.
The letter that you sent to ASIC with the proposal says NULIS's position is that it is a fee for access to service.
I've already agreed that in my mind the trustee would be charging or would be deducting fees for the provision of service. And while I did sign a letter saying access to, it was never my view that we would deduct fees for the mere access of services being offered.
This review that you say you asked to be undertaken, had that been completed by the time you finished as the chair?
I would say that the conclusion that the trustee was looking for in respect of whether or not we could conclude that our controls were appropriate to determine services, sorry, it's a very long-winded answer, I realise, that services had been provided. had been concluded and that there was a proposal of full remediation that was put to ASIC prior to me finishing my role as the chair.
But what happened was that ASIC rejected the opt-in proposal.
Yes, they did.
And ultimately then, the continuance of this negotiation was that NULIS agreed to return all PSFs to MKPS members.
It did.
And it did that because ASIC refused to accept its proposal for opt-in remediation.
No, I don't believe so.
Can I tender that document, Commissioner?
Board papers, NULIS board meeting 18 April 18 concerning planned service fee NAB 00556273767 exhibit 5.75.
Now bring up ASIC.0039.0001.1729. This is a letter to a number of people within ASIC dated the 13th of April 2018.
Yes.
And if we go to the third page of the letter, .1731, we see it's a letter signed by Ms. Cook, the Chief Legal and Commercial Counsel for NAB.
Yes.
At some point, you've looked at this letter.
I'd like to see the full letter. I don't believe I've seen it before.
Right, can we have the full letter provided to Ms. Smith?
I don't know whether or not I've seen this. I don't believe I have. I did attend a meeting with Ms. Cook and ASIC where there were materials were tabled at that meeting, but I don't know whether this was part of those.
Well, let's put that document on one side of the page, on one side of the screen, and on the other side of the screen, can we bring up ASIC.0036.0002.3180? So you see on the right-hand side of the screen is a letter dated the 9th of May 2018 to you and Ms. Cook.
Yes.
And you see that under the heading Suspected Misconduct by NAB Group, we refer to your letters dated 29 March 2018, 13 April 2018 and 8 May 2018.
Yes.
You, I assume, would have read this letter addressed to you.
Yes.
Given that it refers to 3 letters sent by NAB to ASIC, would you have also sought out and read those letters?
I did not. I did ask what letters they were referring to and was of the understanding that I did not seek out and read the letters in respect of the advice business.
I see. When you got this letter on the 9th of May 2018,
Yes.
you asked about those letters?
Whether they were letters in respect of the trustee business, yes.
And again, the advisor service fees issue, do you see that as not an issue concerning the trustee business?
The remediation and the agreement of the remediation of the advisor service fee matter, I do not believe it is my role to be negotiating or involved in the negotiation of that with the regulator.
But is it your role to say to the related party advice licensee to whom you have paid the money, your conduct is unacceptable?
I think I've already responded to a similar version of that question earlier, where I have talked about the response that the trustee has given and the things and it has undertaken. I'm still unaware exactly what the poor conduct is and the extent of the poor conduct by the advice licensee, and I believe the point of ASIC's review will determine the extent of the provision of advice services and the adequacy of that. So at this point, I know that the regulator is unhappy with the advice licensee in respect of the provision of advice services. What hasn't been demonstrated is who that relates to, how wide it is, and how extensive it is.
But you know the issue is, have services been provided in exchange for the advisor service fees?
Yes.
And you know that some of those advisor service fees have been deducted by the trustee from the members' accounts and paid to advice licensees.
Yes.
And you don't know, because nobody knows, because NAB has not done a proper review of it, in how many incidents and in how much of a total amount has the trustee incorrectly deducted from members' accounts and paid to the advice licensees?
Correct.
Surely that is something that the trustee should take not just an interest, but an active interest in.
I think I've already said that the trustee has taken an active interest in that.
Can we just focus for a moment on the letter on the left-hand side of the page, .1729? So you recall we looked earlier at documents showing the various permutations of proposals that NAB had made in relation to the methodology for determining whether services had been provided and whether refunds needed to be made.
Yes.
And you'll recall that one of the issues raised by the outline of contraventions from ASIC was an objection to the idea of NAB assessing whether there was some interaction between the customer and the advisor rather than whether the contracted service had been provided.
Yes.
Now, what you'll see at the bottom of this page is a new variation on a proposal from NAB, and that is, and you can see this in paragraphs 1 and 2, for post-FOFA customers, that is, customers who commenced their ongoing service arrangement between 1 July 2013 and 31 December 2015, NAB will undertake an automatic investigation and review of the arrangements during the relevant period. Do you see that?
Sorry, you're on page 1?
Yes, on page 1.
Yes.
But in paragraph 2, for customers who had commenced their ongoing service arrangement with NAB Financial Planning before the commencement of FOFA, that is between 1 January 2009 and 1 July 2013, NAB will offer the opportunity to request a review of service delivery under their ongoing service arrangements during the relevant period, that is to say, an opt-in process.
Yes.
Were you aware of this proposal having been put up by NAB to ASIC to try to deal with the question of whether services had been provided in exchange for service fees?
No.
You've never been aware of that? This is the first time you're hearing about it?
I may have, it may have been discussed in the meeting with ASIC on the 15th of, I believe the date was, I could have the date wrong. I attended a meeting with Sharon Cook, Miss Cook, after the 9th of May with ASIC, and there were representatives from the advice business in that meeting. I had, whether it was at that point, that it could have been discussed then, but I don't recall it, and I was not aware of an opt-in process.
And do you consider an process to be unacceptable as the trustee?
In terms of, I think that what the trustee would be looking for would be to ensure that all customers, when they have paid an advisor service fee, have been delivered a service. And if there is an issue with that clearly ASIC believes there is, I believe the advice licensee needs to be able to demonstrate for all members of the superannuation business where an advisor service has been paid, that service has been provided.
Do you recall at the meeting that you attended with Ms Cook and ASIC what the rationale was that was presented by NAB to ASIC for its approach to remediating advisor service fees?
Essentially, what was mostly discussed at that meeting was a commitment from the advice business to undertake a review in the form that ASIC was requiring, and so the opt-in, what I was saying is why I don't remember it. It could have been discussed in that meeting, so I can't say black and white that I haven't heard it before, but I don't remember it. That meeting was really focused on what NAB were proposing in respect of the resolution of the ASF review matter.
Can we go to page 2 of that document? I want to take you to some parts and see whether this brings back any recollection for you. You see in the second paragraph, it said, our approach may not be consistent with steps being taken by some of our industry peers. However, we consider a different approach is warranted given NAB led the industry away from commission-based advisor remuneration structures.
Sorry, what? Yes, I see.
Does that bring back any recollection for you of the position being taken by NAB at that meeting with ASIC?
No, so as I mentioned, the meeting with ASIC was really focused on accepting ASIC's requirements and document. I believe there was a document or a discussion. I'm not sure if it was actually documented in the meeting around what ASIC was looking for in respect of an advisor service fee review was being committed to by the bank.
Perhaps I'll frame the question more generally. Does this bring back any recollection for you of any explanation given by somebody within NAB as to the rationale for NAB's approach to remediating
No.
the payers of advisor service fees?
No.
All right. And then you see in the next paragraph, hindsight suggests that NAB may have been better served if we elected, like many of our peers did, to take the easier and more commercially attractive option of placing continued reliance on commission arrangements until the long tail of the generous grandfathering regime eventually runs out.
Yes.
Do you recall being informed by anybody within NAB that NAB considered that in hindsight it might have been better served if it had simply elected to stick with commissions rather than moving to fees for service earlier?
No.
And then in the fourth paragraph, you'll see asking that NAB now conduct a historical pre-FOFA review of how we transitioned customers, advisors and product issuers to fee-for-service arrangements in circumstances where there was no corresponding regulatory requirement to do so, challenges whether NAB ought to have taken a leadership position in this regard. And then you'll see also, but for the changes, the pre-FOFA customers would have continued to be in commission-paying arrangements.
Yes.
Does that bring back any recollection for you of having been informed by anybody from NAB that what is set out here was a reason why NAB didn't think it should have to check whether it had provided services to customers who had entered into ongoing service agreements before 1 July 2013?
No.
And so that we can be clear, what this paragraph appears to be saying is that NAB's position was that if it had just stuck with commissions for pre-1 July 2013 clients, it wouldn't have had to have provided any services in order to be entitled to the money. And therefore, where it entered into an agreement to provide a service in exchange for money before 1 July 2013, it shouldn't have to check whether it has provided that service in order to keep the money. Is that your understanding of it?
I would say I'm not sure of the intent behind what those paragraphs are, and I was not involved in any of the conversations or the preparation of this letter. I have not been briefed on the remediation approach being proposed here, nor the thinking that underpins this letter, so I would have to say I don't know.
Right. And you see the next paragraph? As you know, commission-based remuneration structures are opaque, lack any corresponding customer service obligation, and are not generally understood by customers.
Yes.
Is that a view you share?
I think that's a fair assessment.
And then if we go over the page to .1731, you see the heading ASIC's outline of suspect offending advisor service fees.
Yes.
And you see about halfway down the page the paragraph that begins to provide ASIC.
Yes.
And so what's being set out there is that an independent expert will be retained to test and assure the controls, design and operational effectiveness of this proposed approach.
Yes.
And the proposed approach, as we've seen, is that pre-FOFA service clients will have to opt in to be remediated, but post-FOFA service clients will be remediated where there's no evidence of service.
Yes, I think that's what the paragraph 2 on page 1 is saying.
And then you see the next paragraph. I note that ASIC has previously suggested that NAB consider making a community benefit payment in respect of this matter. Our preference is to provide for a more direct, relevant and effective use of funds. Accordingly, as noted above, we have taken the step of including a pool of $3 million for certain customers to receive further advice about their circumstances.
Yes.
And then you see the next paragraph after that. In terms of ASIC's request for a significant regulatory response, given the steps being undertaken, we do not consider that administrative action is a necessary way to conclude this matter.
Yes.
Now, that proposal seems to be, and I want to check whether you knew about this, that for pre-FOFA clients, they will get to opt in to say they didn't receive advice and therefore should get their fees back. That's the first part. The second part is that for post-FOFA clients, if there's no evidence of service having been provided, then they will get their fees refunded. The third part is there will be an independent expert who will test that process. And the fourth part is that rather than making a community benefit payment, NAB will create a pool of $3 million to fund further financial advice to affected customers, presumably by its own advisors.
So I don't know of any of the proposals in the paragraphs on page 1, nor the paragraph in respect of the $3 million. But I do believe the customer advocate program also involved an offer of financial advice to customers of a member's choosing, so not it didn't have to be within the group.
Had you been advised of this proposal, would you as the trustee have considered it adequate?
I think that I probably have already answered that in the context of saying that my view is that where we have paid advisor service fees, whether it be pre-FOFA or post, there would need to be an understanding of that services were actually provided.
So the answer to my question is no. Had you been advised about it as the trustee, you would not have considered it adequate?
Based on the limited conversation we've had, I would suspect the answer is no. I would not think it was adequate. And
just, I think, to enable you to comment on the particular part of the proposal that would concern you, can we go to page .1743? And you'll see this is Appendix B setting out what will happen for pre-FOFA clients.
Yes.
And the first step in the pre-FOFA clients process is that NAB will write to the pre-FOFA client on one occasion.
Yes.
And you see it says the correspondence will, and then there's a number of things that the correspondence will do.
Yes.
And E is inform the pre-FOFA client that they have 6 months to contact NAB to request a review of their OSP, which would be
ongoing service
arrangement. And then F is request that the pre-FOFA client attest that they didn't receive the service.
Yes.
And then step 2 is for pre-FOFA clients who contact NAB within the 6-month period, and then everything else follows for that.
Yes.
And it's that particular part which is that in order for there to be a review of whether the service has been provided, the pre-FOFA client has to contact NAB within 6 months and attest that they didn't receive the service. That is the part that you, as the trustee, had you known about it, would not have considered acceptable.
So I think the trustee would need to turn its mind to understand what the difference the organisation thinks between pre-FOFA and post-FOFA is, and consider kind of whether or not, on face value, you need to demonstrate that advice has been provided. I'm not sure whether there's a difference between pre and post FOFA. I would expect that we would be looking for ensuring that all members are appropriately remediated in respect of advice services.
You know what NAB says is the difference. We've looked at that part of the letter.
I've looked at a brief summary of a letter that I would expect it is based on far more information and detail. And so I think I've said to you, I agree that the review should ensure that services are provided to members and appropriate remediation. is provided when services are not.
I tender that document, Commissioner.
Letter NAB to ASIC 13 April 18, ASIC 0039 0001 1729, Exhibit 5.76.
Now, the document on the right-hand side of the screen, which we were looking at a moment ago, is ASIC.0036.0002.3180.
Yes,
And this is a letter to you and to Ms Cook.
yes,
And you recall having received this letter
yes,
and read it.
yes,
And you recall that ASIC rejected both the proposal that Ms Cook had made for dealing with advisor service fees and the proposal that you had made for dealing with plan service fees.
yes,
Attend to that document, Commissioner.
Letter ASIC to Cook and Smith 9 May 18, ASIC 0036 0002 3180, Exhibit 5.77.
Now, one of the things that was going on at the same time, of which you are, I think at least now aware, was that ASIC was raising an issue as to the number of occasions on which NAB had breached the requirement to provide a notice of significant breach as soon as possible, but in any event within 10 business days.
So at this time, what I was aware of was that ASIC had been undertaking a industry-wide review of breach reporting, of which the NAB group, including the wealth entities and NULIS, were participating in by providing information. We had received ongoing updates through the CRO report that review was occurring.
Did you know that ASIC regarded NAB as an outlier in the industry?
No, I did not.
I want to show you a document which is NAB.005.896.0001. Now, I'm assuming you haven't seen this document before,
No.
including in preparation for giving evidence.
I may have seen it on Sunday evening.
Okay. So this is a briefing planner for a meeting between Mr. Thorburn and Mr. Shipton.
Yes.
And if we go to page .0008 of that document, you see there's a section at the very top, breach reporting project.
Yes.
And I think you've referred to this, which is that you were aware that ASIC was undertaking an industry-wide review of breach reporting practices.
Yes, and that we had, I didn't want to quote section 33 because I thought I might get it wrong, but a section 33 notice, yes.
And you see the last sentence there is ASIC will likely seek further engagement with NAB about the extent of the issue, noting that NAB appears to be an outlier to industry.
I can see that.
But that wasn't a matter that you as the trustee had been told at any time?
Not while I was on the board, no.
Right. Is it a matter that you've now been told? After you
I
left the
didn't
board?
know. I didn't know that NAB was considered to be an outlier.
I tender that document, Commissioner.
Briefing planner for meeting of 26 April 18 between Thorburn and Shipton, NAB 005-896 0001, Exhibit 5.78.
Can we bring up ASIC.0039.0001.1797? But this is a letter from ASIC to NAB following up on a Section 33 notice, dated the 27th of April 2018.
Yes.
Now, this is a document that you saw in the course of preparing to give evidence.
I think it's attached to my witness
I think
statement.
you've exhibited it.
Yes.
And it notes, and this is what I want to direct your attention to, that in paragraph 1, we have attached a schedule with the current list of 110 breach reports from licensees within the NAB group lodged to ASIC between 2014 and 2017. It appears that all of these breach reports were lodged in excess of the maximum allowable 10 business days to report a significant breach to ASIC upon awareness.
Yes.
And I don't need to tender that document, Commissioner, that's already in evidence through Ms Smith. And then can we bring up ASIC.0039.0001.1776? And I think this document is also exhibited to your statement.
Yes, this was the response that was provided by NAB in respect for that letter.
That's right. This is NAB's response, and we can see about halfway down the page, based on NAB's data validation, there are 84 significant breaches which were reported to ASIC in excess of 10 business days out of a total of 297 significant breaches reported to ASIC in the 2014 to 2017 calendar years.
Yes.
And NAB has done a recalculation, the effect of which seems to be, we don't agree with all of the 110 that you have identified ASIC, but there are some that you've missed. And that's how they get to 84.
I don't know how they got to 84, but they've done analysis and determined it to be 84.
All right. Now, I'm trying to understand the fact of this deficiency in breach reporting by NAB to ASIC. That is something that you became aware of for the first time when?
In preparation for my witness statement.
And that was after you'd finished as the chair of the trustee?
Yes, but I will make one comment that I did talk about yesterday, that pre-2015 for the trustee, it had been identified that our breach review process was not as it should be, and we had an external review undertaken by PricewaterhouseCoopers, and improvements were implemented, recommended and implemented in respect of the breach review process for the trustee. And so I think, as detailed in my witness statement, the bulk of NULIS's non-compliance with the 10 days occurred prior to that uplift in control as a result of the review. I think there have only been a couple of instances of 1 or 2 days being late since the 2015 period. So what I was trying to, long-winded way of saying, yes, I did believe we had a problem pre-2015. We undertook an external review, took steps and actions in place to ensure we were meeting legislative requirements to report breaches within 10 days, and that we were largely complying with that requirement.
Just so we can break that down, or I can break that down. Your recollection is that there was an issue about the breach reporting by NAB in 2015, which prompted steps to be taken?
So I can't speak for NAB, I can speak for NULIS.
Well, let's just be clear about that. NULIS doesn't have its own internal breach reporting facility?
Yes, it does. Facility, so we use infrastructure, so databases and those sorts of things across the entire group, one system called RiskMart to lodge breaches into, etc. But the Breach Review Committee assessing breaches for NULIS is not NAB's Breach Review Committee. It does consider NAB wealth matters, but it's different to the rest of the NAB's process for reviewing and assessing breaches.
I think the question I asked you on the 7th of August was the Breach Review Committee is not within the trustee, and you answered correct.
Oh, so what I meant by that was the trustee does not sit on the Breach Review Committee, nor is it part of the trustee's formal committee structure. It's a management committee that operates under a charter that the trustee approves.
And it's
So
the
I-
charter within NAB Wealth.
It's a charter approved by NULIS.
But the Breach Review Committee sits within NAB Wealth.
Yes,
And it's the Breach Review Committee for all of NAB Wealth, including the trustee.
yes,
And insofar as the trustee complies with its obligations to report significant breaches to ASIC, it is, and also to APRA, it is dependent upon that Breach Review Committee sitting within NAB Wealth.
yes,
And the Breach Review Committee determines whether there has been a significant breach and gives notice to APRA or ASIC of the breach.
yes,
And then once it has done so, that is reported to the trustee.
yes.
Now, what I want to understand is, for the trustee, in its management of its relationship with NAB Wealth, does the fact of the number of failures to make a significant breach notification within the maximum allowable period of 10 business days raise an issue for the trustee?
So I think the report relates to the whole of NAB, as I understand it, and not just NAB Wealth. The trustee has not considered the findings from the ASIC review. It has not gone to the board yet. And I expect it will be discussed at the board, and I understand there are steps. I expect that part of that will be looking at whether or not further steps need to be taken to enhance the breach review committee process. But that has not happened, and it hadn't happened at the time before I left the board.
As Diaz is just pointing out to me, if you look at footnote 2,
Yes, I
Of
can
that
see that
document,
83 of
see.
them relate to NAB Wealth licensees.
all right,
Uh,
so
what I
83
don't-
Yes, go on.
So the improvements I spoke about in respect of the trustees' breach reporting would actually also be improvements for the other licensees. I have not reviewed the other licensees' late notices. I've just reviewed the trustees in responding to, in terms of drawing to attention the elements that actually relate to the trustee. I think if there was a systemic issue still continuing with the other parts of wealth in terms of not reporting, post 2015, that would potentially still be a risk for the trustee.
Attend to that document, Commissioner.
Letter ASIC to NAB of 15 May 18.
Sorry, you don't need to do that, Commissioner. I'm
No,
told that's
it's in.
exhibited to your exhibited to Ms. Smith's
Exhibited to
statement.
her statement. Very well.
Can we bring up ASIC.0039.0001.1173? This is a letter from NULIS to ASIC dated the 7th of June 2018,
Yes,
and it's signed by you.
yes,
And you see it refers to two letters that we've already looked at. Your letter of the 29th of March 2018, presenting the opt-in remediation approach,
yes,
and the letter in response from ASIC on the 9th of May 2018.
yes,
And it then says, we note your observations that the planned service remediation scheme does not adequately address ASIC's concerns. And then it goes on to explain that NULIS has considered those comments and is prepared to enter into the following arrangement to bring this matter to finality.
yes,
And it then runs through a series of things, one of which is in number 2, NULIS will fully refund all PSF amounts charged to MKPS members' accounts together with investment earnings.
yes.
Now, just so I understand, the reason for that change of position was what?
I believe it was based on the facts that were put, that the trustee so what didn't, I believe it was based on the facts that of the matters that I talked about earlier, that the trustee delegates asked to be reviewed by the Breach Review Committee.
Are you saying that at some time between the meeting between you and Ms O'Neill and management and this date on the 7th of June 2018, that there was a report by management to the trustees?
No, there was not.
All right. Was there any information provided by management to the trustees?
No.
All right. So it had, can I suggest, the change in position then had nothing to do with management coming back and telling the trustee about anything?
No, I don't agree. I believe that we would have reached the position and did reach the position regardless of what ASIC said to us.
But
I'll only say the trustee in the nearly 12 years I've been on the board has never sought to not remediate a customer where we have done the wrong thing. And I will agree this matter has taken far too long to come to fruition. But I do believe that regardless of what ASIC said to us, we would have remediated customers based on the work that the trustee delegates asked to be undertaken by the Breach Review Committee.
I think perhaps we're not disagreeing that the work being undertaken by the Breach Review Committee had nothing to do with this change in position.
Sorry, that
Aren't
was a
you
bit of a double
saying-
negative for me.
Aren't you saying that you think ultimately the work of the Breach Review Committee would have led to this position?
Yes.
But the Breach Review Committee hadn't completed its work by the time you changed position.
They hadn't formally completed their work, but I had been in discussions with the Chief Risk Officer and the CEO of MLC Super as to what the review was finding, and it was basically a merging of matters at the point that ASIC wrote to us in discussions with the board.
All right, well, do the best you can for us. What do you recall that you were told by the Chief Risk Officer about what this review was finding?
Essentially, that the control environment for the trustee was not adequate and that we would need to fully remediate the planned service fees for MKPS members.
You already knew that the control environment was not adequate. We have seen that in the report from the end of 2017. Do you
Yes.
agree?
Yes.
So is the only thing that changed was that somebody within management said, we're going to have to remediate all of the customers?
No.
What else changed?
I think that I think we essentially all of the factors that led to the view that full remediation was appropriate came to came to a conclusion and came to kind of be viewed at one point in time, which led to a view of full remediation being required.
Can I suggest this to you? That what happened was this, that after NULIS had tried everything but the right thing without ASIC's agreement, that it finally fell back on doing the right thing.
No, I don't agree.
Now, if we go over the page to page 2, you see it says NULIS has determined to cease charging PSFs to all remaining MKPS members.
Yes,
And it says the fee will cease on 30 September 2018.
yes.
Can you explain why the fee couldn't cease any earlier than that?
I'm going off memory. Basically, it was to do with the need to provide notice to advisors that we would be ceasing the payment, and we didn't have a clause in the contract which enabled us to that had excuse me, I'm at the end of a long period. It didn't have a clause in the contract of a specific notice period, and so we were required to determine what was a reasonable notice period to provide advisors for ceasing the PSF, and this was the time period. What the trustee considered at the time was that members would be remediated for the full amount and would not be disadvantaged as a result of extending the cut-off period or when we were turning the PSF off.
Attend to that document, Commissioner.
Letter NULIS to Mullally, ASIC 7 June 18, ASIC 0039 0001 1173, Exhibit 5.79.
And then can we bring up ASIC.0036.0003.0730? So this is a letter dated the 26th of June 2018, and if we turn over the page to the second page, you see it's sent by Mr. Steele, the General Manager for NAB Financial Planning and NAB Direct Advice.
Yes.
Now, what it refers to is a meeting that occurred on the 7th of June 2018.
Yes.
Were you at that meeting?
That was the meeting I was referring to earlier where Miss Cook was in attendance.
All right. And was it at that meeting that NAB, via, I assume, Ms. Cook, said that NAB would conduct a full review of advisor service fees for all clients who had paid those fees between 1 January 2009 and 30 June 2018?
If that's what's detailed in the letter, then I expect that to be correct. When I described what I described earlier, which was that NAB was putting forward a proposal and an approach for review of the ASF matter, an agreement with what ASIC had been asking for, that was what was discussed in that meeting.
All right, but would you have seen this letter that we are looking at here?
No.
Attend to that document, Commissioner.
Letter NAB to ASIC 26 June 18, ASIC 0036 0003 0730, Exhibit 5.80.
And then can we bring up ASIC.0039.0001.4084? And this is a letter back from ASIC to you and Ms Cook on the 28th of June 2018.
Yes,
And this was 2 days before you finished as the chair. Would you have looked at this before you finished?
I suspect so.
All right. And so you... I'm sorry, I should just check one other thing related to that. You see there's a reference to, at the meeting on the 7th of June, a draft enforceable undertaking was put forward to resolve the advisor service fees issue.
Yes,
Did you see a copy of the enforceable undertaking or the draft
No.
enforceable undertaking?
it was in respect of the advice business and not in respect of NULIS.
Right. And if we go over the page to page 2, you see at the top of the page it said NAB's proposal only covers NAB financial planning and that NAB has yet to propose a further review methodology for its additional advice licensees.
Yes,
Were you aware of that difference between the position taken with respect to NAB financial planning and the position taken with respect to NAB's other advice licensees?
I believe it was discussed in the meeting on the 7th of June.
All right. Do you know what the reason for the distinction was?
No.
Do you know whether it's been resolved?
No,
And then you see that at the end of that section, it said ASIC's investigations into the advisor service fees issues is continuing.
yes,
And then in relation to the plan service fees, you'll see that it said at the end of that as well, ASIC's investigation into NAB's planned service fees conduct is ongoing, and when completed, ASIC will decide what, if any, enforcement action is required.
yes.
I want to just understand what happens between this date and when the media release goes out on the 26th of July 2018, announcing that NAB will refund the PSFs for MKPS members. Now, you've given a statement about that, but I take it you weren't directly involved in it because you'd finished by then?
No, and I only became aware of the media release as a result of preparing my witness statement.
All right. Well, I'll ask you some questions and see if you can assist us with it, given that you've given the statement in relation to it. I tender that document, Commissioner.
Letter ASIC to Cook and Smith, 28 June 18, ASIC 0039 0001 4084, Exhibit 5.81.
Now, you've exhibited the media announcement to your statement. I think it's tab 1 of your response to rubric 5-77, and the doc ID is NAB.005.817.0001.
Yes,
I'll just bring that up. Can we go over a page? The next page. Now, I just wanted to try to understand some aspects of this. If we go to the second page of that document, you see it says there in the second paragraph, MLC has decided to refund members directly even though the trustee did not retain these fees, as the trustee passed these fees on to financial advisors.
Yes.
And then it says approximately 305,000 members will receive a refund, with the average refund being approximately $220 per member plus interest.
Yes.
And that would suggest that the amount to be refunded is $67.1 million plus interest.
I think that the total is included in my witness statement, yes.
Sorry, Ms Smith, speak up.
I think that the total is included in my witness statement.
Well, I think your witness statement
In-
gives a different number. That's what I'm trying to understand. So if we go to paragraph 24 of your statement, which is WIT.001.0094.0001.
I believe that includes a compensation calculation in the 87.1 million.
Oh, I see. So the total dollar amount now is $87.1 million, which is both the number of members multiplied by the average amount plus compensation. That's your understanding?
No, it's the individual fee
Yes.
paid by a member rolled up with compensation as it relates to that member. And that is the estimate at the point of providing my witness statement of the 67.1 million plus compensation.
Right. I think what we've been trying to understand is, can I show you a document which is NAB.005.894.0132? So this is an internal email. You're obviously not on it. But you see at the bottom, there's the calculation of the number of customers, the total PSFs deducted, and the future PSF deduction up to the 30th of September 2018.
Yes.
And it has different amounts for the PSFs. And I'm just wondering whether you know what the difference is.
I don't, and I haven't seen the email before, but I did endeavour to ensure that the data I was providing was accurate. What I do know is that the media release also includes amounts that would be that would go into the pool. So for anyone under a $20 error who has left the fund, the amounts in respect of those members will go into the pool of assets and for the benefit of all members, in accordance with the trustees' remediation policy. I suspect that the only way I could conclude, but I can't accurately tell, would be it's just the 87.1 million would be the compensation to members, actually receiving money.
Right. Attend to that document, Commissioner.
Email 19 July 18 between Campbell, Baker and others, PSF figures for media release, NAB 005-894-0132, Exhibit 5.82.
Then can we bring up NAB.005.891.0019? Can we just zoom in on the two paragraphs at the top and the comment? And
the comment.
so you see, a draft of the media release had said that NULIS would, in addition to plan service fees, also stop charging advisor contribution fees from 1 October 2018.
Yes.
And then you'll see there's a comment from someone with the initials SC, which is, we're also ceasing advisor contribution fee, but then says, I support not mentioning this as ACF has been around much longer, is effectively a grandfathered commission, much less dollar impact, would need us to explain why there is no refund of ACF.
Yes.
And so I want to ask a few questions about that. The first is, to your knowledge, is the advisor contribution fee also stopping from the 1st of October 2018?
I don't know the date, but yes, it's stopping.
And do you know why it is not being refunded?
No, I think we discussed this yesterday, and I said I was not aware that we had done a review or not done had done a review into the advisor contribution fee and whether there was an issue with it or not.
Well, if the advisor contribution fee and the plan service fee are both for effectively the same thing, which is some service that's to be provided by the advisor.
Yeah, I think we discussed this yesterday when I said I haven't thought about it before, and I would be speculating on the legal construct of the fee for me to answer.
I tender that document.
Draft media release concerning NULIS switches off plan service fee and refunds members, NAB 005891 0019, Exhibit 5.83.
Commissioner, could I just ask, there's two possibilities I can throw up. I want to put some propositions to Ms. Smith. What I'd probably prefer to do is to stand down for 5 minutes so I can have a brief discussion with Ms. Diaz before I do that. But I'm also noticing the time, and I'm wondering whether the alternative is to adjourn for lunch now and come back at 2 o'clock. It may depend on whether Mr. Young thinks he'll be very long in re-examination.
Well, Mr. Young, do you yet have a view of how long you will require in re-examination?
I won't take any time. Subject to what follows. Subject to these propositions.
I suspect longest way round will be the most efficient, Mr. Hodge, if we break and come back at 2. How long do you...
I think I'll be 3 minutes, that's all.
All right, well, I'll come back at 1:05.
Thank you.
Hodge?
Thank you, Commissioner. Ms. Smith, I just want to put some propositions to you and give you an opportunity to respond to them. The first proposition that I want to put to you is this, that the approach of the trustee to retaining grandfathered commissions, at least from 1 July 2016, was not in the best interests of the members and was a failure to prioritise the interests of the members over the interests of members of the NAB group. Do you agree with that?
No.
And I want to put to you that the approach of the trustee to managing and monitoring the transition of ADAs to the MySuper product was inadequate and did not involve sufficient systems for the trustee to be satisfied that the best interests of the members were being prioritised over the interests of the NAB group.
No.
And I want to put to you that the approach of the trustee to the allocation of the investment management fee for the investment management of the MySuper product did not involve sufficient monitoring or action and was not in the best interest of the members or sufficiently prioritising of the interests of the members over the interests of members of the NAB group.
No.
And finally, I want to put to you that the approach of NULIS and the other trustees within the NAB group of standing by while NAB Wealth and the executive management team sought persistently over several years in its interactions with ASIC and with the trustee to seek to retain fees where it had not properly reviewed or concluded that there was services provided in exchange for those fees was a failure to act in the best interests of the members and a failure to prioritise the interests of the members over the interests of the NAB group.
No.
Commissioner, I don't have any further questions.
Yes, Mr Young.
Commissioner, I have no questions.
Yes.
I would ask that Ms Smith be excused.
Mr Hodge, what do you say?
I don't have any objection to that, Commissioner.
Yes. Now step down, you're excused. Ms Smith.
Commissioner, I'm not going to close the NAB case study. I need to consider our position in relation to it. I would like to tender at this point some statements of Ms O'Neill. Can I give you those references?
Yes.
The first is a statement of Peggy O'Neill dated 19 July 2018. The document ID is WIT.0001.0078.0001.
Will be Exhibit 5.84.
The second is a statement dated 23 July 2018. It has the document ID WIT.0001.0077.0001.
Exhibit 5.85.
The third is a statement dated 3 August 2018. It has the document ID WIT.0001.0092.0001.
Exhibit 5.86.
Those are the statements, Commissioner. Is this a convenient time then to adjourn for
Yes.
lunch?
We come back at 2:15.
Thank you, Commissioner.
That is, what do we go on with at 2:15, Mr Hodge?
Mr Silk from Australian
Mr Silk
Super.
from AusSuper. Yes, thank you. 2:15.
All stand. The Royal Commission